Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Tennessee versus Blaise Taylor. We are in day 8. We're going to have closing arguments today, a few jury instructions, and then we will be in verdict watch. So, big day ahead, big day ahead. So get comfortable, settle in, and let's get started.
You're safe here, everything is blacked out. Cause tonight gone dancing till we black out. Gonna wake up with your face down. Feel your heartbeat speeding with the bass out. Everything is blacked out. They were holding me down, holding me back, holding me tight and close. Breaking me down, riding my back, down on my knees and toes. But I got up and I became stronger than before. Heavy metal on my fist, had to break the door. With my head up, know exactly what I want. Time to turn it up, get everyone around us. Cause tonight gone dancing till we black out. Wake up with your face down. I can hear my feelings with the bass up. You're safe here, everything is blacked out. Cause tonight gone dancing till we black out. Gonna wake up with your face down. Feel your heartbeat speeding with the bass out.
All right, welcome in everybody, welcome in. We have a live feed, so let me get us in there. And I will check in with everybody. How are we doing today? Day 8. Closing arguments and verdict watch coming up. Horse welfare. Good morning, Camilla. Good to see you. Hellrider, it is going to be spicy today. That is for sure. Hey, Melka, how are you? Melka. Rock and roll, how are you? Snap, good morning. Good vibes only. Kathy Davis, good to see you. Crazy Mary Fitz, William, great to see you both. Debbie, how are you doing? Hey, Teresa, how are you? Deshaun, good to see you. Fanny, welcome in. Welcome in, everybody. It's so good to see everybody today. Lots of old faces that we haven't seen, or people that we haven't seen in a while. Thank you so much for joining us, you guys. Really appreciate it. Nana, how are you? Good to see you. Kimbers, you're going to be at work listening with your headphones. For Baby's mom, what's everybody's thought on Blaise? We've taken a couple polls. I'll go ahead and I'll check in on those in a second. Hey, Mike, happy hump day to you. Good to see you. Tammy and KS, happy hump day to you. Valerie, good to see you. Welcome in. Crazy Mary Fitz, Blaise's fancy boy has always gotten away with his shortcomings, so to speak. Coattailing on mama's money. Interesting. I do not know anything about his family other than his dad is at Texas A&M. Hey, Iowa Backyard, great to see you. Aaron reminded me that Blaise's mother is a doctor. PhD. Not a medical doctor. She has a PhD. Aussie Gardner, hello. How are you? Camilla, Wonder Mod Squad is activated. Scent Bunny, how are you? Elaine, good morning to you. Great to see you. All right, let me get closer to... Oh, happy Canada Day. Aaron reminded me. July 1st. Happy Canada Day for those that celebrate. Hey, Crazier Cat. Heidi, good to see you. How are you doing? The Pretty Chick, hello, hello. Welcome in. Mama of a Medic, there you go. Happy Canada Day, friends. Kelsey Park, how are you? Good to see you. Great Gams, coffee time. Kathy Davis, and here we go. Scent Bunny's looking forward to hearing the closing arguments. Ambi, good to see you. Happy Canada Day to your fellow Canadian chat peeps. Hey, Barry, how are you? Great to see you. Dina, welcome in. Hey, Pammy, good to see you. Iowa Backyard Cam. Hey, Jane, welcome in. Amby, good to see you. Fanny, hello, hello. Miss Bree, great to see you. Bama Green Eyes, good morning to you. Jenny G, yes, welcome in, welcome in. All right, let's get comfortable. We've got a full day ahead of us, We got closing arguments, then we have jury instructions, and then we have deliberation. Then we are officially in verdict watch. Snowcatish, good to see you. Pammy, rock and roll squeegee. I like that, rock and roll squeegee. Hey, BB Card King, how are you? Great to see you. All right. Oh, Sugars, how are you? Thank you for joining us. I think I got everybody. Oh, Linda, there you are. Good morning to you. Teresa saying hello. All right. So yesterday we were kind of doing an experiment of, pros and cons. So I want to continue that. We can continue that when we get into verdict watch. But think about all the pros and all the cons. Like if you were a juror, what would you? Let's weigh out all the pros, for Blaise, and then all the cons against him. So consider that for when we get into actual verdict watch. I got to find where I put that. Where did I put that? Did I put it in here? Oh, facts? Is it facts? There it is, facts. All right. Yeah, consider all the... Oh, nope. Stop. All right, I have it here somewhere. There it is, facts. All right, so we're going to go through, once we get into verdict watch, we can go through all the facts, pro and con. And we're going to watch, did you find Super Bowl? Oh, there she is. Hi, Super Bowl. We had an appliance delivered today, and all the cats had to be ushered into another room, and poor Super Bowl is still she's still a little tweaked out. Everybody else is pretty much recovered, but Super Bowl has not. Come here. Nope. Well, she'll find her way. Super Bowl's still a little sensitive. Hey, Sharon, welcome in. Good to see you. Hellrider, I feel like since he was willing to do whatever it took to delete the first child, I feel, in your opinion, he did it. And that's fine. I'm just trying to let's just really look at the facts. I want to do an experiment today. We've never really done this before. I really want to look at. I mean, your guts are one thing. Your feelings are totally valid. I just want to let's really look at the facts, and let's make a kind of like a balance sheet. Pros and cons. I do that a lot. My dad taught me that. Whenever something big, I was going to do something big, like a life-changing event. He's always like, well, what are the pros and what are the cons? And you put the pros down, you put the cons down, and if the pros outweigh the cons, you go with that. If the cons outweigh the pro, you got to consider that. Seashell, how are you? Great to see you. Thank you for joining us. Eva, you were listening to Led Zeppelin this morning. Which song, which album? Snowcatish, great to see you. So Scent Bunny, your main concern is almost all the cons relying on friends' words. That makes me uncomfortable. No. Well, I want to look at the facts. Let's look at the facts. We can add that in. Yes, we can add in testimony, but I want to really look at just like was there blood alcohol level? No. Was there THC found? No. What was in her blood? What was in her urine? When were the phone calls to 911? When were that's what I really want to focus on. Like, let's really look at the cold, hard facts. We can add in testimony, but we won't give that as much weight. So let's really look at the facts. And, how long does it take for the substance to hit your system and get into your system? Orally, Horse Welfare found a really great thing. I'm going to try and find that. Yesterday, Horse Welfare, thank you so much for that, posted the different times that it takes for the substance to affect you. Snorting is like within a couple minutes, 5 minutes, whatever. Injecting it into your bloodstream, again, 5 minutes. Swallowing it, I think it was like 30 minutes. Was that right, horse welfare? I think it was 20 to 30 minutes. So those are the facts I want to look at. Because if that's the case, there's absolutely no way that Nijaya could have done this, because she left at 8 o'clock and everything was cool at 9:10. That's up until 9:10. That's an hour and 10 minutes. So there's really no way that Nijaya could have put this liquid into a drink just randomly hoping that the right person drank it, unless she tried to poison both of them. I mean, who knows? So anyway, those are the facts I want to look at. Mr. Mann, how are you? I-9, timeline is very important, absolutely. JMS, good to see you. 80 in humidity, high humidity. Heidi, right, and all the facts point to the defendant. Well, that's the experiment I want to do today. We've never done this before, so I want to do that today. I want to truly look at all the facts, and let's really look at it's a scale, right? Let's look at the scale, and if the scale goes towards, more pro than con, let's really look at that. Let's do this experiment. Susan, how are you? Great to see you. Yes, that is true. That is a fact. He called his dad first, and then he called 911. Oh, okay. Thank you. Here's the comparison. Awesome. Thank you. All right, horse welfare. I'm going to download this so we can look at this. All right, here. We still have a few minutes. We have a few minutes here. Horse welfare just sent this over to me, or posted it. So this is a fact that we have to look at. Here's the so snorting, onset is within a few minutes. Smoking, onset is within seconds. Injecting, effects can start within seconds to under a minute. Oral or gum use may appear more slowly, often within 10 to 30 minutes. So that's really good to know. So that, I think, with that in mind, we can throw out Nijaya doing anything, putting anything in her drink. I think with that, we can pretty much negate Nijaya and or Chianti. So that puts that to bed. So that's a fact right there. That's a fact, and we can revisit that. Snowcatish, I wonder if he was trying to end the pregnancy but went too far with the amount of. That's a theory. That's absolutely a theory. Fanny, also does the stomach contents affect the cola and break it down more slowly? Probably, right? Because I would think if you have food in your stomach, it's like anything, right? If you have food in your stomach and you drink alcohol, it's going to interact with the food, right? If you have an empty stomach, it's going to, food is going to interact with it. No question about it, for sure. Yes, we will absolutely get a deliberation time, for sure, for sure. Hey, Muggsy, good to see you. Can we do a poll that says, would let a good friend stop by when you were on a date? I'm not sure. Maybe she wanted. Clearly she wanted them to come over. Green-eyed cat, how are you? Hey, honey badger, great to see you. Pammy, good point. But I see it as completely normal. That's her best friend stopped by, especially with concerns that Blaise wasn't fully on board with baby yet. And then the chicken Alfredo, of course. Of course. All right, let's see. Deshaun, I don't understand why I'm always here when you're not live, but when you go live, I'm never here. It always happens. Let's see. I don't understand why I'm always here when you're not live, but when you go live, you're never here. Well, you're here right now, aren't you? You're here right now, I hope. I think you're here right now. Yeah, put your notifications on, as Kaylee says. Just put you can hit the, there's a bell icon. Yeah, just make sure that you have notifications on. Crazier cat, I agree. I think he just wanted to end the pregnancy and messed up. Hey, Amy, how are you? I see people saying hello to you. Kelsey, how is it a fact when we don't know when Jade actually drank the drink? Well, okay, let's explore that. If Najaya gave her this concoction at between 7:30 and 8, that's when they were there. So that means between 8 and 9:10, she didn't drink anything. So for an hour and 10 minutes, she didn't drink anything. I mean, think about that. Just think about that. I'll just leave it at that and let you come to your own conclusion. But if she puts something in Jade's drink, that means an hour and 10 minutes, Jade didn't take a drink from that. I'll just leave it at that. Hey, Sherry, how are you? Good to see you. Kathleen, good morning to you. Let's see, Iowa. If the friends were devious regarding going into the apartment, they never would have, 1, asked permission, and 2, could have never said a word, but the comforter might not exist. Yeah, we can pretty much probably throw that whole thing out. Even if you just remove the comforter from the equation, just remove it. Just remove the comforter from the equation, remove everything from the equation. The fact still remains, Blaise was with her for an hour and 10 minutes alone. So just he was the last one to see her. Generally, the person who is with you last before you pass away, I don't know what percentage it is, but generally they're the one that did it. At least all the trials we've watched. Think of all the trials that we've watched. Every trial that you've watched, the person that was with that person last generally is the one that's found guilty. I mean, just think about that. I'm not saying it's right. I'm not saying it's wrong. I'm just saying that's the reality. Hey, Stella, how are you? Terry Trial Watcher, great to see you. Pammy, I'm sure she would have drank with supper as well. Let's see. BB Card King, what if she put the concoction in the drink just prior to leaving? Yeah, so from 8 to 9:10, that's an hour and 10 minutes. That's what I'm saying. It's an hour and 10 minutes. I do not, I mean, come on. Let's really think about that. Would you not drink from your drink for an hour and 10 minutes? That makes no sense. I'm sorry, I'm not going to agree with that. That to me is really a stretch, and I just don't, I'm not, that is not reasonable doubt for me at all. To me, that's I'm sorry, that's just not, I can't agree with that. I can't agree that somebody who has a drink is going to let it sit for an hour and 10 minutes. That just doesn't make sense. Hey, Debbie, thank you so much for your $4. And again, you can have your opinion. I'm not going to say don't have your opinion. That's your opinion. I'm just saying that's not my opinion. I don't agree with that. You can absolutely disagree with me. I'm not saying you have to. I'm just saying that I don't think that's just not, I don't get it. Anyway, all right, let's see. All right. Let's see. Horse Welfare is sending some more about low-dose oral cola in humans. Acquisition of discrimination and time course of effects. So 7 abuser volunteers were trained to discriminate 50 milligram oral versus placebo across 50 two-hour sessions. Discriminative, subjective, and autonomic effects were assessed with a procedure developed for precise characterizations of their acute time course. Subjective effects of oral cola began 10 to 15 minutes post-drug, peaked at 40 to 50 minutes. So here it began 10 to 15 minutes and took up to 100 minutes to return to nearly base 10. So it's 10 to 15 minutes after ingesting it orally. 6 out of the 7 participants acquired the discrimination. In most participants, the oral cola produced increases in ratings of liking, alertness, and good effects. Overall, the results support sensitivity of the behavior testing procedure. 50 milligrams can serve as a discriminative stimulus in adult humans. Now, she had 78 nanograms. She had 7,878 nanograms. So this is 50 milligrams. So thank you for sending that, horse welfare. So it's all right, let's see. Hey, Brat, how are you? Great to see you today. Jane, you just got a membership? Oh, Debbie, thank you so much for the Trial TV Live gifted memberships. Appreciate that. And Jane got one? Did I miss all that? Let's see, I missed that. Brat, Blaise could dose a drink while she was in the bathroom. All the food pickup folks would have had to do it in front of a room of witnesses. That's true, Brat. That is true. There you are. Okay, yes. Debbie, Jane got one. Awesome. Mr. Mann got one. Fantastic. Thank you so much, Debbie. 5 Trial TV Live gifted memberships, and you and Jane got one, and Mr. Mann got a membership. But yeah, Brat, you're right. Blaise had many opportunities to do this. Najaya and Keontae. And again, why would they do it? Why would they want to take out their friend and or Blaise? I know a lot of you are saying, oh, they meant it for Blaise. I mean, that's a stretch, guys. I mean, again, I'm not telling you don't have your opinion. You're totally allowed to have your opinion. I'm not saying that. I'm just saying that for me, this is your best friend. You love this child. You want to be a father. She said she wanted to be a father to this child. Why would you risk killing your best friend and this baby girl because you wanted to kill Blaise? But then, okay, if you were jealous of Blaise coming back into your life and you wanted to kill her, then how do you know Blaise wasn't going to drink that? Again, that to me is just a stretch. I'm not telling you cannot have your opinion. By all means, have your opinion. I do not. The more I thought about that, I've been thinking a lot about that in this trial, and I personally can't get there. I just cannot get there with Najaya having anything to do with this. I just can't. But again, you guys can have your opinion. I'm not at all saying you cannot. That's the beautiful thing about us, is you can absolutely have your opinion. I'm not here to change your mind, and you're not here to change my mind. So that's where we stand. Auntie Ree, how are you? Great to see you today. Brenda, good to see you. Thank you for joining us. Oh, Melanie. You got one too, right? You got a gifted membership? I think I saw that, right? Good job, Debbie. I love it when people are actually in chat. There, yes. Melanie got a gifted membership. Jane and Mr. Mann all got memberships. I really love when that happens. All right. Najaya loved her best friend by all accounts. Seashell can't get there either. Yeah, and it's all right. I mean, we don't have to agree with each other. I'm not here to say you have to agree with me, and I'm not here to say I'm going to agree with you. It's just that's the way it is. We are not on the jury, and we are allowed to opine left and right. But it is what it is. Anna, hey, good morning to you. Let's see, there's 1 million nanograms in a milligram, so 78 nanograms. So that's 78 million? Is that 78 million then? Is that the math? I know they said that she had more in her system than anybody had ever seen. And the only time other was 10,000. Sounds like they're coming in. That person was arrested and they ingested it. It's kind of like those mules, right? That if they have a packet and then it explodes in their system. That'd be a terrible, terrible way. We did, JMS. Yeah, we had to herd our cats. We got a new appliance and we had to herd them into the other room. But they're all okay except Superball. She's still a little traumatized. But everybody else is feeling pretty good. Virginia, how are you? Good to see you. All right, let's see. Sounds like they're about ready to come on. All right, so we should have closing arguments first. Oh, I got to get my clock ready. Where's my clock? There's my clock. All right, we got to get our clock ready. So this is going to be probably state first, right? Usually state is first and then defense and then, so this is going to be state closing. State closings. All right, we'll go with state closings. I can reset that. All right, so we'll have state closing arguments. Usually they're first, and then we have defense and then state. I know she said they were given an hour time limit. So we know that they were given an hour time limit. And I think the state said they were going to do like half hour or 45 minutes first off. And then the defense said they were going to be 45 minutes. And then the state was, maybe it was half hour. I think that's what they said. So. CJ says, hello. Hey, Joanne, and happy Canada Day to all that celebrate. So, Susan, to convert nanograms to milligrams, simply divide the number of nanograms by 1,000,000. So, if 78 nanograms per milliliter, someone do the math for me. 78 nanograms per milliliter. Jill, good morning to you. Great to see you. Oh, we have some more gifted memberships. Debbie, again with the gifted memberships. Thank you so much. Anna got one. Awesome. Thank you so much, Debbie. Really appreciate that. Scent Bunny, you got a new kitty currently on your lap watching. Oh, you can't tag me? All right, CJ here. Sometimes when I don't tag people or I'm not in chat here, I'll tag you. Tag you're it. All right, there. All right, CJ says that should work for you now. Derek says, to spike someone's drink, in your opinion, is premeditated. 100% agree with that. And you would expect a particular outcome. 100% agree with that. The defense really was very poor strategy. I'm not sure where I stand with their strategy just quite yet. I'm not quite sure. But I do agree with you with the spiking is definitely premeditated, 100%. And you would absolutely expect a particular outcome, for sure. 100% agree with that, Derek. Absolutely. Debbie, thank you. Dragonfly is so generous, Debbie. Yeah, no problem, CJ. That it happens. Like if I'm not in chat, I'm not tagging. It happens. Bad Tazzy, thank you for the One Trial TV Live gifted membership, and Joanne got one. Awesome. This is fantastic. I love when people are in chat that get memberships. That is so cool. I really. All right, here we go.
All right, anything before the jury's brought down?
There was one thing, Your Honor, in regards to the exhibit that we discussed on yesterday.
One thing about the charge?
No, sir.
Oh, okay.
It was about the exhibit from yesterday that we went up there. When I looked at the exhibit list.
The one that was introduced?
Yes.
60 from the deposition?
No, sir. It was in regards to the text that we discussed at the end of the day yesterday.
That the state said we would have asked a whole lot of questions of your phone person. What about it?
you had it, I didn't understand yesterday. I thought that you were entering it, or were you just accepting for offer of proof?
Offer of proof,
Okay,
marked
that's all I
with
need.
those.
Okay, thank you.
All right, let the jury step down. All right, good morning to you, ladies and gentlemen. Let the record reflect all of the jurors are here and present. Any closing argument on behalf of the state?
Yes, Your Honor. You did this so something would happen to the baby. Jade Benning, she did not call 911. She did better than calling 911. Jade Benning called the one person who knew where she was, knew who she was with, would know that she was calling scared and for help. Now, Jade Jackson said as soon as she heard her best friend's voice, she knew she was scared and she needed help. Jade Benning did better. She made sure that Blaise Taylor was not the only person to hear her last words. She made sure that you heard her last words. She called Jade Jackson and said, "Blaise, you're scaring me." Nigella heard him say, "You're scaring me. I know you put something in my drink. I knew my drink tasted funny. Let me see what's in your pocket. Let me see. I know you put something in my drink because I can't even walk straight. I can't feel my legs. You put something in my drink. You did this so something would happen to the baby." I think I'm about to pass out. Jade Benning ensured that you heard her words that night where she was so excited to be having a date night with Blaise Taylor. Her best friend came over. They were the only two people there. Dr. Aaron Carney gave a very specific medical explanation that Jade Benning would have gone pulseless within 30 minutes of ingesting that concentration of cocaine dissolved in a liquid. There were only two people there. The proof and testimony that you have heard over the last week from Jade Benning's family and friends, the pictures, the things in her phone, she was so excited to be having this baby. She was so happy and planning for her baby girl to be born. I submit to you that it does not matter how many questions were asked about fentanyl or cocoethylene. It does nothing to change the evidence and proof that you have that Jade Benning did not want to harm herself or her baby. She wanted the opposite of that. The proof and evidence from Nijaya Jackson and Dr. Aaron Carney is proof beyond a reasonable doubt for counts 2 and 4 that Blaise Taylor intentionally put that cocaine in Jade's drink to kill the baby. And Jade Benning was killed when he did that. You also have the proof and testimony of Apple Denny. She described to you an event that happened several years before in 2017, but when she heard about what happened to Jade Benning and that Jade Benning was dating Blaise Taylor, she knew immediately. She reached out and contacted people because she knew she had information that it was him. She testified, told you about very personal things that happened to her, but she described what happened over a period of 2 days. Her testimony was she had to talk him out of putting something in another girl's drink who was refusing to have an abortion so that he could cause the abortion without her knowing. Blaise Taylor chose cocaine. He chose what to put in that drink. He chose a substance that you have heard from multiple witnesses is known to cause spontaneous abortions. Dr. Carney described that it is known to cause a placental abruption. And she also testified that that did not happen to Jade Benning. It did not happen because he killed her. I submit to you that there is proof and evidence that you have heard over the last week that proves beyond a reasonable doubt all 4 counts of the indictment, including the first-degree premeditated murder of Jade Benning. Blaise Taylor chose this. You saw when he got back in touch with Jade Benning. They had a conversation that explained what happened back in November of 2022. This is kind of a somewhat joking conversation, but Jade Benning said, "You gave me a crazy ultimatum." Apple Denny testified to that same ultimatum. You have Jade Benning's decision to the ultimatum he gave her. She chose her baby. She did not choose Blaise Taylor. She did not make the choice that Xavier Winford made back in 2017. She chose her baby. Apple Denny gave that same description of the ultimatum, and you have that there was no contact from November 6th to December 31st of 2022. Jade Benning was planning for her baby. Her life was going on. But you also heard from her family and friends that during that time, she was not posting anything about her pregnancy to social media. She had not posted anything to social media about her pregnancy on the day she was murdered. It was not publicized. When Blaise Taylor comes back into Jade Benning's life, this is the evidence that you heard was not he came back welcoming this opportunity with open arms. He tells her very specifically in these messages that your life is changing. This is going to be a thing for you. At no point does he say we, me, ours. This is going to change Jade's life. And he is not portraying it as a positive. Telling her she shouldn't be so optimistic. And Jade Benning, just as her friends described her, always optimistic, still said, okay, but I'm going to be able to make this work. Blaise Taylor did not go to any of her pregnancy appointments with her OBGYN. Not one. She asked him very specifically, sending him the calendar event. And specifically saying, I really hope you can make it. I would love for you to be there when I found out the gender of our baby. If it's going to be a boy or a girl, I want you to be there. And he did not go. And even when they saw the shadow and she had to have follow-up testing and then another follow-up appointment, he didn't go to any of those. Jade's stepmom, Andrea, she went with her the day that she found out she was having a baby girl. And Jade was still so happy even though he wasn't there. You also have proof about why Jade wasn't posting, about why everybody didn't know that it was his baby. He was the father. You have a message where Jade is saying, I talked to my mom and let it be known not to bring up you or my situation to anyone. She is defending him and his request that no one know that he's the father of the baby. He responds, but it's all good as long as we are on the same page moving forward. Everything is cool, but I appreciate it. The day before Jade Benning is murdered, the day before, the night before she is murdered, Jade Benning wanted to see Blaise Taylor that night, and he didn't. He is texting Xavier Winford, who he's had some kind of relationship with since 2017. He's texting her and saying, you should never doubt anything when it comes to us. And she says, I'm doing my best. And he says, I know, I'm trying to reassure you. She thanks him. He says, I'll do anything to help you. That's what I'm here for. She says, I trust that's true. And he says, good. Do you trust in us? She responds, yes. Good. Then you have nothing to worry about. Everything is going to work out. She says he's glad. He says, me too. I love you. And I need you to love me back. And be in love with me. She responds that she loves him, and he says, good, I just want us to be happy together. We are going to be just fine. We just need to stick together. And she promises him that they are going to stick together. The next night, he goes over to Jade Benning's house for date night. The date night that she's planned. She has canvases so that they can paint pictures for the baby's room. He goes over there to the date night with cocaine to put in her drink. He goes to the date night. The testimony that you heard from Nijaya Jackson and from Keontae Jones about them stopping by, that whole time that he's shuffling those Uno cards, he has the cocaine to put in her drink. He gets there at 7 p.m. They show up at 7:30 for 30 minutes talking about spades and having random conversation. And he has it. He does not call 911 until 9:29:27. I'm sorry. The call that Jade makes is at 9:29:27. EMTs don't get to her until 9:50. Dr. Carney's testimony is that Jade was given the cocaine that she ingested orally 30 minutes before. You have this photograph from 8:29 that shows the progress. She has not been given anything at that point. The next image that you have is at 9:10 p.m. It is somewhere between this point and the next image of their progress that she has to have been given the cocaine in her drink. At 9:24 p.m. is the next time that there is an event. It is after that 30-minute mark. She has finished the painting. You heard Dr. Carney's testimony about how the symptoms would start off not severe, but it would escalate really quickly. And 9:24 to 9:28, you have 4 minutes. 4 minutes after he has put this in her drink. He is there and knows what he has done. And for 4 minutes, takes picture after picture with Jade Benning. Blaise Taylor went there with a plan. There was a plan. He has already poisoned her. And he is taking pictures with her. Blaise Taylor did not plan for Jade Benning calling Nijaya Jackson. That hadn't happened yet. The last event that happens is that deleted picture, and within 45 seconds, Jade is calling her best friend. What did you do? She is calling her best friend scared, and she is not talking to Nijaya. She is talking to Blaise Taylor. 6 minutes and 9 seconds. He is there Jade is telling him, I can't feel my legs. I can't walk straight. He is there and he is not saying anything to her. Like, Jade, what is wrong? What's going on? Let me help you. Come on, sit down. What is happening? You seemed fine just a second ago. What can I get you? Do you want me to call someone? You didn't hear testimony of any of that from Nigella Jackson. You also heard Blaise Taylor tell Detective Smith that third interview. He was describing what happened that night, and he said that Jade was trying to lay down. He didn't tell him, so then I helped her. He says that Jade was talking to him. Talking to him. And then he says she wasn't saying stuff right. Maybe she was kind of talking to Nigella. Now, at this point, when he tells this to Detective Smith, Nigella Jackson has already told everybody exactly what she heard her best friend said. She's told the people at the hospital, the first officer, the second officer, the detective, family and friends. She's told Blaise Taylor to his face, like, you didn't tell them what she said. He stood there for 6 minutes and 9 seconds knowing that he put cocaine in her drink and she drank it. Well, she said these things to him of, I know you did this. Stood there for 6 minutes and 9 seconds and did nothing to help her. At some point, Blaise Taylor figured out that Jade called Nigella. He tells Detective Smith that he was there when she called her and that he spoke to Nigella on the phone. And Jade told Nigella she wanted her to come over. Nigella Jackson's testimony was unimpeached about what she heard her best friend said and about what happened that night. Blaise Taylor did call 911. He did. But he already knew that Nigella had been on that phone call. Because this is before Nigella has gotten back to the apartment. She hasn't told anyone she heard what he said. She hasn't called him. She doesn't call him until 9:47:11 when she calls back to Jade's phone. That's when she talks to him. But 5 minutes before that, after he's called 911,
no. If you look up the phone, I think one of her friends is on the way. Okay. You right there? No. If you look up the phone, I think one of her friends is on the way. Okay.
Blaise Taylor is telling the 911 operator that one of Jade's friends is on the way. He hasn't spoken to Nigella Jackson yet, but he already knows she's on the way. I submit to you that call to 911 by Blaise Taylor is because Jade messed up the plan. He knew Nigella was coming. That's why he called. And even then, after 6 minutes and 9 seconds of Jade Benning's last words on earth, he doesn't even call her immediately. He doesn't call 911 immediately to get her help. He waits 2 minutes and 37 seconds And then he calls his dad, which that's a 30-second phone call. There was no testimony as to whether or not that call even got answered. It's 3 minutes and 28 seconds after that call with Nigella ends before he calls 911. There was no cup with any cocaine that was collected in that apartment. There are 3.5 minutes before he calls 911. You do have his statements with Detective Smith. Blaise Taylor tells him, oh, there's no alcohol whatsoever. No. And we both drank the same stuff. And then he's asked if he cleaned up, and no cleanup. He says that Jade cleaned up some. There was some cleanup by her, but he was not cleaning anything in the apartment. And when asked if they went back and got the glasses, if the lab would test positive for anything, and he said no, it won't. Now, there's at least 2.5 minutes before the 911 call, and that's just the call to his father. There's this time of what's happening. This cup ends up over by the sink. Detective Reese testified that it appeared it had been washed out. The camera, that is after Nigella Jackson moved the camera back to where it normally would have been. This is from 3 days before. This is what the camera would have captured. If someone went over to the kitchen island and did anything to any of the cups, it would have been on that camera. But that camera was not where it normally was. When her friends, thank goodness, went to her apartment to secure it and make sure that the evidence was collected, that's where they found the camera. In her bedroom with the blinds up, in a place that would not capture anything that happened to Jade Benning on her bed and anything that happened in the kitchen. You notice the selfies that they took for 4 minutes while the cocaine was clamping down on her blood vessels before it could make her heart stop. They were all off to the right, not in that camera angle. The 911 call that happened 3.5 minutes after the call to Nigella ends, listen to the call and where he is.
February 25, 2023, 21:38 and 58 seconds.
911, what is the location of your emergency? I'm not sure if I'm down. I got my friend's house and I think she's having an allergic reaction. So, what's the address of the house? Is there cellular reminder? I don't know. It's an apartment complex. Is there a nail with her? With the address, I'm looking around. I don't know. It's just give me a second. I'm looking around. I don't know what's going on. I think she just backed out. Give me 1 second. Hey, are you on Donald tonight or are you on Lebanon here? Lebanon? Yeah, Lebanon. It's apartment 107. What is it? Is it 5040 Lebanon Way? don't know, it's not Burger King, I do know that. I'm going to the apartment building to get at the condo / apartment. Yeah, okay, is there a Velcro of the corner there, sir? Is there a what? The Velcro of the corner? I'm not sure, I just passed it. I'm going to, the Ontario, 1522-1550 Lebanon Pike, the Ontario. 1522? Yes. The Ontario, 1522-1550 Lebanon Pike. So the Ontario 1522, she's in apartment 107, and she's having an overdose, is that correct? I don't know, I think she's having a allergic reaction. We were eating cookies and pain, and she said she wasn't feeling it, and we went back to the room to check on her.
I'm running back to the room to check on her. He's outside. It might not be the pink cup by the sink. He's had all of this time. He's running around outside. He's not there with Jade. He told the first officer, the second officer, Detective Smith, everybody. She threw up, called my dad. He told me to hang up, called 911. He is running around outside, not even with her.
No, and what's the case we disconnected while you're up there? What's the callback number in case we disconnected? This number right here. Is it 8 number 573 573? Yeah. Okay, now this is 23, 24. Okay, is she awake right now? Yeah. Okay. And you think she's having an allergic reaction to food? I don't know. I couldn't even pasta. I don't know what she's done. If she's done anything today or anything, but everything was fine. And then I don't know what's happened. So we got 6 amount of numbers she's checking. So you think possibly a reaction to not knowing food? Is that correct? I think so. I don't know. I don't think she's allergic to anything. I don't know. I don't think she is or not. It could be an allergic reaction. So are you next door? Next door? Yes, sir? Yeah. Okay. Does she hear me breathing normally? Yeah. Okay. Does she have any difficulty swallowing? I don't know. I'm not a doctor.
It sounds like she's snoring. Dr. Carney explained that that's agonal breathing, that she is very close to full cardiac arrest. Mr. Taylor describes her as being breathing and conscious the entire 911 call. I submit to you it's unclear if he is giving any information as it happens or if he's just describing what's already happened. He calls 911 knowing that Nijea Jackson is on her way and she is going to find Jade Benning pulseless. He calls knowing what he gave her. When they found her, she is face down on her bed, her mouth on the comforter with pink vomit that tests positive for cocaine. I submit to you, it doesn't matter what was in the drink. It doesn't matter if there was something else mixed in with it. That doesn't matter. The proof and evidence in this case is that Blaise Taylor put whatever it was in Jade Benning's drink. He did it and then stayed for 30 minutes. He did it thinking he would be the only one that would hear her words. He did it thinking you would never hear her words. Jade Benning said, "You put something in my drink. You did this so something would happen to the baby." Blaise Taylor is guilty of the first-degree murder of Jade Benning. He is guilty for the first-degree murder of her unborn baby girl. The proof and evidence in this case proves that beyond a reasonable doubt. He is guilty of both counts of felony murder because he chose to give her cocaine. He chose to put it in her drink. And he chose to kill both her and her unborn baby girl. And we will ask that you return a verdict of guilty on all 4 counts of the indictment.
Closing argument on behalf of Mr. Taylor.
Yes. Good morning. Standing here at the end of the trial and trying to put everything together is always, for me, very difficult because the burden is always very heavy. And your jobs are never, it's just never easy. Never easy. But we're here. And one of the things that I want to talk to you about is the words that you guys gave us. Not just me, but the state as well. Not just Mr. Taylor, but Jade's family as well. No matter what happens as a result of this, it is still a tragedy. It is still a very awful incident that occurred. And there is only one question that we have to answer. Is whether or not Blaise Taylor, in your minds and in your opinions, is guilty beyond a reasonable doubt. There is only one question or one thing that we will ask of you, that I will ask of you, that Blaise will ask of you, that his family will ask of you. And that is to keep your word. Keep the word that each one of you gave us. And that is that you could follow the law. You cannot, we cannot build a justice system based on emotion, based on sympathy, based on just the mere fact that a tragedy occurred. Every time a loved one leaves this earth, it is sad and it is a tragedy. But that in and of itself cannot drive our justice system. What we cannot do is say, because someone lost their life, that we don't have to follow the law. That we don't have to hold the state to its burden. Because otherwise this system collapses. We could talk about the pain that a mother feels when she loses a child. We can talk about a beautiful young lady and her daughter who is no longer with us. And if you're not human, you won't hurt. But if you are human, you will hurt. But that should not play into your decision making. In order for this thing that we call the Constitution to work, you have to set that aside. And that's the word that you gave us. That's the oath you swore to take. There is a burden here. And I bring it up because that's why we're here. I'm not bringing this up as a facade. I'm not doing that. I'm just reminding you what the law is. I'm just reminding you what governs this trial. Every defendant has a Sixth Amendment right to a fair and impartial trial. Every citizen charged with a crime should get a fair and impartial jury trial. And at the end of the day, when those jurors make a decision as to whether or not he is innocent and or guilty, they must use that burden of proof. And they must hold the state to it. What you can't do is say, well, then what happened to her? If he didn't do it, then what happened to her? Well, I don't know. Well, I don't either. Well, then he must be guilty. Because he didn't prove to us that it wasn't him. But remember, we don't have to do that. That's not the burden. They must prove to you what happened to Miss Benning. They must prove to you beyond a reasonable doubt what happened that night. Not us. Not the defense. So then you ask yourself, well, what happened? If he didn't do it, what happened? You're going to say that 1,000,000 times because that's just a natural reaction to what we're dealing with. But remember, as you are going along that journey, deliberating back there, going through the evidence, remember, they must prove it to you. You cannot ever place that burden on Blaise. You cannot. The minute you do that, that Sixth Amendment right to a fair trial collapses. And once that collapses, the system collapses. And once the system collapses, you have people wrongfully convicted and sitting in jail for a very long time, trying to prove their innocence. And that's not the way it was designed to work. That is not the way our forefathers meant for it to work. So with that being said, let's talk about it. Remember, as we came in here on June 22nd, 2026, we dealt with an official finding of undetermined. The manner of death in this case. By the state's own medical examiner. She had the option to choose homicide. She knew the facts. You heard from Dr. Carney way before you did. And she couldn't figure out what the manner of death was. She landed on undetermined, and she's still on undetermined. Now you're tasked with whether or not you can take it over the hump and move it to murder beyond a reasonable doubt. I want to talk to you guys first about the facts of this case and what you've learned since you've been here. What I don't want you to do as we take this journey is come into this environment and say to yourselves, I want to live in La La Land. I want everything to be perfect. Life isn't perfect. And the older you get, the more you learn that. The older you get, the harder it gets. Trust me when I tell you that. And those of us over the age of 50 can tell you about things that we experience in life that are good, that are ugly, things that we've learned along the way. How we treated people in the past, how we interacted with people in the past, how we respond to people in the past, and how we respond to people now. You learn along the way. But what life isn't is a perfect cookie cutter La La Land. That's not life. So let's talk about Blaise and Jade. They met on Hinge. They dated for a little while in terms of, I shouldn't say date, they interacted for a little while, but never really met up. And remember, these are young people. They had casual relationships, not just with each other, but with other people too. And it wasn't just Blaise that dated other people, they both dated other people. They were adults, they were consenting, nobody did anything wrong because everybody agreed that you can date someone else and you could date someone else. We may not want to live our lives that way, but that's the way they chose to live their life. So when you hear the facts about Blaise texting someone else, that was nothing against Jade because she was okay with it. So don't let the state make you think that because he was dating someone else and he texted that other person, that was something nefarious or wrong. It wasn't. He didn't have to hide that. She knew that. Najee told you that. She said it to the police officers. She said they weren't dating like that. They weren't exclusive. So no matter how many times the state tells you that Blaise was texting another woman, there's nothing nefarious about that. And that has nothing to do with whether or not he committed murder. So don't go down that road trap. Stay focused on what you're here to do. And I want to be clear when I tell you that when we're talking about facts, if you remember, in voir dire, I had a slide up, and it had facts and blame. And I asked each one of you, would you be okay if sometimes facts were ugly, but I needed to share that with you so that you could have all the facts to come to a decision? It would be unfair to Blaise if you didn't have all the facts. So don't think that those facts that we're putting before you are there to put blame or shame on anybody, because it's not. But it would be unfair for you not to have all the facts so that you can come to a conclusion, one that makes sense based on the evidence in this case. Because that's how you get to a solid verdict, is because of evidence, not of sympathy. and not of being angry because I want to give you facts. That's all I want to do. So when they're dating in this casual relationship, they knew each other for less than 90 days. That's a fact. They met up in August, and before the end of the month, they were having sex. That's a fact. And they were having sex without a condom. That is a fact. And we know that because otherwise she wouldn't have been pregnant and thought it was Blaise's. So when she finds out that she's pregnant, she and her best friend are trying to make a decision about who the father was. Because at that time, she wasn't sure. And we talked about that with Najee. And to me, I think that that is a crucial fact for you to consider. Because if she wasn't sure Blaise was the father of the baby, neither was he. So you would then have to believe that he would kill her and that child, not even knowing if it's his or not. That's a fact. And so she tells him she's pregnant. And he's not happy about it. She is. And that's great. There's nothing wrong with that. But Blaise, on the other hand, with only knowing her for 90 days, maybe he's not happy about that. I guarantee you he is not the first human being that in his 20s had a unexpected pregnancy pop up and he's not happy. I guarantee you he is not the only human being who's ever felt that way. And they want you to believe that that's just a horrible fact that would give him motive to kill her and the baby. Most folks in their 20 years, who is in their 20s, who get someone pregnant that they don't know within 90 days, I'm willing to bet at least 50-50, are not happy. That's real life stuff. That's not a nefarious fact. That's just real life stuff. And that's what I'm going to talk to you today about, is real life stuff. Because if you remember, you heard from Nigeria, they were talking about possibly going to Indiana for an abortion. Remember Nigeria was saying it was 2 weeks, 8 weeks, you better make a decision and make it quick if that's what you want to do. And she said, yeah, I do. I need to make that decision. You heard that testimony. Eventually she landed on having the baby, which she has every right to do. But somehow it's okay for her to consider abortion. But it wasn't okay for Blaise to consider it. That's not fair. Don't let them turn that into a nefarious fact that will automatically get you over to murder. They both considered it. It was just her window was shorter than his. And it would be unfair for you to punish him if you don't punish her. So at some point, they talk about it. Apparently, Blaise was still in the position that he was in, even though she had changed her mind. And she, with the strength that obviously she has, or had, said, look, I'm not changing my mind. You've made your decision. If you don't want to be part of this baby's life, kick rocks. I'm good. And he said, okay. You don't see after that Because Najee, I asked her those questions. You don't see after that Blaise constantly calling her, trying to convince her to have an abortion, trying to manipulate her into having an abortion, blowing up her phone, smoothing her out. Because if ultimately his plan was going to be to try to kill the baby, it would have made way more sense to do it up front than wait till she's almost 6 months pregnant. Why would you wait until somebody gets 6 months pregnant if that was your plan all along? Remember, she came back in contact with her December 31st. So he's going to drag it out and let that fetus get 2 months bigger? That don't make sense. He could have done that a whole lot sooner. That would have made sense. That would have been easier. A miscarriage within the first 90 days, that makes sense. Some people don't even tell people they're pregnant for the first 90 days until they're sure that they get past that first trimester. But he'll wait until she's 6 months? So she makes a decision. She says, you go your way, I'll go mine. And he honors that. He honors her wishes. Now, if he was cooking up and stirring up this evil plan, why wouldn't he start the manipulation right off? Najee told you that she liked him. She wanted to be with him. So it would have been easy for him to do that. But he didn't. And I think that's a very important fact. Because if you remember that text message that they read, to you, I want to remind you of that text message. This is Jade. Remember, they read this to you. Next time I'm tagging along for the adventure. LOL. Blaise says, LOL, okay. That's if you want, of course. This is Jade. LOL. He says, gotta still have a job first. And second, you probably ain't doing much traveling for a while anymore. When next season rolls around, I don't think you'll be able to just make impromptu trips on the weekends, considering you'll have other responsibilities. Not trying to be negative or nothing, but just being realistic. I mean, it would be great if you could, but it's unlikely. What does that mean? That means next time this year, you're going to be a mother. She's 23, 24 years old, 24. You're going to be a young mother. And that comes with a whole lot of responsibilities. So start getting your mind right. And if that's going to be the mother of this child, let me give you a little advice. Men who handle their business, they want women, the mother of their children, to handle their business so that they can set a good example for the child that they're raising. Don't let the state turn that into some kind of, oh, he was so mean. No, he was telling her the truth. And those of us that are mothers, we know the responsibility it takes to raise a child. There are often times you miss trips because you got to stay home with your child. You don't get to go away like you used to when you're single. You need to start thinking about those things. The lifestyle that you live, hanging out with your friends and drinking and having a good time, that's going to change. And that's what he's telling her. Not to be mean, but to be real. What's wrong with that? goes on to say, or she says, LOL, okay, didn't mean to make it all serious, but yes, responsibilities will be different, but living life will still be happening as well, just living differently. And I understand the realistic thinking of it as well. It's part of the big change, she says. And he says, yeah, especially for you. I remember getting pregnant. And my mother says something I'll never forget. It goes a long way. She said, honey, that's going to be your baby. Because it's nothing like a mother with their child. Daddies love their children, yes they do. But they don't love them the way the mother does. That mother gets up every morning. That mother got to comb hair. That mother has to get that child out there. And yes, the father should participate as well. But the reality of it is, men don't come close on the daily activities that a mother does with their child. That's real. It's probably something he saw every day with his own mother. And she says, of course, wasn't trying to get into a serious talk for us, sorry. He says, but we don't got to be super serious. I just didn't want to sell false dreams because, yeah, it would be great if you could come on my work trips. But I just feel like it's not realistic from a financial or just a feasible ability to randomly catch a flight and get away for a weekend. We're young. Money's already tight. We can't just spend money on getaway trips on the weekend and this baby is coming. And I could lie to you, or I can keep it real with you. Blaise wouldn't have been able to win here. It didn't matter. If he would have sold her a dream and lied to her on here, they would have been telling you that. But now he's keeping it real with her, being honest with her, and now that's wrong too. Would you rather him lie? The man was trying to be honest. The man was trying to be responsible. And somehow, that's wrong too. It's no big deal. I know you wasn't meaning it that way, but I just didn't want to be like, oh yeah, I'll bring you on the next one, next year, knowing that it's probably a lie. She says, totally understand, babes. It's not like it can never happen because I'm having a baby, but realistic, it wouldn't be able to on the fly. Planning out things will always be an option. Life doesn't just stop because of it though. Laugh out loud. We're still going to have one, just living different. He says, I hear you, but you can't minimize how much things are going to change for you. You've got to be realistic that things are about to be hella different for you and will change drastically. Your day-to-day life is not going to be the same. Yeah, life goes on, but it's forever altered and changed in a drastic way. I'm not saying it's over or anything, but it worries me sometimes when you downplay it and act like it's no big deal. And I know you always want to be super optimistic and stuff, but I feel like you need to be honest with yourself about the situation and know what's down the road for you. Now let's back up with that. He says, it worries me sometimes when you downplay it. That means there's something that has gone on in the past that has caused him, with the woman who is potentially going to be the mother of his child, to start having serious conversations with her. Hey man, let's plan this thing out. Start thinking right. So there's something going on there that made him feel like he should have this conversation with her. If that's going to be the mother of his child, what's wrong with that? In fact, that might be good. And then he says, I just want to make sure you understand the gravity of the situation and you're preparing for those realities. That's all. She says, I'm not trying to minimize things, and sometimes I can be super optimistic. She's admitting to it about things which can be scary. But I do sit and process that there will be drastic life changes and prepare myself for the tough realities as much as I can that are to come. I'm not just trying to make it seem like everything is going to be all peaches and cream. I am hearing and understanding everything you are saying. He liked it. And then he says, hey, what time are you going to work? She says around 3. So she wasn't upset about the conversation. And if you remember, Mr. Devlin, when he was testifying about some of the text messages between them, do you remember when she said that it turned her on when he talked serious with her? That's what this is. That came out of her mouth. It turns me on when you talk serious to me. Some people like to date people and be with people that motivate them to be their best. People who hold their feet to the fire. Iron sharpens iron. And I always say, I never want to be the smartest person in the room, because how can I get better? So when you're attracted to people who are responsible, and that's who you attach yourself with, you're hoping that it makes you a better person. All of our parents have told us, watch your friends. Watch who you hang out with. Look at the 5 closest people in your life, and you'll see your future. So she wouldn't have said that she's turned on by having serious conversations with him if she wasn't. And so that was the nature of that conversation. Now, there was so much talk about how Blaise just totally disregarded the baby, totally disregarded her pregnancy, as if he was just pushing her off to the side, waiting for the perfect moment to kill her and the child. Because if you notice the tone of that text message conversation, it was talking about the future. Why talk about the future if your plan is to kill her anyway? You wouldn't even have to have those conversations. You could just continue to make her feel peachy and creamy. You don't make plans and you don't try to help the person become more realistic about what it takes to be a mother if it's not your intention for her to be a mother. That doesn't even make sense. So I wanted to show you a few things, because we didn't get to show you everything in the phone, because if you remember when I asked Mr. Devlin, was there a whole lot more in there? He says, yes, we only provided a sample. So some of those text messages were, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, Kudos, LOL. Why would he do that if it was his intention to kill the child? Didn't you ever state at occasion you knew that he and Miss Benning talked about naming the baby Jim? Do you remember when I asked Nigella Jackson that? And she says, yes. I said, well, that would be involved with the baby, wouldn't it? She says, yeah. Because remember, her name is Jade, his name is Blaise, and so they were going to name the baby Jim. That's being involved. It may not have been to the level that she would have wanted it. And I guarantee you yet again, if we're talking about real life, there's a whole lot of women out there who would love for their significant others to be a little bit more involved with the child. I certainly know that I would. Here, does Does Blaise rub your belly? LOL. Sometimes. If he's planning names, buying diaper subscriptions, and rubbing her belly, then what we're really talking about is that he wasn't doing it on the level that maybe she wanted it. It wasn't that he wasn't doing it at all. Let's go now to the day in question, because we know how they met, we know how they dated, we know what the understanding was, we know they both considered abortion at one time, one changed their mind quicker than the other, they got back together, they're having realistic conversations. And remember I told you about before, during, and after. Because no one saw Blaise put cocaine in Jade's drink. Nobody saw that. That's undisputed. Nobody saw Blaise give her alcohol. And we're going to talk about that a little later. Nobody saw that. So what that means is, this is a circumstantial case. And in order for you to come to a conclusion that is proper in a circumstantial case, because those are the most dangerous ones, because nobody sees what happened, you have to consider all the surrounding circumstances. Most of the time, the crime is in the cleanup, and I'm sure you've heard that before. So you have your before bucket, your during bucket, and your after. What we do know, and like I said, I'm not doing this to shame anyone, because if I was, I would have a ton of text messages up there about drugs and all kinds of stuff, but I'm not doing that. The only reason I'm sharing this information with you is so that you can have the facts as they really are. So when we talk about before, there was only one person involved with drugs, and it wasn't Blaise. You didn't hear any evidence of Blaise purchasing cocaine, smoking weed, doing mushrooms, getting drunk, drinking alcohol. In fact, it was the exact opposite. The evidence you heard is that Blaise does not drink and does not do drugs. However, what you did hear is that Jade does drink to the point that she gets drunk, and she does drugs. So that's before. Remember, this is circumstantial, so you consider all the facts surrounding it. Jade invites Blaise over. This is important because Blaise didn't know that Jade was going to invite him over that day. He had just seen her the day before. Remember, they had gone to the Waffle House. So there were 2 days before that he was with her, that he could have pulled off the elaborate plan, but he didn't. And so spontaneously she invites him over again. This is the third day in a row now. And so you see here, also, will you be free around 7 o'clock? Yeah, I fell asleep watching Outer Banks, then woke up to gun firing on the show. But yeah, I should be. LMAO, woke up confused, ASF. Okay, I'll have plans for us. You can come dressed, comfy to my house. Okay, sounds good. Sweet, I am getting off now, she says. And that is at 3:50. And he says, how was work? So now this spontaneous plan is 3:50. He has 3 hours to cook up the elaborate plan to kill her. Because remember, he didn't know she was going to ask him to come over that day. So, he comes over. When he comes over, it's 7 o'clock, he's there, and then Nigella and Keontae shows up. He didn't know that, right? Now, if all the while it was his plan to kill her that night, you would think that once Keontae and Nigella showed up, if he had any kind of sense, he'll abort the plan. But no, he's brazen. Even though her best friend came over, saw him in the apartment alone with her, almost 6 months pregnant, 25 weeks, I believe the autopsy said, he decides, I'm going to go ahead with the plan and kill her anyway. I know they saw me in here. Doesn't matter. I'm going to do it anyway. And so, they eat. Nigella and Keontae, they come, they talk, they interact. He invites them to stay. He invites them to stay. Why would you invite them to stay if it's your plan to kill her? So you can have witnesses? No. So they stay, they talk, he's shuffling Uno cards. Because the murderer who doesn't drink or do drugs plays Uno and then kills pregnant women on his downtime. And then they leave. And then they talk and they dance. They take selfies. And then the call comes. It's 9:29. The first call from Nigella. And the reason I wanted to lay this out this way was because there's been so much talk about this elaborate cleanup that he must have done. And I wanted you to see that there was no time for that. Because now we're in the during phase. And so 9:29, Nigella calls, and that call lasts 6 minutes, 9 seconds. That takes us to 9:35 and some change. And I think the interchange between that time and when he calls his father at 9:38 and 12 seconds is about 2 minutes. Now mind you, Jade is having a medical emergency. All kind of things are going on. She's foaming at the mouth. She's shaking. She sounds like she's snoring. They tell him to get a towel, go wipe her mouth, put her on her side. He's trying to tend to her. But he's being punished for that. And if he wouldn't have tended to her, he would have been punished for that. But even still, as he is calling, or in the call at 9:29, when Nigella says that she's saying, you put something in my drink. What did you put in my drink? Do you remember the text message that Nigella sent as a result of hearing you put something in my drink? Are you talking to me? I want everybody to think about your best friend. And your best friend calls you on the phone. I want you to envision that. And you pick up the phone and you say hello. And they tell you, on the other phone you hear, you're stabbing me. You're shooting me. You're killing me. Are you going to say, are you talking to me? You know they're not talking to you. You're going to say, what's wrong? What's going on over there? Do I need to come get you? Do I need to call 911? That's a natural response. But instead you send a text saying, are you talking to me? Remember, nobody else heard exactly what was going on that phone call. Nobody but Nigella. So let's look at the facts surrounding that. As much as she says that this was the worst thing she's ever heard, her friend was in so much danger, so much distress. It was horrible. It was scary. She knew, because she just left there, she knew that he was in that apartment. She was in that apartment alone with the man who was trying to kill her, according to her. But she doesn't call 911. Instead, she calls Keontae, who only met Jade twice. And apparently he gets on the phone. They're talking. At least he says he could hear her trying to talk. So if she's trying to talk, Dr. Ola Sugar told you she has to be breathing in order to do that. Remember, Keontae actually said he did hear her voice. But even with that, as dire straits as Nigel explains that it is, he goes out with his buddies anyway. Think about that. If it was as horrible and dangerous, why would this guy put his clothes on and go on out anyway? And then remember, Nigel, immediately after hanging up, called Jade's mom and shares with her what she heard, what Jade said. And notwithstanding that, Jade's mom sends Blaise a text and says, oh, the baby's good, the heartbeat is okay. If it was as serious and people believed Nigel or believed in the credibility of her, do you think that Jade's mother would text that man and tell him and give him an update about the baby? Are you going to text the man who's just been accused of killing your child and give them an update about the baby? Are you going to do that? There's something not right about that. But that's what happened. And so, right after that phone call, he calls his dad, on the phone with him for 30 seconds, because that's what he told the police officer, that he talked to his dad, and his dad said, son, hang up with me and call 911. What are you doing on the phone with me? He does that, and within 16, so if that call lasted 30 seconds, that takes us to 9:38 and 42 seconds. And at 9:38 and 58 seconds, Blaise is on the phone with 911, and you heard that call. You heard the desperation in his voice. He didn't know the address to give the man. You remember that interchange. So the only way to get the address would be to run to the front to get the address. And if you remember what he says, I want you guys to pay attention to this. He said the address is 1522-1550 Lebanon Pike. Most of the time when people give an address, it's only one numeric value. It makes sense that he ran to the front of the apartment or the condominium complex, because that's the exact address he gave them. So then, after that, I went the wrong way. Then he gets off the phone with 911, and she calls back. So if it was 6 minutes and the 911 call was almost 9 minutes, so that would take him right around to 9:47, and Nigel calls back to Jade's phone. And he answers. He didn't have to answer. It was Jade's phone. He could have said, I was dealing with an emergency. But he picked up the phone and gave her an update, doing the responsible thing. Then after that call lasted about 2 minutes, she says. That takes us to around 9:49. EMS arrives at 9:48. And if you look at that slip from the EMS, because you'll have the right to look at the evidence, it's going to show you that EMS arrived about 9:48. And you heard him say, I can hear the sirens. I think I can hear the sirens. And then he goes out and runs to get them. Remember, on the call, the man says, put her on her side. So he did that. Then if you remember, as much as she didn't want to, she told you that Blaise ran out to meet them, at least at the door. So perhaps she rolled over while he was gone. We don't know. But nobody's calling 911 and doing all those things to help, only to put her on the side and try to kill her. So by now, EMS is there, so the time for cleanup is gone. Where was all this time for him to clean up? It's not there, because remember, those selfies was less than 60 seconds before the emergency call. The time just isn't there. So that's during. So when we think about during, there was only one person who called 911. Only one. As sick and as dangerous that it was described to be, only one person called 911. Frantic, running to get the address, doing everything that he could do. That's during. Now let's talk about after the investigation. Listen. What's unfair is 3 years later, Blaise is now held responsible to try to prove himself innocent, when one, that's not the law, and two, a lot of the evidence is gone. That's unfair. How can I prove my innocence when Detective Reese said he let the video surveillance camera get erased? How does the lead detective not get that surveillance camera that would have showed Blaise coming and going, Najee and Keontae coming and going? If he really ran to the sign, we would have seen that. If he came there with something in his hand, alcohol and or cocaine, perhaps we would have seen that on the video. If somebody else showed up there that day, perhaps we would have seen that. But they allowed it to get destroyed. Blaise didn't know that. Remember, he didn't get arrested for a year later. If he knew the burden was going to be shifted from what the law was, then maybe he would have done the investigation himself. But he was trusting the police to do the investigation, because that's their job. And we know that she met with the drug dealer that day, albeit it was for Mario or whoever it was for. If this is a drug overdose, I really want y'all to think about this. If this is a drug overdose, why wouldn't the police officer go talk to the drug dealer? If it was a financial crime, you chase the money. How in the world, in a drug crime, you don't bother to speak with the dude who sold her drugs that day, whoever it was for, whether she met up with him or not? That's not for us to have to figure out. But he didn't. So now you don't talk to key witnesses. And there were other drug dealers in her phone too. They didn't call any of them. You let the surveillance video get destroyed that possibly could have exonerated him. But we'll never know that. And now he will be punished for it. You let the cup that was supposedly the missing cup, the crime scene investigation team, they didn't see it. It was on the counter. Somehow we missed it. But all along, there was this missing cup that Blaise must have taken, because he cleaned up. We already seen there wasn't time to clean up. And he had taken the cup with him. The whole time, Detective Reese had to tell you, we missed the cup. It was there the whole time. Well, perhaps if Blaise knew one day he would be sitting here facing felony murder charges, he'd have had the cup tested himself. But he can't do that now. And he shouldn't have to do that now, because that's not the law. That was their job. And if it was cocaine in it, they would have known it. But they did take a bunch of glasses. They took all kinds of things from out of their dishwise, and there wasn't anything on it. Anything. And think about this. Remember how they talked about all this cocaine? One thing they cannot get away from is that she had cocaethylene in her system. They can't get as much as they would love to. They told you first it was coming from vanilla extract. Don't do it. Don't believe that. Or two, because of some of the treatment she got at Vanderbilt. There is no treatment at Vanderbilt that leaves you with cocaethylene in your system when cocaine and alcohol come together. That means, think about this, that means that he would have had to put cocaine and alcohol in either her water or her lemonade. And the chefs have sensitive palates. They taste food. That's what they do. They'll taste something and they'll tell you what ingredient is in it because they're trained that way. She didn't taste alcohol or cocaine. Neither one of them. And the amount that they're saying that he gave her. Does that make sense? How do you do that? How do you put that much cocaine in somebody's drink and alcohol? And they come out saying it tastes funny. It's going to taste a whole lot worse than just funny. You're not going to keep drinking it. And according to the state, it was so much that it caused this overdose. So she kept drinking cocaine and alcohol, the chef, and never ever noticed it? No. So then we go to the fact that first, Lauren Weber went to the scene. Now remember, police are all through that hospital now, because they get to the hospital at 10:12. That's going to be on your sheet. Remember, 5. So that's over an hour or so later. You got Officer Fish, Officer Pfeiffer, Detective Martin. You have all these officers who are now interviewing Najee, interviewing Blaise. And Najee knew it, and I guarantee you, Ms. Burks knew it, Ms. Franklin knew it, and Lauren Weber knew it. And we know they knew it because Officer Fish told you that Ms. Burks was on the phone when she was talking to Ms. Brown. And she said that they told them the detectives are coming that night. But Lauren Weber remembers the significant other of Mario, the one who asked her to go get drugs that day. The first person in there is Lauren Weber. And she said, don't get lost on it, she said, all I did, I didn't touch anything. I grabbed the keys, blew out a candle, and left. But Officer Reese told you that she said she removed belongings too. And that she looked all throughout it. You can't do both. One of them is not true. Either you went in and grabbed keys and just left, or you went in there and grabbed belongings and looked all throughout it. And if you did that, why lie about it? Just say what it is. Unless you had something to hide, or unless you went to get something. Then notwithstanding that, now you have detectives on the scene. And Officer Fish told you that she told Ms. Burks and Ms. Browning, this scene is on lock. Nobody in, nobody out. But the truth is, nobody should have had to tell you that. Because if he did it and you think he did it, you want to leave that scene just the way it is, because he may have made a mistake. And I want those officers to be able to catch that mistake. I don't want to touch it. Jade doesn't need to go back there that night. She's in the hospital. We're going to lock this thing down because we're going to catch him. I know he would have made a mistake. They went in there and they removed evidence and they manipulated evidence by moving it from here to here. Why would you do that? And they said, oh, well, the officer gave us permission. And then you remember Detective Martin getting on the stand? And then he said, oh, I may have given them permission. And Mr. Joyner said, well, didn't you send me an email yesterday saying that you didn't? What changed? Oh, well, this morning when I got here, things changed. Okay. Don't allow that to happen. That's not right. Because what detective would tell a woman and 3 young girls, y'all go do the investigating for me, let me know when you're done and what you come up with? That doesn't happen. That doesn't happen. And then you have the only other eyewitness, the only other person in that house. He should be just as important as Nigel.
All right, Ms. Hollins, you need to be wrapping up your argument.
And Detective Reese, yes sir, Detective Reese said, I like to bring people in to talk. But I didn't bother to have Keontae came down. I just called him on the phone. And Keontae wouldn't tell you the truth about his theft conviction. And he told you, because he didn't talk to anybody there that night, even though he went there. Why not? He said they didn't have security. There it is right there. Why didn't he talk? I don't have a lot of time left, so I'm going to go through it quickly.
You don't have any time left.
May I have 5 minutes? Yes, sir.
You got a minute.
I've given you the investigation. That's the towel he took. I got 60 seconds. I'm going to do my best. That's the towel he took. That's where he got it from. If he was cleaning up, he would have fixed those towels. But he didn't. That's the surveillance video. That's that missing cup. It was sitting there the entire time. No one in, no one out. That's the V8 bottle. It wasn't in there. You see the lemonade, you don't see the V8. And on those other pictures, you don't see it either. So, that's the communication log. Cocaethylene is in the system. You're going to have the reports. It's there, and it was there in the vomit. And all of these doctors told you that. And the autopsy report at the end of the day, don't forget what I've shared with you. At the end of the day, even the medical examiner can't come to a conclusion. And with all these surrounding circumstances, how can you? Now, I told you that when you get back there, you're going to be tired and it's going to be long. And you promised me that you would not let anyone change your convictions of what you believe, no matter how long it takes. Because you said if they can't make a decision in the most important affairs of your life, that you wouldn't let them do it for Blaise. I thank you so much for your patience and for being here. And the Taylor family does as well. I won't get back up here and make another argument because we don't have the burden, they do. So when you get back there, you make the argument for me. Thank you.
All right, Edie, you're going to argue on behalf of the state.
Yes, Your Honor. Ms. Hollins went back and forth between whether or not Blaise Taylor even thought he was the father of this child. She said that Jade Jackson said she wasn't sure. You heard the testimony. I submit to you that Nigea said she was sure, it's just he wasn't involved. And she was saying that at the hospital because he was telling the people at the hospital that he loved Jade more than her. And she was, that was not true. That's what she testified to about whether or not he was the father. She told all of the officers, he's just the father. He's not involved. But Ms. Hollins argued to you that he wasn't the father, but then she also wants you to consider a text message where Jade is telling her mom that he signed up for a diaper service. You can't have it both ways. Also, Blaise Taylor told people he was the father of her baby. He told Keontae, Nigea, the people at Vanderbilt. He told the police officers. Now, when he calls 911, he's with a friend. But when the police come, that is his girlfriend. He is absolutely committed. And the text messages with Xavier Winford absolutely were not submitted for any purpose of saying somehow Mr. Taylor was a bad person because he was seeing more than one woman. It was for that very purpose. He had someone that he loved, that he was telling, I love you. But also the rest of that thread is that something's happening, but everything's going to work out for them. But it's very much against what he told the police that Jade Benning was his girlfriend. His interactions with her, it wasn't I love yous. She also wasn't going to admit he's the father of the child, but yet wants to say that they picked out the baby's name together. Well, Nigea Jackson testified about that, and she was very specific that that was a name that Jade suggested, and he agreed. He didn't disagree with it. But you also heard testimony that Jade's unborn baby girl's name is Ivy. She, just to clarify, I don't know where the Lauren Weber Mario connection came from. I submit to you that the evidence that you heard was that Mario texted Jade. Jade texted Danny. Danny wasn't in town. No one met up. Lauren Weber was not involved in that. Lauren Weber went to the apartment, and her testimony was that it seemed too clean. And she told the officers that. That was the first thing she said to them. She went in, and it was so weird to her that she took 2 pictures and she locked the apartment. I submit whatever happened within the police department for officers to not go there that night and seize that scene, absolutely. That is a mistake. That should have happened, and it did not happen. But it doesn't change anything. Thank God for Jade's family and friends that they were not happy because nothing was happening, and it needed to happen. And they took care of it. There was nothing that was disturbed. Now, Mr. Taylor in the cleanup, he did not put the camera back. And they put the camera back where it would be, where it would face the door, not knowing if he could come back in because the police aren't there. Ms. Hollins also argued that somehow if he wanted to kill the baby, that he wouldn't be wanting updates from Jade's mom. Jade's mom's updating him because nobody knows yet about the cocaine. That first drug screen in the hospital, it was negative. She doesn't, nobody knows what's happened. She referenced the cause of death with Dr. Carney. Not the cause of death, the manner of death with Dr. Carney. And she put the report up, and it very clearly states that there's a suspicion for homicide because it's possible that she ingested the cocaine without her knowledge. Someone gave it to her. But Dr. Carney's determination has nothing to do with yours. Your determination is reviewing all of the evidence to determine what proof beyond a reasonable doubt. If she determined it was a homicide, you could not consider her determination for your decision. That is for the death certificate. Ms. Holland's arguments to you about Blaise Taylor. We wish we had the surveillance video. Yes, it would be much better if we had the surveillance video, but not to exculpate him. It would show him going in and out. How long was he out there before he went back inside on 911? How many times did he go out there? It would show Jade Benning pulseless the way he saw her being carried out by the EMTs. There is nothing about that that undoes the proof in this case. She argued that a chef would know that there was something in a drink. Jade Benning absolutely said, I knew there was something in my drink because I tasted it. Those are the facts. Ms. Holland's entire argument is asking you to ignore the testimony that again was unimpeached by Nijaya Jackson, that Jade Benning said all of these things. She said them to him. It's only the two of them in the apartment. He says it's only the two of them. He says Jade was talking to me. Her arguments to you are asking you to not only ignore everything that Jade Benning said, but it's to ignore that if for some reason it was true and Jade Benning ingested the cocaine herself to kill herself and her baby, and then called her best friend and said these things to Blaise Taylor, and Blaise Taylor never tells anyone what she said. He doesn't, when he sees Nijaya, say, oh my God, what happened? She said these things. I didn't do anything. We have to figure out what's going on. That is absolutely not true. He didn't tell anyone what Jade said. And when Detective Smith asked him if Nijaya would have any reason to make up these accusations, he didn't even say she was making it up. He said, I think she's just in shock, and I was the last one with Jade. There is no explanation because Jade Benning said these things. It is the proof and evidence in this case. Jade Benning named her murderer and the murderer of her baby, and she told you why. The state does not have to prove the why, but Jade Benning told you why. And I submit to you that the evidence in this case is proof beyond a reasonable doubt that Blaise Taylor is guilty of all 4 counts of the indictment. Thank you.
Members of the jury, count 1 and 2 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree premeditated murder. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. Counts 3 and 4 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree murder during the commission of a felony. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The indictment of this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. To this indictment, the defendant has entered a plea of not guilty. The evidence and arguments in this case have been completed, and it's my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I've ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, nor any other remarks which I've made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume that the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Sometimes in the trial of a criminal case, when a defendant is charged with a crime or crimes, this crime or crimes include lesser included offenses. The law permits the jury to find the accused guilty of the lesser included offense, which is included in the crime charged in the indictment, whenever a course of conduct is consistent with the facts found by the jury from the evidence in the case and when the law is given in the instructions of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The court will now instruct you as to the law applicable to all counts of the indictment. First, it will set forth the laws applicable to the crimes charged in the indictment. Finally, I will describe for you the deliberation process. Counts 1 and 2, first-degree premeditated murder. Any person who commits the first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Counts 3 and 4, first-degree murder during the commission of a felony. Any person who commits first-degree murder during the commission of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate an alleged first-degree premeditated murder. That is, that the killing was closely connected to the alleged first-degree premeditated murder and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged first-degree premeditated murder. For the defendant to have been found guilty of first-degree premeditated murder, the state would have had to prove beyond a reasonable doubt the essential elements of first-degree premeditated murder, which have been previously set out on page 5 of these instructions, and you should refer to those instructions as they apply to this offense. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged first-degree murder. The killing may precede, coincide with, or follow the first-degree premeditated murder and still be considered as occurring in the perpetration of the first-degree murder, so long as there is a connection in time, place, and continuity of action. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant unlawfully killed the alleged victim, as to count 1, as to count 3, Jade Benning, and as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established that if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. The definition of recklessly has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. The definition of criminal negligence has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. When you begin your deliberations on the indictment, you must first deliberate on the indicted or charged offense. If you find the defendant guilty of the indicted offense, you may stop your deliberations as to the remaining charges within that count of the indictment. If you find the defendant not guilty of the indicted offense, or you have a reasonable doubt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses as set out in your verdict form. You must first deliberate on the greater offense and reach a verdict as to the greater offense before you move on to the next lesser included offense. If you reach a verdict as to the guilt of the defendant as to a greater offense, you may stop your deliberations as to that specific count. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree as to counts 1, 2, 3, or 4, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to life imprisonment without the possibility of parole or life in prison. But you will not consider punishment for this offense at this time. I noticed that some of the jurors appear to be making notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and to use the notes only as an aid to memory. and any juror who takes notes will use those notes only for that juror's assistance in that regard and not as an authoritative thing to show others. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. The court charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Blaise Taylor, committed the crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of proof in this case, then you should return a verdict of not guilty. During the trial, you heard expert testimony of Dr. Michael Olashoga and Dr. Kelly Larkin, who is described to us as an expert in the field of emergency room medicine, Detective Tom Miller, who is described to us as an expert of the field of digital forensics, Dr. Aaron Carney, who is described to us as an expert in the field of forensic pathology, Dr. Carrie Midthen, who is described to us as an expert in the field of forensic toxicology, Eric Devlin, who is described to us as an expert in the field of digital forensics, Nicole Dowell, who is described to us as an expert in the field of forensic science drug identification, Dr. Alex Krotulski, who is described to us as an expert in the field of forensic pathology, Dr. Melissa Giguere, who was described to us as an expert in the field of forensic toxicology, and Dr. Janice Lindsay, who was described to us as an expert in the field of forensic toxicology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is evidence that proves one or more facts from which you find or infer the existence of some other fact or facts. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. An inference is a reasoned, logical decision to find that a disputed fact exists on the basis of another fact. You should consider all the evidence that is presented in this trial direct and circumstantial. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. You are the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. If from the evidence presented you find that a witness has been convicted of a prior crime, you can consider such only for the purpose of its effect, if any, on his credibility as a witness. The defendant has not taken the stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Tape recordings were allowed in evidence, and you were provided with a document purporting to be a transcript of the audio tape. This document was provided to you to assist in your listening to the audio. If from your listening to the tape you find discrepancies or inaccuracies between the transcript and the tape itself, you should rely upon your understanding of the tape and disregard those portions of the transcript you find to be inaccurate. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Davidson County, and that it was committed before the finding and return of the indictment in this case. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report that you find the defendant guilty and name the offense according to your previous instructions. On the other hand, if you find that the state has not proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt, then you must find the defendant not guilty. In that event, your foreperson will report that you find the defendant not guilty. You will be provided with a form for all possible verdicts in this case. For each count, the jury will check the appropriate verdict on the form, and your foreperson will sign the verdict form. The verdict form which you'll receive reads as follows. Verdict form. We, the jury, find the defendant Blaise Taylor, count 1, first-degree premeditated murder, and count 1 and 2, the verdict forms is the same. Choose 1. Guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. Count 3 and 4, the verdict forms are the same and read as follows. Count 3 and 4, first-degree felony murder during the commission of a felony. Choose 1. Guilty of first-degree felony murder during the commission of a felony, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. There's a signature line for the foreperson and a line for the date. When you retire to the jury room, you will first select one of your members as a foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge so as to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the indictment in this case is herewith handed to you together with the charge and the exhibits in this case. You may now retire and consider your verdict. And let me swear in the court officer. Do you solemnly swear or affirm that you will keep this jury committed to your charge, keep them separate and apart from all citizens, allow no one to communicate with them or communicate with them yourselves on the subject of the trial?
I do.
All right, let the lawyer step up just a moment.
All right, the jury has not started deliberating yet. Polly is schmoozing my computer right now. I think she wants to play. They get used to me playing with them at lunchtime after they eat. I know. Good girl. Here's Polly. Yeah, that's a good girl, Polly. Yeah, it's my good girl. Good girl.
12 regular jurors, if our 4 alternates, I'll speak to you in just a moment, can stand right there against the wall there. The other 12 of you, if you'll step down the hall, we'll get these items to you. All right, the alternates, obviously the court never knows whether we'll need someone to substitute into the deliberation process or not. Would have expected a week ago, Monday last week, that we probably would, but we didn't. So I appreciate your service. You'll be discharged from this case. We'll shred your notes for you, and you can step out with the court officer. All right, we'll be in recess.
Court's in recess.
I'm going to start it at 12:40. We still have another minute here. 12:39 local time. I'm going to start it at 12:40. Because as we heard from PI Sam, it takes him a good 5 minutes to get back to the room, get all the evidence. And now we wait. Yes, and now we wait. All right, 12:40. Here we go. Officially starting it at 12:40. This is local time. I'm sorry, this is East Coast time. So, pin that up here too. 12:40 Eastern time. Start. All right. 12:40 Eastern time start. All right, we have a lot of testimony to look back on. So I think, Deshaun, you were asking to start with Apple. So we could start with Apple. Let's start with Apple's testimony. We'll start with that. He didn't say anything about, excuse me, he didn't say anything, meaning judge, didn't say anything about how far, once a verdict came in, how much time would be in between, right? Did he say that? Did you guys hear anything? We were feeding the cats. Did you guys catch that at all? Did anyone catch, did he say it? Did he say, please be within 10 minutes, 15 minutes, 20 minutes? Did anybody say that? Or did anybody catch that? Did the judge say that? I did not hear it, but I was involved with feeding kitties, so I did not hear that. Did he say that? Kaylee, yeah, you didn't hear anything about that? Yeah, I didn't hear that either. Sometimes they'll say stay within 15 minutes. Michelle sent a goat. Thank you for that, Michelle. Oh, there it is. I see it. Thank you for the trophy goat. Appreciate that, Michelle. He didn't say that. Sent Bunny, Aussie, yeah. Sent Bunny, yeah. No, he did not. Scott, okay. Everybody's saying no. All right. Everybody's saying yeah. Okay. I was listening, but I was paying attention to the cat. So all right. So we'll see what happens. All right. Let's go to Apple. Deshaun, this is for you. You wanted to hear this, and again, I want to listen to literally I kind of want to listen to all testimony again, because there was so much testimony. So let's start with Apple, right? Let's start with Apple's testimony. So let me see here. We'll start with Apple's testimony, but there's a lot of testimony I want to hear again. But we're going to start with Apple's testimony because Deshaun asked for it, and we're going to provide it. All right, I'm going to put this down here. So that's the live view there, and let's see, I'll put it over here. So that's the live. The live one is behind me, and then this will be Apple.
Good afternoon, Ms. Ms. Denny, could you please state your full name for the record?
Apple Denny.
And can you spell your last name for the court reporter?
Dennie.
And Ms. Denny, how do you know Blaise Taylor?
We dated when I was an undergrad at Arkansas State.
And how old were you when you started dating him?
18.
And can you describe how long did you date him?
A couple years through 2018. It was breakups, get back together, breakups, get back together, so the timeline gets a little foggy.
Which, for reference, you said that y'all began dating when you were 18. How old are you now?
28.
And what year were you in school?
I started fall of 2016, fall of 2016, and I met him in November of that year.
And what year was he in school?
I believe he was a senior.
Do you remember how old he was?
No.
But he was a couple years older than you, is that fair?
Yes.
And did you continue to date into the beginning of that next year, early 2017?
Yes.
And at some point in your relationship, did you ever become pregnant?
Yes.
And about when did that happen?
January of 2017.
And when that happened, did you talk to Mr. Taylor about it?
Yes.
And can you describe kind of what were your feelings when you learned that you were pregnant?
I was really scared and confused. I knew I wasn't ready to have a kid. So.
Was that your reaction kind of from the beginning, and did it stay that way?
Yes, I immediately, that wasn't something that I thought I wanted for myself.
Was that something that you felt like you could talk to your parents about at the time?
No.
And so from the time that you found out, what did you ultimately end up doing?
I had an abortion.
And was there any point in which you changed your mind about that?
No.
And Mr. Taylor, did he accompany you to the appointments for that?
Yes.
And was there one appointment or was there more than one?
There was two.
And did he go to both of those appointments with you?
Yes.
And can you describe at that first appointment what information was provided to you about the options?
There were two different types of abortions that I could have. One was the procedure, and
Your Honor has already ruled.
Go ahead.
Your Honor.
and the other was taking a pill at the center and then taking one when you got home, and that would induce the abortion.
And did you discuss those two options with Mr. Taylor during that time that you were going through this?
Yes.
And which option did you ultimately choose?
I had the procedure at the facility.
And did he accompany you to that visit?
Yes.
And at any point did you meet his parents?
Yes.
Did y'all continue to date after that?
Mm-hmm.
And you said that you broke up, but then you would get back together.
Yes.
And when you broke up, was there anyone in particular that he might have dated while you were broken up?
Yes.
And who was that?
Her name was Xavier.
And what was her last name?
Winford.
Did you know Miss Winford?
Yes, and not personally, but I knew her through him, and we had a few interactions.
And can you describe what was your understanding of his relationship with her?
Someone that he dated before he met me, or didn't date. He said they were never together, that he would never bring her home to his parents, and that she was crazy, and that I needed to block her, and it was kind of that situation.
And at some point, did he come to you and talk to you about something that happened with her?
Yes.
And what was it that he came to tell you about?
That he got her pregnant.
And what was the time frame that this occurred?
This was the summer of 2017.
And what was his demeanor like when he came to you to tell you about this?
Very erratic. He was upset, didn't want to have a baby with her. That's what he was telling me, that this was something that he couldn't do.
Was that a different reaction than he had when you told him you were pregnant, but you did not want to keep the baby?
Yes, it was flipped. How I was panicked the first time around, and he was freaking out when it was her.
And when you say he was freaking out, how did he act when he was panicked?
Really erratic, and but then he would say he could control the situation. It went on for a few days of us talking about it, but that night he was trying to figure out if there was something that he could do. He was Googling things, so he was looking stuff up to figure out how she, if there was something he could do to make her have an abortion, and asked me if I could get the abortion pills and he could make her take them or put it in her drink.
And so you talked to him over a period of a couple of days, is that correct?
Yes.
And what was he telling you? I mean, he's telling you that he's trying to figure out something that he can give her.
Yeah.
Was she wanting to have an abortion based on what he said?
No, he said she would go back and forth, and he would tell her, well, I'm not gonna be a part of the child's life, thinking that would convince her to not have it, because that's ultimately what he said she wanted. And then they would just go back and forth about it, and then someday he would say, I think she's gonna do it, and I think she's not gonna do it, but she didn't want to.
And you said that he was telling her he would be a part of the child's life. Was he also saying not part of her life?
Yeah, he wouldn't have anything to do with her if she went forward with it.
Kind of like an ultimatum.
Yeah.
And he asked you if you could get the abortion pill for him so that he could make her take it and put it in her drink. Is that right?
Yes.
Okay, she says acknowledging what Gordon said. Go ahead.
Did you do that?
Did I get the pill?
Yes. No. Was that even, not saying that you would agree to do that, but is that even possible?
No.
And did you explain that to him?
Yes.
And you said that it went over a couple of days. Did he talk about anything else that he might be able to get to put in her drink?
Justly.
Okay, I will overlook Judge when she's just asking, did he?
Yes.
And the things that he was mentioning, how did he get the information?
He said he was looking stuff up on his phone. I couldn't see what he was looking up, but he had his phone in his hand.
And I guess what, if anything, else did you discuss with him about Miss Winford and Miss Winford getting an abortion?
He had asked me to make the appointment and said that he thinks that he could convince her by the time the appointment came to get the abortion.
And what would be the reason that he would need you to call to make the appointment?
Because she wouldn't call herself, but he wanted to go ahead and get an appointment set.
Is there a waiting time? Was there going to be a delay from the time you called to when the appointment would actually be scheduled?
Can you rephrase that? Sorry.
You said that he wanted you to schedule the appointment
Yeah.
because he thought he could convince her to do it and didn't want her to change her mind.
Yeah.
I'm asking if there was going to be like a time period.
Yes. And he didn't want, like, they were booked, so he didn't want her to finally decide to and then not be able to get it.
And did you agree and call and schedule that appointment?
Yes.
And did you pretend to be her?
Yes.
And do you know if she went to the appointment that you scheduled?
Yes. I assume it was that appointment.
And you said you assume. I guess, do you know what ultimately happened with that pregnancy?
Yes, that she had an abortion. That's what I was told.
And do you know, did Mr. Taylor continue to see Ms. Winford after that time frame? That would have been summer of 2017.
Yes.
And do you have any knowledge if he's continued to see her since then?
Yes, I have assumed so.
Objection. No basis for that. It's just personal.
Okay, I'll strike that if she just thinks so.
Do you have any knowledge about that?
I saw a post of her at a game,
Objection.
and I was.
Okay, hang on just a second. You carry me further.
I'm just asking if she has personal knowledge of the two of them being together.
When it was something was taken or when it was posted, and she doesn't know that.
Okay.
All right, go ahead.
Did you know Jade Benning prior to February 25th of 2023?
I knew of her. We had had some message exchanges on social media. Like, she told me happy birthday, vice versa.
And what was the connection between you and Jade Benning?
She was in a similar area. Like, the Little Rock area is pretty small, so like a lot of my friends grew up with her. So we kind of just would see each other on social media and connected that way, but I never met her in person.
So she was kind of the social media connected friend of other friends?
Yes.
Did you both participate in the same athletic sport?
I think I was told she cheered, but I never like met her through that, but we might have both been cheerleaders at some point.
Okay. So you knew of her, but didn't actually know her, and you had never met her?
Yeah.
How did you hear about what ultimately happened to Jade Benning?
Two of my friends had said that they needed to talk to me and called me and told me about what happened.
And when you say they told you about what happened, about what was the timing of this? From when the incident happened, Ms. Benning passed away, was it before she passed away?
Yes, she was still in the hospital at this point.
And so that would have been kind of right after this incident?
Yes.
When you say they told you what happened, what kind of information did you get?
I don't remember like verbatim, but they told me that they thought that, or were told that he might have poisoned her or something of the sort, but they like didn't have details, and that she was in the hospital and they were like keeping her on life support, I think, until her birthday. Yeah.
And when you heard that, what did you do?
Like immediately after the phone call, or
I guess kind of connected to Ms. Benning and this case and how you ended up here today?
Well, like I talked to them, they knew about the situation with Xavier in the past, and I want to say maybe a few days later, my friend Ariane had reached back out to me and asked if like I wanted to connect with Miss Bridget, and I said yes, that's fine. I'm open to helping in any way that I can. And then Miss Bridget reached out to me, and then from there it was Detective Reese and so on and so forth.
And did you talk to Detective Reese and provide him with the information that you've just testified about?
Yes.
And then did you also meet with Detective Reese, myself, and Deputy Moore, and Ms. Houston?
Yes.
In Arkansas? And did you provide us with that information as well?
Yes.
If I can have just one moment. And I'm sorry, Ms. Denny, I feel like you said that they told you about Jade.
Mm-hmm.
When they told you about Jade, what was your understanding of whether, like, what her condition was?
That she was pregnant, and you mean like her physical state, that, or
No,
just the
but
fact that she was pregnant?
The information that you got from the friends was that she was pregnant, and
Yes.
there was
And
suspicion.
something happened to her, and they were thinking that it was Blaise, and that she was in the hospital after that.
And do you see Mr. Taylor in the courtroom?
Yes.
And could you point him out and identify him?
Right there.
Thank you, Ms. Denny.
All right, questions on behalf of the Yeah, you can turn up top. There you go.
Miss Eddie, I want to make sure that I'm understanding, got this right. So you never put anything in anyone's drink, right?
No.
You never went and got an abortion pill on behalf of Mr. Taylor?
No.
You never got any kind of other substance from Mr. Taylor?
No.
You never got any cocaine?
No.
Never got any fentanyl?
No.
You guys never slipped anything in anybody's drink?
No.
You never saw Mr. Taylor do that either, right?
No.
So what we've kind of described is like just a conversation, right?
Yes.
Conversation while Mr. Taylor was, as you described him, like erratic.
Yes.
He was panicked, I think was the word he used, and maybe that was my word, I'm sorry, but was panic a right word?
Yeah.
And while he's erratic, panicked, you guys are having this conversation,
Mm-hmm.
and he's talking about this kind of stuff.
Yeah.
But it wasn't something that you ever actually acted on.
No.
It wasn't something that he ever actually acted on?
No.
Okay. And just so I got the time right, so we're talking, you started school in 2016?
The fall of 2016, yes.
Fall of 2016. And you met Blaise, Mr. Taylor, and start dating maybe the middle of that first year of your school?
We met in November, yeah. Things evolved from there.
Okay, I apologize. So you met at the beginning of the year, is that right?
We met in November of the fall of 2016.
Okay.
And then continued on from there.
And your kind of pregnancy situation, which I know is difficult to talk about, that happened more like the middle of the year, is that right?
That was in January of 2017.
Which would still be your freshman year of college.
Yes.
Right? And you're still just 18, 19 years old?
Yes.
Just very young, right?
Yes.
And that's a very difficult thing for someone who's that young to deal with, isn't it?
Yes.
And during that situation, at least initially, Mr. Taylor was maybe on board with keeping the baby, wasn't he?
Yes.
And in fact, ultimately it was your choice, right?
Yes.
And you made the choice, and Mr. Taylor was supportive of that choice, wasn't he?
Yes.
He went with you to the appointments, right?
Mm-hmm.
And he did whatever needed to be done, right?
Yes.
And then, whatever happens with your relationship, this thing with Miss Winford comes up. Is that right?
Yes.
And he has a reaction to it. Is that fair?
Yes.
And it was a pretty extreme reaction, right?
Yes.
I mean, and at that age, are you still 18 or are you 19 by that time?
I'm 19.
19. He's maybe 20?
No, he might have been 21. I think he's a couple years older than me, but I don't remember how old he is.
Okay, so maybe he's 21, right?
Mm-hmm.
You're both still in college, right? Is he playing sports in college at that time?
Yes.
And you're a cheerleader?
Yes.
Right? you guys are both busy with your lives in college,
Yes.
right? And this pregnancy was a scary thing for him, right?
Mine or
Xavier's.
yes.
And he confided in you in a way that he was really terrified, right?
Yes.
So that conversation, the words that I wrote down is the conversation you had where he's asking you about getting an abortion pill, where that night, was there something we could do? So that was the first night that he finds out about it, right?
It might have been the first night. I'm not 100% sure if it was that very first night or the second night. But I know it was shortly after, like, this was unfolding and he found out.
Sure, really a quick, immediate reaction right after he finds out, right?
Yes.
And so he's talking about these kind of crazy things like, can you go get an abortion pill for her, right?
Yes.
And this says something else crazy like, is there something we can put in her drink, right?
Yes.
That's what you're saying. And then that was kind of the end of it. Like, you have a couple crazy conversations and there's no more, right?
That I remember, yeah.
Okay. And certainly this, I mean, you're here 10 years later talking about it. You might have, if you had done something, if someone had acted on it, if it had been a big deal, this would have been kind of seared into your brain, right?
Yeah, I suppose so.
Okay. And you're doing your best here to give us your recollection, right?
Yes.
And you guys were so young at that time, right?
Yes.
And that was at least 6-7 years before 2023.
Mm-hmm.
Long before that. Okay. Thank you, Ms. Taylor.
Any regret?
Ms. Denny, you described kind of the conversations with Mr. Taylor that this happened over at least a 2, maybe 3-day period. Is that right?
I think so. Mm-hmm.
And he was saying like, oh, this is a crazy thought. This conversation continued over those couple of days. Isn't that right?
Yes.
And is it correct to say that you were trying to talk him out of it?
Yes.
He was very adamant of trying to find something to do it.
Yes.
Absolutely.
She's answered that. Any other questions?
No.
Okay. Thank you. We can step down and be excused. Who's next witness?
The next witness is Bridget Burks.
All right. So next up, I want to watch Dr. Alex Krotulski. So we had the medical examiner, then we had the forensic toxicologist. But I want to get to the forensic toxicologist first. Then we can go back to the ME. I want to get to this. Here, hold on. Let me pull this up. Let me do this. I want to listen to the forensic toxicologist because I think he talks about, he was the one where I was kind of running around and I didn't really hear all of his testimony. And he talks about, same with the ME, but he talks about how long it takes to get into your system. And we did some independent research and we found it was 10 to 30 minutes, which would put to bed Nigea and Keontae doing this because they left by 8. Jade was fine until 9:10, 9:15, and then if they put anything in her drink, she would have drunk it well before then. All right, so let me get to this. I liked his testimony too. I want to hear his testimony again. All right.
Dr. Krotulski, could you please state and spell your name for the record, please?
Yes, my name is Alex, A-L-E-X, Krotulski, K-R-O-T-U-L-S-K-I.
And what is your profession?
I am a forensic toxicologist.
How long have you been a forensic toxicologist?
And this comes by request from Horse Welfare. So we'll give this one to Horse Welfare. Thank you for the gift, Horse Welfare. This one comes by request of horse welfare.
Toxicologist.
I've been a forensic toxicologist for about 11 years, and I've worked at the laboratory where I work now for all of those 11 years.
Okay, where do you work?
I work at a nonprofit forensic laboratory called the Center for Forensic Science Research and Education.
And what connection does that have to NMS Labs?
Yeah, so we are a nonprofit forensic laboratory. NMS Labs is a for-profit forensic laboratory. The two of our forensic labs are actually in the same building. NMS is in the front half of the building. We're in the back half of the building. We do have some connections through the family and through the forensic toxicologists that founded NMS Labs, but we are two unique laboratories and two unique organizations.
And what is your title with CFSRE?
My current title is Director of Forensic Toxicology and Chemistry.
Okay, how long have you held that title?
I held that title as director for about 3 years, and prior to that had a title of Associate Director for also about 3 years.
And can you describe your job to the jury at CFSRE, please?
Yes. So I am a manager and a supervisor. I oversee a team of about 10 people, including 5 full-time forensic toxicologists. So as a research and educational facility, I do perform research in forensic toxicology and forensic science. I also teach and educate as part of our graduate programs that we have with universities in Pennsylvania. And then pertinent to this case, we also run forensic cases. So we bring in under chain of custody forensic evidence, process that through the tests and the methods that we have in our laboratory, and report out those results through forensic reports.
And what type of education do you have? Can you tell us a little bit about your background?
Yes. So my latest degree is a Doctor of Philosophy in Chemistry, in which I did my dissertation related to forensic toxicology. I also have a master's degree in forensic science. I also have a bachelor's degree in chemistry as well.
I passed those. What is that?
So the document you just passed me is my CV, or my curriculum vitae.
Okay. Are you required to have ongoing training?
Yes, as part of really the field of forensic science as a whole, forensic scientists continue their professional education, whether that be through courses that we take, through conferences that we attend every year, or through a variety of other means like reading journal articles and whatnot.
And have you ever testified as an expert in toxicology?
I have, yes.
Okay, about how many times?
Once before.
Your Honor, at this time, I can make Dr. Kurtulski's CD, the State's Sex Exhibit 33.
Okay.
And tender him as an expert in toxicology.
No objection.
Okay. All right, again, ladies and gentlemen, Dr. Kurtulski will be allowed to give his opinion as an expert in that field and place such weight as you choose to apply. Okay.
Dr. Kurtulski, did you get involved in a case involving a patient, Jade Benning?
Yes.
Okay. Do you recall about when you became involved with Jade Benning's cases?
Yes, that was in March of 2023.
Okay, and how did you become involved?
At that time, our laboratory takes in cases generally for different unique scenarios. We do testing for a variety of different drugs and toxins in the field of forensic toxicology. So generally, the way we get involved in cases is that there are biological specimens, whether that be blood, urine, whatever it may be, that need advanced toxicology testing. So with our relationship with NMS Labs had contacted us about samples that they had that they were interested in getting additional testing performed on, and that's how our laboratory got involved.
Okay, did you also talk to Vanderbilt doctors?
Yes, I talked to Dr. Brucolaria as well at Vanderbilt.
Okay, and did you issue a few reports in regards to Ms. Benning's urine?
Yes.
Okay. All right, so I can pass. Dr. Kurtulski, what did I just hand you?
You handed me 2 different reports. One report for a urine sample that we tested, and one report for a blood sample that we tested.
Oh, I'm sorry.
The case number for the urine is 2023-0092. The case for the blood is 2023-00989. Sorry.
And these are pretty thick. Can you explain to the jury what is with the report?
Yes. So this second report that I was handed is for a second urine specimen that we tested, 2023-0090. These are the reports. The first 2 pages, or 1 page, is the report that we issue after our testing. That report consolidates all the information about who submitted the sample to us, what samples we received, what our results were, what testing we performed, as well as some reference comments as to the substances we identified. And then the rest of the page is the rest of the packet for the case. There are a few pages that include the chain of custody, as well as the sample preparation documents that we use to prepare the samples in the laboratory for analysis. And then the bulk rest of the pages are the data associated with the identifications for the drugs that we made.
And are both those samples involving Miss Jade Benning, or both those reports?
Yes.
Okay. And do you commonly refer to them as litigation packets?
Yes, yes.
Okay. Your Honor, at this time, I would like to mark those 2 reports as the State's next exhibit 34 and 35, please.
No objection.
Okay. Which you want to delineate?
34, Your Honor, that could be 0092, and 35 be 0090. They're
Different
the
day.
report numbers. No, sir.
Okay.
Your Honor, if I could publish it for the witness, we have it on a PowerPoint.
Okay.
Dr. Krotulski, can you walk the jury through this first page and what we're looking at and what kind of identifying information is on this page?
Yes. At the top, you can see that this is the toxicology report that we issued. That's the logo for our laboratory, as well as the date that we issued it. So it was issued in July 18th, 2023. This report was issued to Dr. Rebecca Bruccolari at Vanderbilt University Medical Center. On the top right there are the different case numbers associated with the case. So every agency is going to assign generally their own case number to a case. So our laboratory assigned our case number, the CFSRE case number, but then there were additional case numbers, including the NMS case number, as well as the agency's case number that we include as well. Next down under items received is the item that we received for that case number. In this case, under the description, you can see that it was 1 vial containing urine. The next section is the results and conclusions. So these are the substances that we've identified. In this case, the analytes, benzoylecgonine, norcocaine, and cocaine. Under concentration, our laboratory does at times perform quantitative testing.
All right, so we're going to walk through this. So he tested, they found the parent and the let's just walk through this.
Would be valued the analyte under the description, as well as the agency's case number that we include as well. Next down under items received is the item that we received for that case number. In this case, under the description, you can see that it was 1 vial containing urine. The next section is the results and conclusions. So these are the substances that we've identified. In this case, the analytes, benzoylecgonine, norcocaine, and cocaine.
So benzoylecgonine and noricola and cola, which would be the parent. So this is what they found in her urine. This is what, again, I guess it's we're not debating whether she had cola in her system, but I want to hear his breakdown again.
Under concentration, our laboratory does at times perform quantitative testing, so there would be values for the quantitative analysis there. However, this testing that we perform was just qualitative, so it just says positive, meaning that the substance was identified and was positively present in the sample. Under methods of analysis is the instrumentation that we use for testing. Under reference comments are generally short blurbs about the substances that we've identified. So if anyone's reading the report and they see the term benzoylecgonine and they don't know what that is, they can correlate that under reference comments. And I'm so sorry, I did not mean to. Next is laboratory comments. That just says that we took the sample into our possession under chain of custody, seals and everything were in order, and also notes that when we discard the specimens. And then finally at the bottom is again the case number, the date that we're signing this, my signature, as well as another toxicologist signature at our laboratory.
And Dr. Kutulski, you've already talked about how you were in communications with Vanderbilt. From your knowledge, when was this first sample taken?
In my communications with Dr. Brucolari, it's my understanding that this was the first urine specimen collected when the individual presented to the hospital.
Okay. And if medical records have previously been introduced and that first urine was at 2259 on 2/25/2023, would that be correct?
Yes, that's consistent with my understanding.
Okay. Can you walk the jury through your findings for this first urine of Ms. Benning?
Yes. I will go in reverse order because it will make, I think, a little bit more sense. The bottom substance there is cocaine. Cocaine is a stimulant drug. We identified parent cocaine within this urine sample, as well as norcocaine and benzoylecgonine. Those two are metabolites of cocaine.
Okay. And did this specific test for E&E?
No, our testing does not include ecgonine methyl ester, which is another metabolite of cocaine.
And can you walk the jury through how many drugs and what kind of testing this specific urine was tested against?
Yes, I don't recall the exact number. Our laboratory is constantly adding drugs to our method of detection. Currently, we test for more than 1,300 substances. This time in 2023, our scope was probably around 1,100 substances. And if the substance is not listed on this report, it means it was not identified through the testing process.
Okay, so we can say out of at least 1,100 drugs, the only one that was tested positive was cocaine.
And it's metabolites, correct.
Yes. Okay.
All right, so they tested for 1,100 substances, and the only one that tested positive was for cola. All right, so these are facts. These are facts that I'm putting into the list. These are facts. I'm not gonna add all of that. I'm just gonna say this all leads us back to she had cola in her system. Nothing else. No fentanyl. Nothing else was in her system from the urine sample collected at 10:59. So basically 11 o'clock on February 25th.
And what, if any, what is your threshold for cocaine and the metabolites for a urine sample?
Yeah, our cocaine threshold is about 20 nanograms per milliliter. Sorry, I don't believe I said that correctly. Our threshold for cocaine in urine is about 20 nanograms per milliliter. That would be the same for its metabolite norcocaine. However, benzoylecgonine has some different chemical properties, and our testing limit for that is about 100 nanograms per milliliter.
And from your discussions with Dr. Brucolari, what were you advised that Vanderbilt's threshold was?
Yeah, so it's my understanding that in the hospital, as many hospitals do, they perform a urine drug screen. That's done by a different type of test than we perform. That's done by something called immunoassay, whereas our testing is performed by mass spectrometry. Through my conversations with Dr. Brucolari, it was my understanding that the cutoff for benzoylecgonine in the hospital was 300 nanograms per milliliter. And again, our cutoff was 100 nanograms per milliliter.
So is it consistent that if Ms. Benning's blood or urine tested in the hospital negative, but then was positive with you, is that consistent with just the different thresholds and Vanderbilt being much higher?
Yeah, so when you have differences in thresholds, you can have concentrations that are between those thresholds. So one laboratory may report it negative because it's below their threshold, and another laboratory may report it positive because it's above their threshold. Both of our tests were not quantitative, though, so we don't know exactly how much benzoylecgonine was in this sample. However, based on the data that we have from our test, we can see, based on some of the characteristics of the data that we look at, that it's my opinion that it looks like the amount of benzoylecgonine likely was between our two thresholds, and that's why our result was positive and their result was negative.
And before I move on, can you walk the jury through what typical effects of cocaine are and then what the severe effects of cocaine are?
Sure. So cocaine is a stimulant drug, so it does a lot of things to stimulate your body. Certainly people use cocaine for its euphoria and its high feeling, but when you get to some of the sort of clinical signs and symptoms, it can do things like increase your heart rate, increase your blood pressure, increase your temperature. It can make people more talkative, more movement. It can, in higher amounts, or for some people, it can cause sort of agitation and anxiety. And in more severe cases, especially with the effects on the heart, you can have sort of detrimental cardiac effects because of that increased cardiac output. Cocaine has been associated with seizures as well as other more bad side effects, if you will, of cocaine at either chronic use or at higher amounts.
And can you tell the jury what the common forms of someone taking cocaine would be?
Yeah, so in the United States, cocaine is primarily found in two forms, cocaine salt and cocaine base. So the basic form of cocaine is known as crack or crack rocks. Crack rocks are generally smoked. The salt form of cocaine, or known as coke, is a powdered form that people typically snort.
Okay. Is oral ingestion of cocaine common?
No, from my experience, oral ingestion of cocaine is not common.
And for symptoms and side effects, how would oral ingestion of cocaine differ from IV, snorting, something like that?
Yeah, so the manner in which drugs enter the body is really going to be dependent on potentially how quickly those drugs affect an individual and how quickly those drugs can get to the brain. So something like snorting or smoking is going to have a much quicker onset of actions, whereas if you ingest something orally and it goes to the stomach, you have to get it then absorbed into your body. Some of that drug could break down in your stomach acid. So there's different effects and how quickly the substances can affect an individual based on the route of administration. But then also there's other things that can be important about how the drug is metabolized or how it's breaking down throughout the body based on the route of administration as well.
And in preparation for this trial, did you research to see if you could find any sort of studies on oral ingestion of a liquid cocaine?
Yes, I did.
Okay, were you able to find any studies for liquid cocaine?
I did not. There are a few studies that have looked at oral cocaine administration, but typically they're through capsules or tablets, in large part because that's how a lot of substances are taken orally, as capsules or tablets. I could not find any studies looking at liquid cocaine oral administration to humans.
Okay. And I want to talk to you about your research that you found for capsules. Can you walk the jury through how quickly symptoms appeared in your research?
So in those studies, they looked at sort of the symptomology of individuals, but then also the peak plasma levels. So plasma is sort of a form of blood in terms of the way that drugs are in the body. They collect blood and then can convert it to plasma. So they found, one of the studies found that the peak plasma concentrations were between 50 and 90 minutes. And that just means that the cocaine has gotten into the bloodstream, it's circulating around the body, and as they test serial amounts of, serial meaning replicate amounts of blood over time, that in 50 and 90 minutes it was the highest amount of cocaine, and then it started falling down.
Okay, and is it in your opinion that liquid cocaine would work quicker than capsules?
Yes, when you have a capsule has to get into your stomach, the capsule has to be broken apart, in order for those substances to then be absorbed into the body. A liquid form of the drug, generally compared to a capsule or a tablet, that liquid is already ready to be absorbed, so that process can be a bit quicker.
Okay, so...
All right, so the studies that he found were for capsules. This was ingested orally. So the studies that he found, it took 50 to 90 minutes for peak plasma levels. Now that's for capsules. All right, so that's for capsules. Liquid would take faster. As we found, liquid took like 10 to 20 minutes or something like that. I think that's what we found. Actually, Horse Welfare found that. Wait, hold on. I have that here. Horse Welfare found oral or gum use 10 to 30 minutes. So he's saying a capsule, which of course the capsule has to break down first and then has to circulate. Whereas if you're just taking a liquid, of course it's going to be a lot faster than a capsule.
If we have Miss Benning, who at 9:10 is painting words on a canvas, 9:25, a photo of a new word that she has painted on a canvas, and then we have a lieu of about 4 minutes of taking photos, and then 9:29, so about 19 minutes from that 9:10 to that 9:29, there's a phone call, and it's 6 minutes long. At the beginning of the phone call, you can understand Miss Benning for the most part, and by the end of it, you cannot understand her. During that phone call, she's saying things like, I can't feel my legs, and then by 9:50, when EMS finds her, she's pulseless. From that 9:10 to that 9:50, is it consistent with a 30-minute window of Miss Benning ingesting that cocaine and then feeling those side effects and becoming pulseless?
Yes, as I mentioned, you can get peak cocaine concentrations orally in about 50 to 90 minutes. So the effects certainly are presenting sooner than that. So that is consistent with that time frame and that the results or the data that's in the scientific literature.
Yes, and you're saying it would be less than that time with the capsules, that 30-minute time frame for us is consistent because it was not capsules.
Yes, generally the drug does not have to be absorbed or taken out of a capsule or a tablet. That time frame can be shorter.
And going back to the test result, is fentanyl one of the 1,100 drugs at minimum that you tested this urine for?
Yes.
And was fentanyl present?
No, fentanyl was not detected in this urine sample.
Okay, what about cocoethylene?
So again, fentanyl was not tested. Fentanyl was not found. Sorry. Let me replay that.
Yes.
Because it was not capsules.
Yes, generally the drug does not have to be absorbed or taken out of a capsule or a tablet. That time frame can be shorter.
And going back to the test result, is fentanyl one of the 1,100 drugs at minimum that you tested this urine for?
Yes.
And was fentanyl present?
No, fentanyl was not detected in this urine sample.
Okay, what about cocoethylene?
All right, fentanyl was not detected. Fentanyl was not detected in that urine test. So this is when she came in at, this was 11 o'clock at night. She came in around 10, right? She came in around 10:06, something like that. She was picked up around 10 to 9:50. And she made it over there around 10. So by 11 o'clock, so within an hour, they took urine. There was no fentanyl detected.
Yeah, so cocoethylene was also and is also in the scope of our testing, and it was not detected in this specimen.
Okay.
No cocoethylene was detected either. All right. So no fentanyl or cocoethylene. So no fentanyl, no cocoethylene.
And so I just want to be very clear for the jury, cocaine and only cocaine metabolites tested positive for this 2/25/2023 at 22:59 urine.
Correct.
And Vanderbilt's threshold was 300 and was only testing for the benzo, is that correct?
So the way that immunoassays work, they have a target substance, and generally in urine immunoassays, that target substance for cocaine is benzoylecamine. Some of the other metabolites will have cross-reactivity, so their amounts could sort of combined in total potentially reach that threshold. But in this case, with the result being undetected, those combined amounts of the substances still did not reach the threshold for them to produce a positive result.
Your Honor, if I could have the witness pass exhibit number 32, please. Dr. Krutulski, you are being handed State's Exhibit number 32, which is Ms. Benning's autopsy report. Are you familiar with any sort of addition that for cocaine, the parent cocaine and the EME being added, and what that can give you as an estimate?
Yes, I am familiar with that practice. Again, active methyl ester, or EME, is also a metabolite of cocaine. So there's a practice in which you can, or where folks will add the parent and the metabolite together to get an estimation of potentially how much of the parent drug could have been present if it hadn't broken down to that metabolite in this case.
And if you could, Dr. Krutulski, get to that lab result in the autopsy report, please. And could you tell the jury what the EME and the cocaine was, and then how we would get to that number of the estimated concentration of cocaine in Ms. Benning's blood that night?
Yes, this is the NMS Labs toxicology lab report that reports cocaine at 78 nanograms per milliliter and the active methyl ester at 7,800 nanograms per milliliter.
Okay, and what would that bring us to if we were doing that addition?
So if you were to do that addition of the two, it would be about 8,000 nanograms per milliliter.
Okay, and is 8,000 nanograms per milliliter a high concentration of cocaine?
Yes, if there was 8,000 nanograms per milliliter of cocaine in someone's system, that would definitely be considered, in my opinion, a high amount of cocaine.
What is typical that you see? Do you see anywhere near 8,000 nanograms per milliliter on a daily basis?
So we do quantify cocaine in blood samples, not as routinely as NMS does. I do not recall what the highest amount of cocaine we've seen in a blood sample is, but I would think that we have seen concentrations of cocaine in the thousands. I just don't know exactly what those concentrations are.
Dr. Krutulski, what are we looking at now?
On the screen now is the second report.
Okay. And from your discussions with Vanderbilt, do you know if Ms. Benning, if this report was after Ms. Benning had been treated in Vanderbilt?
Yes, it's my understanding, and talking with the individuals at Vanderbilt, that the first urine sample was collected prior to the individual being given drugs in the hospital, and the second sample was collected after those drugs had been administered in the hospital, which is consistent with the results that we found.
Okay, and can you walk the jury through what medications, if you want to touch your screen, would Ms. Benning have received in the hospital, and how you know they're medical grade medications?
Sure. So from our perspective, when we test for drugs, a drug molecule that we see, you don't necessarily know if it's medical grade or not. As that's oftentimes why we'll consult with the individuals at the hospital to understand what substances the hospital is administering, but also through sort of my experience in dealing with these cases, many hospitals administer the same drug, so it's something that we can kind of see reproducibly. So one of the first substances, acetaminophen, that was really bad. Acetaminophen is a drug that can be administered in the hospital. Acetaminophen is Tylenol. Levetiracetam, which is an anticonvulsant, also known as Keppra, can be administered in the hospital.
And Dr. Krutulski, I'm going to stop you right there. Are seizures a side effect of ingesting cocaine?
Yes, as I previously mentioned, seizures can be associated with cocaine toxicity.
Thank you.
Next on the list is lorazepam. Lorazepam is a benzodiazepine, which is also, benzodiazepines can also be administered as anticonvulsants for seizures. And then fentanyl. Fentanyl is an opioid. Many people know about fentanyl because of its illicit uses in the street drug supply. However, fentanyl is actually a common opioid analgesic used in the hospital as well.
And is it your understanding that Ms. Benning received fentanyl at Vanderbilt University Medical Center?
Yes, that's my understanding.
And that Ms. Benning had no fentanyl in her when she got to Vanderbilt Medical Center?
So based on the testing that we performed, there was no fentanyl in the first urine sample that we tested.
I want to draw your attention to levamisole. Can you talk to the jury about what you know about levamisole and its importance to cocaine?
Yes, levamisole is, while it has uses in animal medicine, it's something that we call an adulterant. So a lot of times drugs within the street level drug supply will be adulterated and things will be added to them, a lot of times to sometimes help with side effects, but sometimes make the high that those drugs produce better. So in this case, or levamisole but in this scenario, levamisole is a substance that we see as an adulterant alongside cocaine in the street drug supply.
And is levamisole a common cutting agent of cocaine?
Yes, levamisole is as well as lidocaine are common cutting agents for cocaine.
Okay, and what would be the explanation of why Ms. Benning's first urine, when she initially got to Vanderbilt, did not have levamisole in it?
Yeah, so I reviewed the results for the 2 urine samples, and as I mentioned previously, during our testing, aspects of the data can show us, while we don't quantify the amount of cocaine, how high or low that level is. The amount of cocaine that we detected in the second urine sample is much higher, as well as some of the other substances as well. So it is possible that because the amount of cocaine was lower in the first urine sample, the cocaine or the levamisole may not have accumulated or been excreted in the urine sample yet. So levamisole may have been there but below our detection limits, whereas in this later sample, as more cocaine is being excreted from the body and put into the urine, it's rising above and potentially then is above our threshold, and we're able to detect it in this sample.
And is that common to initially get a low threshold cocaine and then later on get levamisole?
Yes, the way that drugs are excreted into the urine, when you first take a drug, there will be no drug in the urine. So you'll start out at 0. As the drug is metabolized, then the parent drug as well is excreted into the urine. Those concentrations increase, and eventually as the bladder is emptied and the drug is sort of cleared from the body and there's no more drug to excrete into the urine, those concentrations then will go back down. So that is consistent with sort of that trajectory.
And do you know how low the levamisole was in this urine?
I do not recall, but I know that it was significantly smaller than the cocaine.
Let's talk about cocoethylene. What can you tell the jury about cocoethylene?
So cocoethylene is an interesting substance in that it forms in the co-ingestion of cocaine and ethanol.
Okay. Was cocoethylene present in Ms. Benning's first blood or first urine?
No, it was not present, but similar to the explanation I gave for levamisole, it could be that it was present but below our detection limits, therefore we weren't able to see it because maybe it hadn't been excreted fully yet.
And do you know how low this sample of cocoethylene is in Ms. Benning's urine?
Yeah, so I did take a look at that, and again, comparing those responses that we get from the instrument, the amount of cocoethylene that we detected was about 1% of the amount of cocaine. So again, quite a small amount of cocoethylene compared to the amount of cocaine that we saw in this urine sample.
And this.
All right, so first of all, he says it wasn't present, but it could be at a lower level, but it also could have taken time to show up. And then it was 1% of the level. So hold on a sec. Let me rewind that.
1% of
cocaine.
Benning's urine.
Yeah, so I did take a look at that, and again, comparing those responses that we get from the instrument, the amount of cocoethylene that we detected was about 1% of the amount of cocaine. So again, quite a small amount of cocoethylene compared to the amount of cocaine that we saw in this urine sample.
And this one.
So they did find it. Now they're saying they did find it? Am I hearing this right?
1%.
Can you dissolve cocaine and alcohol?
Responses that we for levamisole, it could be that it was present but below our detection limits, therefore we weren't able to see it because maybe it hadn't been excreted fully yet.
And do you know how low this sample of cocoethylene is in Ms. Benning's urine?
Yeah, so I did take a look at that, and again, comparing those responses that we get from the instrument, the amount of coke-ethylene that we detected was about 1% of the amount of cocaine. So again, quite a small amount of coke-ethylene compared to the amount of cocaine that we saw in this urine sample.
And this 1% of cocoethylene, would that be consistent with Ms. Benning drinking alcohol and then taking a bump of cocaine?
So from my experience in those scenarios, you wouldn't have that small amount of coke-ethylene, although it does depend on sort of the timing of when the urine sample was collected. But generally, when we see coke-ethylene with people who are co-using larger amounts of alcohol, we do see it at more appreciable amounts than the small amount that we saw in this sample.
Can you dissolve cocaine in alcohol to make it a liquid cocaine?
Yes, cocaine, like many drugs, are dissolvable in what we call solvents, and ethanol would be an example of a solvent.
Dr. Krotolski, was cocoethylene present in any other samples for Ms. Benning that you tested?
No, it was not. Coke-ethylene was only detected in this specimen.
Right. And we talked about the hypothetical about Ms. Benning's timeline. Would you expect to see more cocoethylene if Ms. Benning had been drinking alcohol?
So in cases where we do collect urine samples from people who have been drinking alcohol and using cocaine, I would say typically those amounts of coke-ethylene are larger. But again, there's a variety of different reasons as to how the level of coke-ethylene could be in this case, including the dose of the substances, not only the cocaine and the ethanol, but also the time associated with it.
Okay, and for that first urine to only have cocaine, benzo, and then the other metabolite, but no coke-ethylene. If she had been drinking heavily and doing cocaine, would you expect to see that cocoethylene reporting above the threshold?
Yes, if she was drinking and taking cocaine together, I would have expected to see the coke-ethylene in that first urine sample.
And is it your understanding that through all the other testing of Ms. Benning at Vanderbilt, that there was no alcohol present in her system?
Yes, it's my understanding, and through talking with the toxicologist at NMS Labs and Dr. Brucaleri at Vanderbilt, that the ethanol testing that had been performed by the other laboratories was negative.
And Dr. Krotolski, is there any other explanation other than just drinking alcohol, it being dissolved in alcohol, that you could get that cocoethylene?
Yes, there are other ways that small amounts of ethanol can get into your system. Some other drugs that are used may have ethanol as a minor component in them. There are some things that may be used in foods that could have small amounts of ethanol in them. So there are other ways that ethanol can get into your system other than drinking beer or other forms of drinking alcohol.
And is that consistent with how low Ms. Benning's cocoethylene percent is at, and then we don't see it again?
Yes, I would say that would be more consistent.
Right, and could it be used in cooking for like homemade cookies with vanilla extract or something like that? Could that low reporting level of cocoethylene be consistent with Ms. Benning have cooked that night?
Yes, I'd say that could be consistent.
Governor, give me one moment.
Those are all my questions.
I'm Letitia Quinones-Hollins, and I just have a few questions for you. I first want to ask you about your forensic toxicology certifications. Did you have to go to school to become a forensic toxicologist?
So forensic toxicologist is a job, just like an electrician would be a job, or just like a chemist would be a job. So generally, there's a variety of different programs that train individuals to become forensic toxicologists. There's a variety of different ways you can get to being a forensic toxicologist without a degree in forensic toxicology. In the United States, there are no PhD programs in forensic toxicology, so many of us who have our PhDs and work in forensic toxicology get our degrees in areas like chemistry, pharmacology, sort of general toxicology, one of those other fields.
So have you had training in toxicology?
You know, another thing I'm thinking, if she was drinking, Blaise would have told law enforcement, and he would have known. Like, all Blaise said was that he thinks it was an allergic reaction. He never once said, "Oh, she was drinking." He never once said, "I think she was doing, it could have been drugs. I think I saw her put something in her drink. I think I saw her." You know when somebody's drinking alcohol, right? That's why I'm like, I don't think she was drinking. I don't think she was drinking alcohol, because he would have said that. That would have been like one of the first things I would have thought he would have said. He would have been like, "Yeah, she was drinking. I don't know. Maybe something was in the alcohol." Because he only said, the only thing he said was that he thinks she had an allergic reaction, and then I heard something on the 911 call about pasta. He said something about the pasta. So if she had been drinking, Blaise would have known that. I mean, they were kissing. You're going to taste it. You're going to smell it. They were like being up in each other's face. She would probably been slurring her words if they had been drinking. If Nigea probably would have said something too. Yeah, I think she may have had, or maybe Nigea wouldn't, because she's trying to protect her with Ivy. But I would think Blaise would have been like, yeah, she was drinking. Even if she only had one drink, you're still going to know. And I think he would have said that. So anyway.
Yes, I have a master's degree in which I spent 2 years learning about forensic toxicology. I've done a variety of different research work related to forensic toxicology. I also have on-site training. So in addition to the time I've spent at the CFSRA, I actually did also work at NMS Labs for a short period of time and received training as part of that at NMS Labs. So I have received training both through on-the-job training as well as educational training to be a forensic toxicologist.
And in order to be classified and certified as a forensic toxicology, it took many hours and a lot of time dealing with toxicology to be able to be qualified as a forensic toxicologist. Would you agree?
I guess I would. It certainly has been a lot of time and education that I've gone through. The field of forensic toxicology is made up really of three separate fields: analytical chemistry, forensic science, and toxicology itself. So it's learning about all those different aspects and pulling all that together to become forensic toxicology.
Thank you. Now, I want to draw your attention to, I believe that the first testing from the 2259 urine, where it's labeled 20230092 from the CFSRA.
Yes.
And I see there that we have positive results for what they call BZE. Is that right?
Correct. Benzoylacogene is called.
Linda, yes, there is literally vodka in vodka sauce, but she wasn't making vodka sauce. She was making Alfredo sauce, which is a white sauce. Vodka sauce is more of it's a red sauce. It's vodka and tomatoes. But no, chicken Alfredo or Alfredo sauce is basically, I think, Parmesan cheese, butter, and cream, I think, right? We've looked that up before. Yeah, it's butter, Parmesan cheese, and sometimes heavy cream. So she wasn't cooking with alcohol, unless they did suggest vanilla extract in the cookies. And I know the defense was all over that. Like, are you kidding me? You know, sorry, mic wasn't on. Sorry. How much did you guys miss? Sorry, my mic wasn't on. And I know the defense was all over that. Like, are you kidding me? You know. Okay, it just went off then. So alcohol can be formed in your body that interacts with the cola coming in. I know they've made a big deal about it being connected, but it can form in your body to create that, as we've been finding out. All right, so no, she was not making vodka sauce. She was making chicken Alfredo sauce, which is butter and Parmesan cheese. Did she put wine in there? Possibly. Who knows? We don't know what she exactly put in there, but it is traditionally a white sauce and heavy cream, Parmesan cheese, and butter. So.
BZE for short.
Norcocaine,
Correct.
which is another metabolite for cocaine,
Yes.
and then of course the parent cocaine.
Yes.
Why would you say that I wouldn't see something here for like heroin?
Heroin is a substance called diacetylmorphine. It metabolizes to 6-monoacetylmorphine and morphine. Those substances are included in our scope of testing, so I would expect if they were present in the urine at our thresholds that we would be able to detect them and report them.
Okay. So
yeah, I agree with that, Camilla. They to suggest that it was in the vanilla extract, I'm like, that is pretty, that's and it cooks off, right? Alcohol cooks off. That's the whole point. You don't use alcohol for the alcohol taste. You use it, or I'm sorry, for the alcohol content. You use it for the taste. You don't cook with things that have alcohol in them for the alcohol. It cooks off. I mean, that's the whole point.
the fact that that isn't there, it means that it doesn't appear that it was in this matrix of the urine. Is that correct?
Correct.
And my point with that is that when you go now to 20230090, we see cocaethylene. Is that correct?
Correct.
And just so that we're sure, this is the urine in 20230090 of Miss Jade Benning. Is that right?
Yes, I believe that's correct.
And so we see that cocaethylene is in fact positive, right?
Yes, and we're talking about the second urine sample that was collected.
Yes, the 20230090.
Yes.
Okay. Now you said the second urine sample. When was that taken from Miss Benning?
As forensic toxicologists in our labs, we take in samples and they come with a variety of different information. In this case, the case was not given to me with the date and time collected, so that's not something that appears on our report. That's something I would refer back to the folks either at Vanderbilt or also, I believe that information is on NMS Lab's report.
Okay. You believe that it's on NMS Lab report?
I believe it's included in their report, yes.
Okay, and that's NMS Lab report 896, based on where it says, I'm sorry, 899. NMS work order number is 230-78899. Is that correct?
So I don't have the reports in front of me, and with all of the numbers, I'm having a little hard time following. Yes, if that is, I do not have that report in front of me. If that was the, yeah.
This packet of yours had that.
Sorry, yes, the packet that you have. Oh, yes, thank you. So this for this report, 2023-0090, which is our CFSRE case number, that is associated with NMS work order number 23078899.
So, as it relates to the urine where we see cocaethylene, you don't know what time it was taken. Is that right?
Correct. As part of our responsibility as a forensic toxicology lab, we bring the samples in, and it's our responsibility to report the results out. It's not our responsibility to keep track of when the samples were collected and to sort of marry up that information. It's our responsibility to do the drug testing and report the drugs that we find.
Well, is that a no, sir? You don't know what time it was taken?
Off the top of my head, no, I don't.
Okay. And so...
Is there any of your records that would tell you that?
No, so our records do not. So you would correlate back our case number with the NMS Labs case number and the agency case number and the information they had in terms of when the specimens were collected. So that's NMS Labs or Vanderbilt's information about when the samples were collected.
So you can't say it wasn't taken at 22:59 or that it was, as the information that you have before you at this time.
Again, that's not my role. Our role is forensic toxicologists.
I'm just asking.
Okay, yes.
Yes. Now, irregardless of when it was taken, this is the urine of Jade Benning, right?
From my understanding, yes. This is based on the conversations I've had with Dr. Rebecca Bruccolari at Vanderbilt.
Okay. And so in the same manner that you don't see, I think you called it levamisole, which is a cutting agent for cocaine, right?
Yes.
The same way you don't see levamisole in your initial testing of 202300092 is the same manner for which you don't see cocaethylene, right?
Yes, as I explained before, in order for us to have a positive result, there needs to be enough of the drug or the metabolite in the urine sample to meet a threshold for us to detect it. So it is possible that they were present in the urine, however, below our thresholds to detect it, so therefore we would not report them as a positive result.
Nonetheless, you have those two different metabolites that weren't present in your first results that are present in the second. Yes or no, sir?
That is correct. However, I think it's important to note that these are not replicate samples, so we don't expect to have the same results in both urine samples. These urine samples are collected at different times. We have different results because we know that there were drugs that were administered in the hospital that we don't expect in the first sample that we do expect in the second sample.
We wouldn't expect for Vanderbilt to give someone something that would cause them to test positive for cocaethylene, or would we?
So again, depending on whether or not cocaethylene was present but below our detection limits in that first sample, whether or not the cocaethylene was formed after, that's not something that I can speak to because we don't have information about that, but it could be really either of those scenarios, or potentially either of those scenarios or others.
Okay, the statement that you just made was that Vanderbilt had treated Ms. Benning, and so that's why you'll see a difference in what is present in her urine in this later sample than you would in the first sample, right?
Yes, I said that referring to the drugs that would be administered in the hospital, things like levetiracetam, fentanyl, lorazepam, those substances that are medical grade drugs.
Are they administering cocaethylene, do you believe, at Vanderbilt?
No, I would not believe they would be administering cocaethylene at Vanderbilt.
And so, if we see this in her system, then it is safe to say to this jury that she had to get it from somewhere other than the treatment she received at Vanderbilt. Wouldn't that be right?
And I apologize if I hadn't explained this well, but cocaethylene is really not a substance that's available out there. People don't go out on the street and buy cocaethylene. You can't sort of get it as a prescription drug. Cocaethylene is something that's formed in the body when someone uses cocaine and ethanol. So again, this wouldn't be something that could be administered. This wouldn't be something that is ingested. It's something that's formed through those two substances.
Exactly. That person would have had to have ethanol and cocaine in their system at the same time. Yes or no, sir?
Correct, yes.
Now, so what we do know, and the reason I gave you the hypothetical of the heroin is because the only reason that it's going to show up positive is because there was alcohol and cocaine taken at the same time for Ms. Benning, right? That's why your testing came positive. Yes or no, sir?
So I don't want to confuse the terms ethanol and alcohol. Ethanol is a small molecule. Alcohol, while we refer to drinking alcohol as alcohol, alcohol is really a class of substances. Methanol, for example, is also an alcohol, and there's other alcohols as well. So what I'm saying is that cocaine and ethanol come together to form cocaethylene. The source of that ethanol As I previously testified to, is unknown, but there are different sources as to where that ethanol could come from.
Right. You said that it could have come from the vanilla extract that she put in her cookies.
I didn't say that. I said it could come from different things that are used in cooking. Could also come from, again, ethanol could be a minor component in some medications that are used. I didn't necessarily say it came from a certain a certain place. We don't necessarily know where that ethanol may have come from.
Well, actually, the prosecutor actually asked you, could it come from the vanilla extract? And your response was, yes, it could have.
Correct. She said could, and I said yes.
And that was my question, because you just said earlier that it could have come from vanilla extract.
I apologize. I thought you were asking me if I said that it did come from the cookies.
No,
which I did not.
you said it could have. But it also...
Hypothetically.
It could have come from her having a drink and then also taking cocaine, couldn't it?
Yes, that is possible, again, depending on the amount of ethanol consumed. Ethanol can come from, as I mentioned, those other sources. It also can come from drinking alcohol as well.
Now, do you know what a screen test is, sir?
Yes, I do.
And what is that?
So in forensic toxicology, typically we do two tests. Historically, we referred to them as a screen and a confirmation. Screen is a way of saying, okay, well, I've tested this substance, usually for I tested this sample, usually for a large array of substances, and then we know what's present, and then we take that through a confirmation test, which is then usually quantitative in nature. So typically in forensic toxicology, you would do those two tests, a screening test and a confirmation.
And so, is it fair to say that you don't go, a lab would not go past a screen test to a confirmation test unless something is coming up positive in that screen? Is that correct?
Yeah, so the field of forensic toxicology has really advanced in recent years. Historically, when we thought about screening tests were usually things that were not very accurate. They may have tested for a class of drugs and you would get a positive result and you have to figure out why you got that positive result. A good example would be if you tested for benzodiazepines and got a positive result for benzodiazepines, you may have to do a confirmation to say, well, what exact benzodiazepine am I looking for? But as forensic toxicology has advanced, some have tried to get away from the term screening and confirmation because a lot of the instruments that we use now for screening tests are actually a lot more accurate and sensitive than they've previously been, but also sometimes are more accurate and sensitive than the instruments that we use for our confirmation tests. So typically, now you really have to understand what specimens were provided to the forensic toxicology lab and really understand what their methodology for testing was. It's not as easy to paint it with a broad brush to say, oh, absolutely this was a screen or absolutely this was a confirmation.
Well, you're not telling this jury, sir, that your laboratory would be using something that you can't rely on and or is not credible, are you? Are you saying that?
I'm not sure what you're referring to. No, I'm not saying that.
Okay. And so I would assume and hope that whatever immunoassay testing or whatever testing that you are performing at your laboratory would be one that is credible and reliable for you to represent to the community and your clients that trust you. Is that right?
Yes, so we do not rely on the results of other toxicology labs. We perform all of our own testing in-house. When a sample comes to us, we may have heard of testing that's been performed externally, but we perform all of our own testing in-house. And then yes, to your point about our methods being accurate and reliable, we validate our assays, we run quality controls and different checks during our testing to make sure that the results that we are reporting meet a level of high forensic.
Hold on. RA saying that I'm not seeing anything on X yet. Hold on. Not seeing anything. Not kidding, you got a notification. All right. Well, we're here. I mean, we're right here. So don't worry. We're not going to miss anything. We're right here. Not seeing anything. Not seeing anything on. I know. All right. Hold on, guys. We're right here. Don't worry. Kathy's not saying anything yet. Nothing is posted. So we're right here. Don't worry. If anything, we can pause it at like 1:25 or something. I'm not sure how Scott knows. Where's Scott getting his info? You got a notification from Scott. All right. I'm not sure where he's getting his info from yet. I'm not seeing it from Kathy Russin yet. I want to see confirmation. It's not that I don't trust Scott, or it's not that I don't believe Scott. Where's he getting his info from? Where's he getting his info from? I am not seeing it on, unless he's getting it from another channel. Hold on, let me check. We're right here, so don't worry. Let me see if maybe he's getting it from here. Did they say it over here? All right. Nobody's saying it other someone in court. Yeah, unless he's got a court watcher, because Kathy Russin is not saying anything. Kathy Russin is not saying anything. And the other two channels, those that shall not be named, they're not saying anything either. Yeah, nobody's saying it. Scott turns off his stream for lunch. He's only starting the afternoon stream. He's got a person in the courtroom. Okay. All right. Well, then he's got some intel that Miss Russin does not have. They're saying Scott's saying there's a verdict. I'm not seeing anything on anywhere else. You don't think it's a verdict? He just started his verdict watch. All right. Yeah, I'm gonna have to say I don't see any confirmation of that yet, you guys. I don't see any confirmation. Scott's message was something else. False alarm. All right. No verdict. All right. Yeah, I'm gonna go with Kathy Russin. That's who I always go with. Unless we have like Selena Kay or somebody or Newton Ward in the unless we have somebody in the courtroom. I'm going to go with Kathy Russin, and she has not said anything. So, all right, false alarm. It was him just starting his stream. All right. Glad I didn't stop the clock. False alarm. It happens. All right. Still has timer going. Only started afternoon stream. Okay. All right. Okay. All right, let's all calm down. let's all take a breath. Yeah. The other two big channels, they're not saying anything. So I am going to rely on Kathy Russin. So until she says something, we're going to go back. All right. He just started his verdict watch stream. Okay. All right. Derry, yeah, he just announced he's starting his verdict watch. Okay. All right. Let's all take a breath. All right, let's go back to Dr. Kratulski. Dr. Kratulski on cross.
Reliability.
And so your assay, the ones that you rely on and the ones that you deem credible, tested positive for this cocaethylene, right?
Correct. The second urine specimen.
Now, in regards to the NMS lab, you see, if I can draw your attention to the 889, and we just talked about that you don't move on to a confirmation test unless there was something that was positive in the screening test, correct?
Again, to
yes
try.
Or no, sir?
Well, so I think that you're trying to use the terms screening and confirmation for the test that we performed. Our laboratory really does not define them as a screen and a confirmation. The test that we perform, we define as a drug identification. So we did not perform 2 tests. We performed a single test, a drug identification of these substances. I would not characterize it as a screen or a confirmation.
I wasn't speaking about your test. I asked you to look at 889 of NMS.
Oh, I'm sorry. I apologize. When you use the 4 numbers, I thought you were referring to my report. Yes, and I do not have a copy of NMS Labs report.
Okay, can I?
It's in the autopsy report, Dr.
Oh, I apologize. I do have that in front of me.
Yes. You see there that NMS moved on to a confirmation test for cocaethylene. Do you see that?
Can I just ask a clarifying question? So I'm looking at an NMS Labs toxicology report that has a work order number that ends in 6889.
Correct.
Is that correct? Okay.
Yes, sir. And do you see a confirmation test performed for cocaethylene?
So this is really getting slightly outside of the testing that we performed, again, because this is the testing that another laboratory performed. NMS Labs lists the tests that they performed, and they list that they included a cocaine and byproducts panel. So from looking at the report, it does appear that they would have looked for cocaine in those byproducts, but again, I cannot testify today to exactly what NMS Labs did. I don't have their data and their results in front of me. My testimony is really about the testing that occurred at the CFSRE.
I'm not asking you about the data that they utilized. I'm asking you, with your expertise, as you being a forensic toxicologist expert, is to only share with me about looking at this toxicology report. And so that I'm clear, you're an expert in the field of toxicology.
I'm going to ask an answer. He's already testified that
You know what that lab means by screen test?
So again, I'm happy to sit here and look through the report. Certainly they will lay out what testing that they used and what testing was performed. But again, this was not within the scope of what I prepared for this testimony. I'm happy to take a look at it.
Would you do that for me, please? Just to see whether or not there was a confirmation test performed for cocaethylene. Would you please do that?
Again, based on the report says testing was performed for cocaine and byproducts panel. And if you look then to 2 pages later where they describe what's in the cocaine and byproducts panel, it does list cocaethylene as an analyte within the scope of that testing, yes.
Thank you. And that's for the scope of testing on a confirmation, correct?
I believe NMS would characterize this test as a confirmation test, yes.
Okay, thank you. Now, let's talk a little bit about the CFSRE lab. Do you see that?
Yes, by laboratory, yes.
And the number in regards to
0092 or 0090?
0090 for the cocaethylene that's present there, correct?
Yes.
Okay. So, when the testing was performed for this particular urine, do you know whether or not the levels for any of those metabolites, do you have those levels?
No, so for our testing, our laboratory, while we obviously test for cocaine and these substances, in this case, when we received the specimen, we received our qualitative results and issued those results back. We were not asked to perform a quantitative test. We typically wouldn't just do that on our own. And there was no request for us to perform a quantitative test. So in this case, we did just perform a qualitative identification of cocaine and the metabolites.
Okay, so you didn't perform a test to give us levels, is that right?
That is correct.
Okay, so you can't tell us what level that cocaethylene is, can you?
So with exact certainty, the exact concentration of that cocaethylene, no, I cannot tell you what the concentration is. However, As I mentioned previously, and is present in our data packet, there are pieces of the data, what we call peak area. So as every analyte is detected by the instrument, it generates a response. And that response is proportional to the amount of drug that is present. So a higher response means more drug, a lower response means less drug. So we can use that response to see whether or not it's a high or low amount of cocaine. So I cannot say that there's exactly, say, 120 nanograms per mil of cocaine. However, I can see what the response looks like based on what comes from our testing.
So is that a no? You can't give us a level?
I cannot give an exact quantitative level for the cocaine feeling.
Now, let's talk about what you were speaking with the prosecutor about in regards to, I think you said 8,000 nanograms per milliliters, is that right?
Approximately, adding those two numbers together, yes.
Okay. Now, is that the way that you would have calculated how much of that metabolite or cocaine, parent cocaine, was in that person's body or in that matrix?
Okay, so our laboratory actually does not quantify, does not test for EME, as I mentioned previously. So this is not a practice that I would do on our cases because we don't have that data. I was asked whether I'm familiar with that practice, and I am familiar with that practice, but that's not something that I personally do.
That's not what you would do. Is that what you're saying?
Well, I was not. So as a forensic toxicologist, in addition to the testing that we do, oftentimes we're asked to render an expert opinion. And as you sit and prepare for that expert opinion, that's something to consider as part of that process. I was not asked to do that as part of this case. So I would have to, and every case is different. You can't say that necessarily you're going to, because the drugs you find in every case are different. You have to take cases and evaluate them on a case-by-case basis. So it's really hard for me to sit here and speculate what I would have done because I wasn't asked to do it.
Okay, well, you're a forensic toxicologist, correct?
Correct.
You are the director of a toxicology lab, are you not?
Yes.
You've had significant training in forensic toxicology.
Yes.
So I'm asking you, as an expert, if you were trying, giving you a hypothetical, you're given a case, and you're trying to determine how much parent cocaine is in a matrix, in this instance, someone's blood, would you utilize the method of combining the parent cocaine and EME?
So I think I would consider that, again, because that is a process that's out there. I certainly would not use that definitively. I would understand that that's a way of looking at kind of a generality, but definitely not anything definitive.
Exactly, because with all of your expertise and training, that is not a method you would use.
Yes, as I've stated.
Now let's hypothetically utilize that method and come up with a number of 8,000 as apparent cocaine in someone's blood, okay? The pharmacokinetics that you would utilize to try to determine how much cocaine that person took at a certain time, how much cocaine would that equate to, sir, if we were to go back 24 hours?
Yeah, there's not really a way to correlate the amount of drug in this case to the amount that an individual would take. It's not, you can't say just because there's 8,000 nanograms per mil of cocaine there's not, or there was X amount of dose that the person ingested originally. That's not something that we would do in forensic toxicology to try to back calculate a dose.
So then are you telling this jury that you cannot so first you said that's not a method you would use, and so you're now saying that there would be no way to try to ascertain how much cocaine that person originally took. Is that what you're saying?
Yeah, through the training that we have as forensic toxicologists, we generally do not train individuals on how you would calculate a dose of a drug that someone used. Certainly through someone's expert opinion and training, they may try to do that, but that's not something that we typically do in forensic toxicology, to try to calculate a dose.
So what is pharmacokinetics?
So pharmacokinetics is the way that your body processes a drug. So it's broken down into three different areas: absorption, which is how the drug is absorbed into your body, distribution, which is how it's distributed throughout your body, metabolism, so breaking down cocaine to its metabolites, and then excretion through the kidneys into the urine. So pharmacokinetics is that process of what's happening in the body to a drug, and it's a very vast field. There's a lot of other parts of pharmacokinetics as well.
What is it used for?
So in forensic toxicology, a lot of the substances we deal with are not legal. You can't give them to humans. So a lot of times when we think about pharmacokinetics, especially for substances of abuse, we would look at pharmacokinetic studies generally in maybe a rat, and we'd see, well, how much drug was given to the rat, how much drug we were able to detect if we collected the rat's blood, how much of the drug was excreted through the rat's urine. There are some substances that are used in humans, like cocaine. I mentioned previously that there were studies looking at individuals ingesting capsules of cocaine, and through that same process you can look at then peak plasma concentrations, as I mentioned, metabolites, all those different aspects.
So you'll agree with me then that pharmacokinetics is sometimes used to try to determine a dose amount?
I would not say pharmacokinetics is used to determine a dose. I don't think that would be the correct way to state that.
Well, how would you state it?
So I mean, the only time that this is really done in forensic toxicology is with alcohol. So you can look at, and you may be familiar with this, but you can look at, based on the amount of ethanol in someone's system, you can back extrapolate to potentially how many beers or how many shots or how many glasses of wine they took. The reason we can do that with alcohol is because of its pharmacokinetics and its linear elimination from the body. In the world of other drugs on humans, I'm really not aware of any pharmacokinetic properties or calculations that you would do to correlate those drug concentrations back to the dose. And in this case, the blood concentrations of cocaine back to an exact dose of cocaine consumed.
So you're stating that it is never utilized to try to determine a dose. Pharmacokinetics is never utilized in your field to try to determine a dose of cocaine? Is that your testimony, yes or no, sir?
So I am not in a forensic case like this. I am not aware.
I said, ever. Is pharmacokinetics ever utilized to determine a dose of cocaine?
Well, as I mentioned before, in terms of a rat study, actually this can be, there are certain research studies where they may look at in the hospital trying to see how much, if they can control the amount of urine that is collected over a certain amount of time and do quantitative testing on that urine. There are some research studies that would look at trying to then calculate back the dose of a certain drug that was consumed. So there are aspects of forensic toxicology where that may come up. But in terms of a case like this, where you're looking at drugs for a legal case, that's a whole different realm from what we're talking about today.
So the answer to my question is yes, it has been done.
Yes, it has been done, but again, under the different premises that I mentioned.
But is your testimony in a case like this, you should not do that? Is that right?
It is my opinion that if I was asked to calculate the dose of cocaine consumed, that is not something that I would do.
And so then, based on your testimony, there is nothing we can do to try to determine the apparent amount of cocaine that was in her system at the time of ingestion.
Well, now you're asking two different things. The dose of cocaine would be the amount of cocaine outside the body that is then ingested in whatever form you want to ingest it. The amount of cocaine circulating in blood is a whole different thing from the dose. That's not the dose. That would be the circulating concentration of the cocaine.
I wasn't speaking about this, sir. I was speaking about trying to determine the amount of cocaine that Ms. Benning would have had to take in order to have the numbers that we see in her blood. I'm asking you a simple yes or no for this jury. Is there a way to try to make that determination, sir? Yes or no?
Yeah. So I think I'm getting confused because you're talking about the 8,000 nanogram amount, and these are really two separate things. Yes.
Don't worry about the 8,000. Simply listen to my question.
Let me ask it maybe in a more
Yeah.
quicker way, can you tell us whether she took an ounce, 2 ounces, or a kilo?
There would be calculations to potentially rule out really large amounts or really small amounts. I don't think that there is not a calculation to get an exact amount in the middle, to answer the question.
And so there are calculations to make an assumption.
Yes, and in a hypothetical world, to make an assumption, yes, I believe someone could do that.
And what would they use to do that?
Yeah, I mean, there's a lot of factors. I mean, there's factors in terms of, right, you'd have to look at you'd probably take some sort of concentration that you're starting with from what we would detect. There'd be different parameters within the body, understanding, was this a larger or a smaller individual? Did they have potentially a lot of blood, a little bit of blood? What is their different physiological parameters of them? Time is a really important thing.
I'm not asking about the factors. I'm asking about what would you call it? If it's not pharmacokinetics, in order to get to that answer, what would you call it?
Okay, so I would call it that it would be some sort of pharmacokinetic calculation, but it is not the entire field of pharmacokinetics.
Well, so then you can use pharmacokinetics to try to get to an assumption as to what amount of cocaine she took, correct?
Sure, yeah, somebody could, in theory, do that.
Thank you. So, in regards to that, have you done that calculation for this case?
No, as I previously stated, that would not be something that I would consider doing.
Now, and a number of, well, let me ask you this. What is a half-life of cocaine?
So the half-life is defined as the amount of time it takes for a concentration to half. So say, for example, at 1 hour it's 800, and at 2 hours it's 400. The number is halved. Over 1 hour, the half-life would be 1 hour. And you would expect then the half-life to continue 400 down to 200, down to 100.
Okay, so what is the half-life for cocaine?
I do not have that number off the top of my head. That's not something we typically would memorize.
Okay, but you will agree with me there is a half-life.
Correct. There is a half-life of cocaine. I just don't have it off the top of my head.
And would you utilize that half-life if you were to employ the methods of pharmacokinetics to try to get to a number? I know it may not be accurate, but would you utilize that half-life?
Yes. If you were going to do this back calculation, one of the things in that equation that you would use, I would imagine, would be half-life. Yes.
Okay. Very good. Thank you. As you sit here today, the number that you see on that NMS lab that's with the CFSRE lab ending in 889, you'll agree with me that I believe it's, 78? Is that right?
Yeah, so the econyl methyl ester concentration is 7,800.
No, the parent cocaine, is it 78?
Oh, I apologize. Yes, the parent cocaine concentration is 78, yes.
And that number in and of itself is not just an abnormal high number, is it?
No, but again, this was not something
All I'm asking is about the parent cocaine and that number 78. That's not an abnormally high number, is it? Yes or no?
No, it's not that 78 alone is not a large amount, but again, there's a lot of factors that will go into it, and I've not reviewed this, so I'm not exactly sure sort of the time course of this.
I wasn't asking about the time, I was just asking about that number.
Yeah.
Okay. And so you'll agree with me also that that number 78 is in fact a number that someone could take on their own. Yes or no, sir?
Well, certainly cocaine can be taken on its own by an individual, yes.
Thank you, sir.
Dr. Krotulski, Dr. Carney had testified that she adds the EME to the parent cocaine to estimate the total amount of cocaine level before it began creating the NE or breaking it down. Do you agree that that is a common method to use to estimate the value?
Yeah, so one thing I didn't explain, cocaine is a very unique drug. It's actually quite unstable. It can go through different processes of breaking down by enzymes or through hydrolysis. And it can break down to things like benzoylecgonine and econyl methyl ester. So because cocaine is sort of so unique, there have been different research studies looking at saying, okay, well, because we know it's an unstable drug, is there a way that through different calculations we could potentially estimate how much cocaine was present at the time the blood sample was collected, rather than a few days or weeks or months later when that cocaine broke down?
And your testimony as a toxicologist is that you would not estimate that value because your testing is very precise, but you don't disagree with Dr. Carney using that.
Correct. I'm not disagreeing with Dr. Carney. Right.
And the state never asked you to calculate a dose, but you can't calculate the dose Ms. Benning ingested. Judge asked you about an ounce or a kilo, but it could have been much smaller than that, especially if it was dissolved in a liquid. Is that fair?
Yeah, I mean, one of those factors is, as I mentioned previously, time. There's also, a lot of times if you're going to do some of these pharmacokinetic studies, there's assumptions you're going to make. One assumption being that this was likely a healthy individual, normal processes, their heart was beating, their blood was flowing. If you're outside of those normal processes, some of these calculations start to break down. So again, I was not asked to do that. And again, it's a very complex process, and I just don't believe that that's something that would really be, I don't think you could probably do it with the information that I have and the understanding I have.
That's what I was about to ask you. You cannot calculate the dose Ms. Benning ingested.
Correct.
Thank you. Those are all my questions, Your Honor.
Now, you stated now, when I asked you the question, you told me that that was not a method you would use because it wouldn't be a definitive method. Are you changing your answer now?
Right, so when you say definitive...
No, you said definitive.
Oh, sorry. When we use the word definitive, for example, in this case, when you have 78 and 7800, I don't think it would be wise to put the two of those together and definitively say 7,778. If you're going to use it as an estimation for the amount, that's one thing, but using the word definitive here, in my mind, that says to say exactly what this concentration is, and again, that's not, I don't know exactly what Dr. Carney's testimony was, but that's what I meant by not being definitive.
Actually, I think you said in a legal case like this, you would not utilize that type of method to get a definitive answer.
I believe I said that based on the calculation of the dose when you asked me.
By adding EME and the parent, right?
He's talking about your questions when you wanted to see if he could determine a dose.
No, my question was to determine the parent
What is your
amount
question?
of cocaine. I want to be clear that you're saying if we were trying to determine the parent amount, we would not take the EME and the parent amount and put them together.
So again, I want to just make sure we're taking these two things apart, and we're not talking about dose. So now we're talking about circulating amount of drug in the body, and in this case, taking the parent amount of cocaine, and then the substance that the cocaine broke down into, understanding that those two substances are related, and doing an estimate based on that is something completely different. And that's what I was just asked by the prosecution. Again, this is completely separate from the question of dose, how much someone ingests.
And when you were talking about the CFSRE record that did not show the fentanyl, and that would be 202300092, this was an opiate screen, was it not?
So our testing for...
Yes or no, so was this an opiate screen?
So
one, you're way beyond what was asked on the redirect. So number two, let him answer the question.
So the testing that we performed on both urine samples includes opiates and opioids.
So this was in fact an opiate screen?
So I would not characterize the testing that we did as an opiate screen. We consider it sort of a broad-based drug screen that includes opiates and opioids, as it does stimulants, benzodiazepines, and everything else. So if fentanyl was present in the first urine sample, it was in the scope of testing, and if we would have detected it, we would have reported it.
Okay, so I just want to be clear, it would have, if fentanyl, if it was there, it would have been positive.
If fentanyl was present in the first urine sample, case 20230092, if it was present at levels detectable by our analysis, yes, it would have been reported.
So it could have been there, but it just wasn't at your detectable level.
Yes, that's how forensic toxicology testing works. As I mentioned with the levamisole and the cocaethylene, if something is below our threshold for detection, right, we would not be able to detect it, therefore not report it.
I just wanted to be clear so that the jury understood.
What is your question?
Is that it was possible it was there, but it just wasn't above the level.
Correct. And we have a pretty low detection level for fentanyl. I don't know what it is exactly off the top of my head. I'd have to go look it up.
Any other questions?
No, sir.
Thank you, sir.
Thank you.
All right, just want to thank you, Debbie, for that. Appreciate that. Hopefully you will get your situation sorted out sooner than later. All right, before we move forward, excuse me, I just want to take a quick moment here. My brother, no, don't want that. My brother in Ohio just sent me this picture. And I had no idea. I mean, I kind of did. That's not, that I shouldn't say that. I did have an idea that this was going on. But I just want to take a moment to acknowledge this. Let's see, where is it? Oh, hold on. I got to pull it down. Hold on. I just want to take a moment to acknowledge that this is going on for a lot of you guys. All right. Oops, sorry. That's totally my bad. Hold on. Hold on. All right, while we have time, sorry. And because we are fans of the weather here, weather and space, this is in Ohio. This is like kind of central Ohio. It's almost 100 there. So I know a lot of you are experiencing this. So just want to acknowledge this real quick. All right, these are heat alerts. These are all heat alerts all the way from Kansas City all the way up to Maine. All right, so that's that. If you guys are outside, definitely hydrate. New York City, 101. I remember those days, and I didn't have AC, and I lived on a 5th floor walk-up. Oh. I remember those days. It would be like midnight, and it would still be like 95. And then you go down into the subway, and it's like 110 down in the subway. Ugh. I remember those days, and it was not fun. It was not fun at all. So, if you guys are outside, absolutely hydrate, take care. Here's let's see. Here's out to the Midwest, out into Denver even, 90s in Denver. I mean, they're breaking records left and right. Right? This is today's Wednesday. This is Wednesday, Thursday, and Friday. This is what's going on here. Here's the South. Now Orlando, that's kind of typical, you know. Orlando, it's actually warmer in New York City than it is in Orlando, but that's kind of typical weather for Orlando. But Raleigh, 101, Memphis. Yeah, it's going to be warmer in Boston than it is in Orlando. Let me check Boston again. Yeah, Boston is going to be warmer in New York, Boston, Burlington, DC, Pittsburgh. It's going to be warmer. It's going to be warmer than Orlando. That's just crazy. So, 7 of Hearts, it's 103 for you. Yeah, I believe it. Virginia's, yeah. If DC is going to be 97 today, yeah, you're 103. Seashell, it's only going to be 78 today? Yeah. Lucky you, right? Miss Key, for those of you in the heat zone, please stay safe. It's been beautiful here in Northern California past few days. Thinking about you, praying. Yeah. Radioactive, it's only 70 for you guys. Yeah. Sharon, hotter tomorrow and Friday. Yeah, look at that. Everybody's going up. Everybody across the board is going up, except Burlington. But everybody else is going up. So, Kaylee, we're used to the high 90s. Yeah, we have AC. No, you're right. I had no AC in New York. When I was in New York, I didn't have AC. The one place the first place I did, second place I didn't, third place I didn't, fourth place I did. That's when I was in the city. When I was in Brooklyn, I didn't have it either. Yeah. So I really only had, out of the six places I lived in, 2 of them had AC. So yeah, 5th floor walk up without any AC. It was brutal. But I was living by myself, so whatever. It was just me and my cat, me and my cat Sasha. So anyway, yeah, definitely be safe, guys. All right, so that's a little weather blip. And for those of you in the south, yeah, there's south. Dallas is going to be hot, Houston. But aren't you that's kind of typical, I would think, for Dallas, for Texas. But Raleigh, Atlanta, is that kind of normal? Hellrider and you guys in is that kind of typical for you guys? I mean, it is. Oh, I see movement. Is there seriously? Hold on. Wait. There's some movement. Let me see. I just saw somebody's head. All right, nope, nothing. Still verdict watch. All right, still verdict watch. Isn't that kind of normal for you guys? Like Atlanta, it's not called Hot Atlanta for nothing. Is that kind of typical? Amy, yeah, typical for Atlanta. Yeah, that's what I figured. Yeah, I think it's going to break by next week. So, you set it to 65. That's pretty cold. We have ours set for 72. It says it's 95 for honey badger, and it feels like 111. Wow, that's just crazy. Today, when I woke up and I went outside, oh man, the humidity was just ridiculous. The humidity was just oppressive. I gotta mow the lawn this weekend. Not sure how I'm going to manage that. I'll just go in little bits and pieces. But even Denver, Chicago, I mean, that's like Detroit, 98 for Detroit. Minneapolis in the 90s. That's pretty intense. Radioactive, your daughter's in Hill Country. Yep, Hotlanta. That's why we call it Hotlanta. It is, yeah, it is record heat. They're saying, I was just looking at New York City. They said it's been about 15 years since they've been this hot. Dina, typical for North Texas. All right, yeah, that's what I kind of figured. Somewhat, but it's a little hotter than normal. Yeah. All right. All right. Mow after dawn. Grass may be a little wet. Safer for you. Yeah, I try to get out by like 10. I try to get out like around 10 in the morning. I try to get out at 10 in the morning. Yeah, I don't know. Well, I'll play it by ear, obviously. Hellrider, to be real, I do like it hot, but when it feels like 106, yeah. Linda, the weather map never shows Arizona. Is Arizona getting it? Are you guys? It looks like you guys are getting it just as bad, right? Looks like Arizona is going to be getting it just as bad. Yeah. So, all right. It's a little break. I need goats. I tell everybody that too. I think I told Barry that because Barry said he was going to be our moderator. Barry, he said he was talking about poison ivy and mowing, and I said, you should get goats. We thought about it. There are goats. We have a lot of farms where we live, and there are goats. There's goat farms where we live. Maybe I could go borrow one for like a weekend and have them. No, the cats would love that, I'm sure. The cats would love that. All right. Interesting captures. Good to see you. I see you joined us. Thank you for joining us. General Rod says next Wednesday it's supposed to be 110 in Arizona. But that's kind of typical, right? Isn't Arizona, New Mexico, aren't you guys used to like 120, 115? Isn't that kind of typical? Ooh, Jenny G, ouch. That is toasty where you are. Ouch. Jenny G just sent, wow. Yeah, that's hot. When you're not used to it too, like when it's 90 degrees and you're not used to it, that's just, you know. Yeah, your brother has goats, Seashell, cool, in South Carolina. Goats eat everything and anything, yeah. I mean, 90 degrees when you're not used to it, that's hot. It's debilitating. That'd be like for us, like our high right now should be like 92, I think, 93, somewhere like that. So it's okay when it gets to like, I don't think I've ever experienced 100 degrees, other than my car. When I got my car, I would see 100 degrees, but actually I think it was 105 one time. But Florida, I don't think Florida really gets 100 degrees, you know, because we have the Gulf, we have the sea breezes always blowing. So I don't think, not like the interior, where you get 100 or even hotter. Jen, you're from Orlando, and it gets hot. Yeah, but that's what I'm saying. It's all relative. Like we're used to it. We're used to that temperature. At least I'm used to it. I mean, I expect it. Yeah, 92, 91 in Orlando. I mean, that's what I expect. It is July, so I'm like, yeah, to me that's normal. Actually, I think that's probably below normal, if anything. But we're used to that. We have AC. Just like you guys have the North people up north and Midwest, you know, you guys have heaters. You know, we don't have heaters. I mean, we do specifically, but when we were in South Florida, well, that's not true. Our AC was a heater. We could get heat with our AC, but we used it like 2 or 3 times a year, and that was it. You know. JMS, they said yesterday. The judge said they can go till midnight if they want to. The judge yesterday said they can go to midnight. So I think they're going to let them. I think he's going to just let them go. Scott, yeah, dry heat. You know, I've heard that, you know, ever since I started following weather, which is, you know, when I was a kid or whatever. But I'm always like, I guess my comeback would be, yeah, but it's like sticking your head in an oven. Sure, 120 degrees, it's a dry heat, but it's literally like sticking your head in an oven. That's hot. Although I would prefer a dry heat versus the humidity. Humidity is just brutal. You take a shower, you walk outside, and you're just soaking wet in a matter of like 2 minutes. Got to take a shower again. Yes, and move slowly for sure. Yes, horse welfare. Yeah, he said yesterday they can deliberate until midnight. So. All right. Well, that just I saw that. My brother sent me the almost 100 degrees, and I was like, woo. And then I checked. This is from the Weather Channel, but I just checked, and yeah, I was like, wow, this is affecting like 175 million of us over. It's July 4th weekend. You know, there's going to be a lot of people out celebrating July 4th this weekend, and just be careful, just be safe. Even though today's only Wednesday, just be careful. All right. Next up, we have a medical examiner. We also have forensic services supervisor. Let's see. All right. I want to go back to the medical examiner. Let's go back to her. This was Dr. Erin Carney. Let's go back to her. Because I was driving when her testimony was going on. I think I came in right as her testimony was ending. So I want to see her testimony. All right, this is Erin Carney. This is the medical examiner.
Here an hour plus ago, but just blame me for any kind of delay. We've dealt with a legal issue that I should have dealt with late last night after y'all left, but I didn't. So just blame me for any issues you have with the delay. All right, Doctor, if you'll step up. Raise your right hand and be.
Do you swear to tell the truth, so help you God?
Judge, at some point I had 3 photographs that were sent up. I don't know if everybody sees those.
They're right there.
Good morning, Dr. Carney.
Good morning.
Could you please state your full name for the record?
Yes, it's Erin, E-R-I-N, last name Carney, C-A-R-N-E-Y.
And Dr. Carney, where are you employed and what is your position?
I work at the Center for Forensic Medicine. We service the Davidson County Medical Examiner's Office and the Regional Forensic Center for Middle Tennessee, and I'm a forensic pathologist.
And what is your current position?
I am the Interim Chief Medical Examiner for Davidson County.
And how long have you worked at the Medical Examiner's Office?
I've been there, it'll be 13 years next week.
And prior to that, what did you do?
So prior to that, I did my education and training to become a forensic pathologist. I earned my Bachelor of Science degree in biology with a concentration in biochemistry and cellular and molecular biology at the University of Tennessee, Knoxville. I attended Vanderbilt University School of Medicine, where I earned my Doctor of Medicine degree. I completed residency in anatomic and clinical pathology at the Johns Hopkins Hospital and a forensic pathology fellowship at the State of Maryland Office of the Chief Medical Examiner.
And do you hold any certifications or medical licenses?
So I have medical licenses in the states of Tennessee, Texas, and Kansas, and I am board certified in anatomic, clinical, and forensic pathology.
And can you describe, do you do any teaching in the field?
Yes, so we teach residents in pathology who rotate through our office, and I am an assistant professor at Vanderbilt.
And approximately, can you estimate how many autopsies have you performed in your 13 years at the medical examiner's office?
I've performed over 3,000 autopsies.
And that's you yourself?
Yes.
And Your Honor, if I can pass the witness the document.
Okay.
Dr. Carney, do you recognize that document?
Yes, ma'am.
And is that a copy of your CV?
Yes, ma'am.
Your Honor, at this time, I'm to ask that be made the next numbered exhibit, which I believe is number 30.
Okay.
Dr. Carney, can you describe what is an autopsy? What is that process?
So an autopsy is an examination of the body that consists of 2 parts. There's an external examination and an internal examination. For the external examination, I'm looking at the outside of the body. We will record the length of the body on the table to estimate their height in life, look at the hair color, the eye color, and I'll look for evidence of disease or injury that would help me understand why this person died. Then we'll do an internal examination that starts with a Y incision on the chest and abdomen, where we reflect the skin and soft tissue so I can see the ribs, look for any rib fractures. We'll cut through those ribs and take off that sternum and ribs, the chest plate, if you will, so I can see the internal organs and look for any bleeding or fluids around those organs maybe that shouldn't be there.
And then I'll look carefully at each of the organs for evidence of disease or injury. And then finally, we do an incision behind the ears, across the top of the head, and reflect the scalp forward. And that way I can look for any bruising that might be hard to see if we have a lot of hair. And then we'll actually cut through the skull, and that way I can look at the brain and look for any evidence of stroke or bleeding in the brain.
And when you're completing an autopsy, what is kind of the ultimate determination that you are making as a medical examiner?
So the goal of the autopsy is to determine the cause of death.
And obviously there's many causes of death. Is there another determination that you assess?
Yes, so I want to determine the cause of death from autopsy. And then from the autopsy findings, in combination with the investigation into the circumstances surrounding the death, I will come to a conclusion for the manner of death. That's a classification of death, and it typically fits into one of 5 categories. There's 6 on the death certificate because there's a pending option if we're still waiting on information.
And that determination of manner of death, is that for purposes of the death certificate?
Yes, ma'am.
Is it a legal determination that has anything to do with this criminal process?
No, ma'am.
And what are the 5, or you said actually 6 possible outcomes as to the manner of death?
So it's homicide, suicide, accident, natural, could not be determined, and then the 6th one, like I mentioned, is the pending investigation. So if I don't have all the information yet to make the determination in one of those 5, then they'll get a pending death certificate until I have everything.
And that is a separate standard that you use just for the death certificate, is that correct?
Yes, ma'am.
So if you labeled something a homicide, it would not mean that a criminal homicide occurred, is that right?
Correct.
And many times it would not be determined from your perspective for purposes of the death certificate.
Yes.
But you still come to court and testify in criminal cases, even in that situation, is that correct?
That's correct.
And did you perform the autopsy of Jade Benning on March 7th of 2023?
Yes, I did.
And at this time, I would proffer Dr. Carney as an expert in forensic pathology.
Okay. All right, again, ladies and gentlemen, Dr. Carney will be allowed to testify as an expert in that field and give her opinion that a lay witness wouldn't be allowed to give. You could place such weight upon her testimony as you choose to. Okay.
And at this time, I would ask that the witness be handed a document.
Dr. Carney, did you complete a report of the autopsy that you completed on Jade Benning?
Yes, ma'am.
You have that report, you can take a look at it and let me know.
Yes, this is my autopsy report with the attached toxicology report.
Dr. Carney, how did you first get notified of Jade Benning? Was it when she was received by your office at the medical examiner?
Objection, Your Honor, leading.
Okay. The question was, when did you get notified about the death of Jade Benning?
Well, my office was called actually a few days after she went into the hospital because she had experienced this anoxic brain injury and it was believed that her death was imminent.
Is that a typical thing that happens?
Yes.
And once you were contacted, did you engage in discussions with people at Vanderbilt?
Yes.
And specifically, who were you speaking to at Vanderbilt?
I had a lot of dialogue with the toxicologist at Vanderbilt because initially Ms. Benning's reason for her brain to be deprived of oxygen, the reason that her heart stopped, was unknown. And so there was a lot of testing and trying to determine why this happened. And so we were in discussion trying to determine what might be her cause of death and what I might need to test for or look for when she came to my office.
And did you actually make requests related to Jade Benning before her body ever arrived at your office?
Yes. So when we are notified that a death is imminent and they're in the hospital for an extended period, and I think the toxicology could be very important in the case, then we want to make sure that that initial blood sample that was taken when they first came to the hospital is saved and not discarded. So we contacted the laboratory at Vanderbilt Hospital to make sure that they saved that blood for me to be able to test after her death was pronounced.
And Your Honor, I'm going to ask that the witness be handed Exhibit 12, which I have, as well as 3 other photographs. Dr. Carney, do you recognize the image in Exhibit 12?
Yes, ma'am.
And can you describe what is that in that image?
So this is the hospital blood, the sample that I mentioned that was taken when she first arrived at the hospital that we asked them to save in the laboratory for us to pick up after she passed away. And this is that blood sample.
Your Honor, may I display this exhibit to the jury? I have it digitally.
Okay. And that exhibit has been talked about before. The photo, who made that?
Who made this photo? The photographer at my office took this picture. This was when the blood sample was transported to the medical examiner's office.
And Dr. Carney, does this have the specific date and time the blood sample was collected from Ms. Jade Benning?
Yes, ma'am. So you can see on the label it says 2/25/23 at 22:31, so 10:31 that evening.
And is there a Vanderbilt University medical record number also on that same label?
Yes.
And I guess, can you describe, does it have Ms. Benning's date of birth?
Yes. So her date of birth is listed there at the top of the sample. It's upside down in this picture, but yes.
And the labeling underneath it, can you describe what that is?
So whenever an individual comes to my office, they are given their own unique medical examiner case number. So the MEC number 23-0842 is Ms. Benning's specific case number. And then the date underneath it is the date that she died.
Your Honor, at this time I would ask that Exhibit 12, which was previously marked only for identification, be entered as Exhibit 12.
Okay.
Yeah, may I object and have Coach?
Okay. All right.
Office along with Ms.
Dr. Carney, did you also have 3 additional photos? Do you recognize those?
Yes, ma'am.
And can you explain, when did you receive the blood sample on the one from 2/25/23 at 22:31? When did you receive that?
So that blood was actually transported to the medical examiner's office along with Ms. Benning's body on March 7th in the early hours of the morning.
And you said that it was photographed at your office, is that correct?
That's correct.
And then what, if anything, did you do with that vial of blood?
So I wanted to see what kind of tube it was in and how much blood was there so that I could determine what kind of testing I could order on it. And then I sent it to NMS Labs for the needed toxicology testing.
And can you explain what you mean by you wanted to see what type of tube it was in?
Well, typically when we draw blood at the time of autopsy, we put blood into a tube that has a gray top. It contains sodium fluoride, which is important to inactivate those esterases in the blood. It's these enzymes that can break down cocaine. And so they continue working even after death. And so I wanted to see what kind of tube it was. This is actually a clear top tube, so those esterases are still able to break down the cocaine. But just so I'm aware, and that way I order the correct testing so that I can not only see if there's cocaine there, but if there's those breakdown products that have probably been formed over the time that it's been in this tube in the hospital.
And Dr. Carney, can you explain why was it that you were wanting to have it tested for cocaine?
It was, I learned in the process of while Miss Benning was still in the hospital that she had a urine drug screen that was positive for cocaine.
And so once you received that file, did your office submit a request to NMS?
Yes, ma'am.
And can you explain what is NMS Labs?
So NMS is a toxicology laboratory that is located in Pennsylvania, and they have a lot of capacity for testing, and so we send our specimens to them.
And did you send that specimen to them for testing?
Yes, ma'am.
And did they report the testing results to you?
Yes.
And then what, if anything, happened with the blood from Jade Benning from 2/25/23 to 22/31?
So when they were done with testing, they sent me a laboratory report with the results. I actually ended up talking to a toxicologist at NMS, and I let them know, typically they hold the blood for 1 year and then they discard it. So I let them know I did not want them to discard this, and then before that year was up and time to discard, I asked them to transport it back to my laboratory so that we could preserve it.
And do you recognize what is in those 3 photographs?
Yes.
And what is that?
So this is that same tube of blood that I asked them to send back to our office, and now it has their case label on it.
No, at this time I would ask that those 3 photographs be entered as the next numbered exhibit, which I believe is 31.
Sure. Okay. All right, show those 31.
And Your Honor, may I have permission to publish the photographs for Exhibit 31 to the jury?
Okay, you need these?
Yep.
Okay.
Dr. Carney, can you see the image that is on the screen?
Yes, ma'am.
And can you describe what's in the image and how you were able to identify it?
So if you see on the tube, it has the case ID, which is her unique medical examiner case number and her name. And then the label at the bottom is one that we printed at my office to take the picture.
And the next image, which is 31B, can you describe what is shown here?
So here we have a barcode and we have a series of numbers. That 231-26889 number, that is the unique work order number that is attached to her laboratory report, her results.
And if you need to reference your autopsy report, do you recognize that work order number from NMS?
Yes, and even the 001 identifies it as the hospital blood for this particular case.
And can you, just for the record, read out what the work order number is and verify that it is the same in your autopsy report?
Yes, ma'am. 231-26889, which is the work order on the report as well.
And the next image, which is Exhibit 31C, can you describe what's shown here?
So this again confirms this is her hospital blood. It shows the date that we entered the order into the computer, and then the date, it looks like the date they received it. So we didn't ship it out the day that we ordered it. We usually send it out twice a week. So it got sent out likely on the 3rd for overnight shipping for them to have it first thing in the morning. And it's sent with cold packs to keep it in the best quality.
And where is that tube of blood now?
It is at my office.
And it is still at your office, is that correct?
That's correct.
Dr. Carney, when the blood was sent out, did you receive a report from NMS Labs?
I did.
And specifically, can you describe what was the testing that you requested and what was the testing that was done as it relates to that 2/25/23/22/31 hospital blood?
So I ordered a cocaine and products panel so I could catch not only the cocaine, but any breakdown products that may have formed while it was sitting in that tube. And then I also asked them to test for designer opioids.
Your Honor, at this time, I'm going to ask that Dr. Carney's autopsy report be made the next numbered exhibit. I can't believe that I did that.
No objection.
Okay.
You have a copy.
Yes, ma'am.
No objections outside of the standing objections.
Dr. Carney, your autopsy report, which is now Exhibit 32, did you incorporate the NMS lab work order number 231268889 as part of your report?
Yes, I did.
And did you rely on these findings in making your determination as to the cause of death?
Yes, ma'am.
Your Honor, may I publish a page from Dr. Carney's autopsy report to the jury?
All right, I'm not sure what's going on. They've gathered. They've gathered, you guys. I'm not seeing that this could be a question. They have gathered. They have gathered. We have action in court. Action in court. All right, action in court. Let me see if there's anything over here. Nothing over there. They just gathered. Something happened. You saw that, right? They literally just gathered. I just want to get to that. Yeah, they just gathered. This was just moments ago. They just gathered. Everybody's there. All right, here we go. Let's see what happens.
All right, the court's staff's been made aware that the jury's arrived at a verdict, so we'll let them step down and announce it. Just out of respect to the jury, just keep your reactions, if any, to yourself, and we'll deal with it. All righty. All right, you can have a seat. All right, ladies and gentlemen of the jury, the court just, and I say this just to reference to you by numbers. We start down at the far right and run down this way, 1 through 6, upper right, 7 through 12. So, Miss Juror number 7, you are the foreperson? And the jury's arrived at a unanimous verdict?
Yes, ma'am.
All right, if you would, please, ma'am, stand and announce that verdict on behalf of the jury.
We, the jury, find the defendant Blaise Allen Taylor for count 1, guilty of second-degree murder. For count 2, guilty of first-degree premeditated murder. For count 3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am. All right, ladies and gentlemen of the jury, you can back up just a second. Ladies and gentlemen of the jury, you've heard your foreperson, juror number 7, announce your verdict in this particular case, that you found Mr. Taylor guilty in count 1, second-degree murder, in count 2, first-degree premeditated murder, in counts 3 and 4, felony murder during the commission of a first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is. If it's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, the foreperson, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, sir.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right. Thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. Don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer. Mr. Taylor, you've heard the verdict of the jury in count 1. They found you guilty of second-degree murder. That verdict, as well as the other counts, guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of initial verdict. Come back and hear that proposed testimony under State versus Nesbitt, and then see Mr. Grant, Ms. Hollins, Mr. Joyner, what mitigating factors you want to submit and find that's necessary to submit to the jury. So,
the state's position is that Nesbitt only applies in death penalty cases.
What?
As far
I'm
as
talking about as far as victim impact 403 analysis.
Under Nesbitt, if it's life without parole, there is a submit no analysis.
So you
There's no dry run unless it is a death penalty case.
You can just have whatever that may be overly prejudicial?
No, it will be victim impact under pain.
Okay. And does Mr. Brand, Ms. Hollins, you have prepared proposed mitigating circumstances?
Yes, Your Honor. I think there are mitigating circumstances, mitigating factors we would argue to the jury.
Okay. All right. If you'll get those.
I think we need a minute, probably.
Okay. Like I said, we'll take a short break. But let me ask the state this. There are cases with, obviously with the finding in count 1, that wouldn't be considered by the jury. But there's also, I think it's Vargas versus State, that does apply to any felony murders that your notice that you submitted, the felony murder portion, I think it's your number 2, wouldn't apply in counts 3 and 4.
Disagree, Your Honor, because it is Middlebrooks. It is not a Middlebrooks situation. It is within the legislation that amended the statute post Middlebrooks, so that is something the state submits the jury can consider in a felony murder sentencing.
That an aggravating factor is the felony murder.
Which is based upon that aggravating circumstance, which is above and beyond just the definition of felony murder.
What do you mean by that?
Well, that the jury would have to find the aggravating circumstance that, again, that it is not a Middlebrooks situation, so that state's position is the jury can consider that as an aggravating circumstance. That was the whole issue in Middlebrooks.
But there's some that would only apply to certain counts.
Yes, Your Honor, the age of the victim, certainly.
Right. All right, we'll take 15 minutes and then come back and hear from the defense in terms of mitigation.
Yes, Your Honor, the state would like to be heard or see that.
Yeah, let's
we have an argument about that.
Taylor, and by law, Mr. Taylor bond has to be revoked. So if you'll step into the back and talk with your attorney.
Folks, in a 15-minute recess.
So that's her mom and Nigella. That's Nigella and her mom, Bridget. So for those that are just joining, a verdict came in, and Blaise Taylor was found guilty. He was found guilty second degree on count one, which was Jade. He was found guilty second degree, which was the lesser included. But for Ivy, he was found guilty for first degree. And then counts 3 and 4, he was found guilty. Murder and commission of the attempted homicide. I see they're all wearing purple, so purple must have been, maybe that's Jade's favorite color, I'm not sure. Yeah, I'll do a recap. Let's just sit in this moment. I'll do a recap in a little bit. All right, we really don't hear much other than the general clamor. All right, so to get to some of your questions, yeah, they're all dressed in purple. So I'm wondering if that was Jade's favorite color, maybe. All right, so he was found guilty of taking out Jade second degree. So that was one of the lessers. So that's second degree. as far as Ivy was concerned, the unborn female daughter, unborn fetus, that was first degree. And then count 3 was murder during the commission. That was for Jade. He was found guilty. And then count 4 was murder during the commission. That was for Ivy. That was guilty. So what they basically, I think the jury thought that he did not mean to kill Jade. He meant to cause an abortion. That's the way I'm reading it. And Jade was Jade unfortunately she lost her life. So it seems like the jury was thinking he did this to get rid of the baby. Didn't mean for it to happen to Jade. So that was some raw emotion there, that's for sure. No matter what side of the aisle you are on this, that was definitely some raw emotion. So lots of purple in the chat. Lots of purple for the chat. In the chat, I should say. So yes, sentencing. They're going to do sentencing. They're going to do sentencing right now. And then he said the jury, in front of the jury. So I guess the jury decides the sentencing. That's usually in a DP case. What is he actually facing? Probably a very, very long time. What's second degree in Tennessee? Second degree. Second degree sentencing in Tennessee. 15 to 60 years, fine up to $50,000. The lowest looks like 15 to 60 years. Multiple offenders, 20 to, yeah, he's not a multiple, so he's a first time. So it's 15 to 60 years. Now that's just for count 1. That's his second degree. Then he's got first degree. First degree is not probably going to go well for him. Then you got first degree. First degree is life without possibility of parole, or life with the possibility of parole after serving minimum of 51 years. So he's going to look like he's going to be in for a long time. He's going to be pretty much his life. It seems like he's pretty much going to be, but it seems like first degree can be minimum of 51 years before becoming eligible. Now, I don't know if the jury decides this or not. The most common sentence for first degree, that's the United States. I don't care about United States. I just care about Tennessee. So the mandatory minimum sentence is life. The exact penalty handed down by the court depends on the presence of aggravating factors, the defendant's age, whether the prosecution seeks the DP, which they did not. So, all right, so he could get possibility of parole if there are no aggravating circumstances. So if there's no aggravating circumstances, and that's first degree, that's an unborn child. So I'm thinking that's an aggravated circumstance. So I think the end result is I don't think Mr. Taylor there is going to be seeing the outside of a self probably for the rest of his life. I think he's going to be. I think he's going to be going away for a very, very long time. And guys, just as a reminder, just put DV instead of spelling out domestic. Just put DV for us. We don't want to get smacked by YouTube. We've already had some run-ins with YouTube over the years. So just put DV. Put DV. We don't want to have to to delete your comments. Just put DV. So count 1, which was Jade, he got second degree. Count 2, which was Ivy, he got first degree. Count 3, which was in commission of attempted homicide for Jade, he got guilty. Count 4, commission during the commission for attempted homicide for IV, he got guilty. So the purple is for DV. Gotcha. That makes sense. Thanks, guys. Thank you, Lizuzzi. Thank you for that. So, all right, I'm going to remove the verdict clock because we don't need the verdict clock anymore. We will leave Jade up there. Let me see. I have other pictures of her. Let me see if I can find another picture. Actually, this is the one. This is the one we really should be putting up. Is this one? That's the one we need to put up. Let's see. So Brett says, in any first degree case in which the state does not seek the DP but is seeking imprisonment for life without possibility of parole as a maximum punishment, should the jury find the defendant guilty of first degree, the jury shall fix the punishment in a separate sentencing procedure to determine whether the defendant shall be sentenced to imprisonment for life without possibility of parole or, okay. The sentencing proceedings shall be conducted in accordance with. All right, so thank you for that, Brat. It does seem like, the jury's going to decide his sentencing. So appreciate that, Brat, for finding that for us. So the jury, apparently the jury is going to decide the sentencing as well. So there you have it. Bond was revoked. Yep, Elaine, his bond was revoked. That is true. Debbie says maybe he wanted sentencing right away if he was found guilty. His choice. Could be. Defense mentioned litigation. What does that mean? Mitigating circumstances. I think they said mitigating. It was mitigating. I'm not sure if they said litigation, but mitigating circumstances. You have aggravating factors, which are for the state. You have mitigating circumstances, which are for the defense. It basically is, it just minimizes. Mitigating is kind of, it minimizes the impact. It's like he was a straight A student. He didn't get involved. He didn't drink. He didn't do substances. He was never involved in gangs. He was part of the church group. Those are all mitigating circumstances. Aggravating factors are. What would be an aggravating factor in this case? I'm not even sure, to be quite honest. Like if you use a firearm, that would be an aggravating factor. I guess using poison would be an aggravating factor. So mitigating circumstances is just going to show how good he is versus how bad the crime was. So. And then there's that, Mike. We don't know. I think that'll probably be up to the judge. Whether it's consecutive or concurrent. You're welcome, Anthony. No problem. Yeah, ask as many questions as you guys want, and if we don't know the answer, we'll look it up. And he does have a lot of mitigating circumstances. He does not do drugs. He does not do. He doesn't do substances. He doesn't do alcohol. He doesn't drink. He's never been involved with the law, as far as we know. He may be involved with his church. I mean, we're going to hear all of that. Hopefully his family will stand up. I hope his family, at least comes and talks to him. I think his dad, I'm pretty sure his dad was in court. We saw him the other day. Trooper, I believe his name is. Is that his? I forget his dad's name right now. I think it's Trooper. Trooper Taylor. Yeah, his dad's name is Trooper Taylor. He works for Texas A&M. He's the football coach. He's a football coach for Texas A&M. So next time you guys watch Texas A&M play, Texas A&M is a huge college. Carl Trooper Taylor. He was born in 1970. He is the coach for Texas A&M. Oh, I'm sorry. He's serving as associate head coach, and he is the running back coach. So he's an associate head coach, and he's the running backs coach. So Carl Trooper Taylor, that's Blaise's father. So That's true, Amber. It could be. Yep, it could be multiple victims for sure. It just makes it's whatever makes it look worse than it is. It's like if you used a knife, if the person was over 60, did you use, and in this case he used an illicit substance. That's probably going to be a aggravating factor. So there's going to be there'll be a few. He may have more positives for him, to be quite honest, right? I think not drinking, not doing substances, I would think that would go a little, but no, let's face it, he's not going anywhere. I mean, that's not going to like get him for, we're going to give him 5 years, no previous, misconduct. It's not going to get him, we're going to give you only 5 years. No, I mean, he's going to be going, he's not setting foot outside of prison. So, well, we don't like that. We don't like that. Show us. There we go. There we go. Camera operator. Hey guys, let's see if we can get up to 300 likes. We are at 289 likes. If you can hear my voice and you have not had the opportunity yet, please take a moment to hit the like button. Let's see if we can get up to 300 likes before they come back for the sentencing. They said 15 minutes. If you can hear my voice, please take a moment, hit the like button. We're at 289. 289. Let's see if we can get, it's been about 12 minutes. No, actually, it's been longer. It's been more than 15 minutes. It's been almost 18 minutes. Let's see if we can, 298. Thank you. 2 more. We need 2 more likes. 2 more likes. Can we get to 299? 299. Do I hear 299? Can we get to 299? Let's see if we can get up to 300 likes. There we go. 302. Thank you, guys. Really appreciate that. We got to over 300 likes before they came back. Thank you, guys. Really appreciate that. Thank you so much. 303. Thank you. Really appreciate that. Thank you. Whoever 420, you hit like on your phone and computer. Awesome. Thank you for that. Appreciate that. Now we just have to make sure. Sharon says, how always amazes me how people can do this to someone. He's claiming his innocence. I'm sure he's claiming his innocence, but that's not what the jury. Wow, yes, 300 we're at the 316. Oops, sorry. Dang it. Oh my God, sorry. Interesting captures there. 317 actually. 317. Thank you guys. Really appreciate that. Heidi, we rule. Yes, we do. Thank you guys. Thank you so much. Yeah, Missy, sentencing is today as well. Sentencing will be today. Judge said 15 minutes, and oh boy, that's not us. Cameraman, please stop playing with your toys. All right, so we heard the breakdown. Hold on a sec. I heard the breakdown of the jury. I heard the 4-person was a female, so the 4-person was a female. I heard female, 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 male, 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 female, female. Then another female would be 6, and then another male 7, 8. So I heard 8 females and 4 males. That's what I heard. Did you guys? Is that what 323? Yes. Keep it coming. Keep it coming. I heard. What was that? 8. I said 8. I heard 8 female and 8 female and 4 female. 8 female and 4 males. That's what I heard. Did you guys hear that too? Renee, the verdict came in a good half hour ago now. If you want to rewind it, verdict came in about 25 and a half hour ago. Yeah, half hour ago. If you want to rewind it, about a half hour ago. Then they were going to break for 15 minutes, and then they're going to come back with the sentencing. So if you want to rewind it, you can rewind real quick. And I would rewind, but I don't want to miss the sentencing. I don't want to miss the sentencing. I'd rewind it, but I don't want to miss sentencing. Brad, I should have done that at the beginning. Brad says Tennessee statutory aggravators that seem relevant. Committed. Make sure that I'm committed during another felony. A vulnerable victim. There you go. Especially heinous or cruel. Yeah. No, that's all good, and that's all true. That's all true. Green-eyed cat. The moving fellas arrived. You missed it. Rewind about a half an hour. I don't want to miss the sentencing. All right. You know what? I'll rewind real quick. I'm going to rewind it real quick, and then I don't want to miss sentence. If they come back for sentencing, I'll go live, but let's just hear it.
In count one, that wouldn't.
We, the jury, find the defendant Blaise Allen Taylor for count 1 guilty of second-degree murder. For count 2, guilty of first-degree premeditated murder. For count 3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am.
There, I didn't catch that. So it was during the commission of a felony. So it wasn't attempted. It was during the commission of a felony. So during a commission of a felony. So.
Start down at the far right and run down this way 1 through 6, upper right 7 through 12. So Miss Juror number 7, you are the foreperson, and the jury's arrived at a unanimous verdict. All right, if you would please, ma'am, stand and announce that verdict on behalf of the jury.
We, the jury, find the defendant Blaise Allen Taylor for count 1 guilty of second-degree murder. For count 2, guilty of first-degree premeditated murder. For count 3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am. All right, ladies and gentlemen of the jury, you can back up just a second. Ladies and gentlemen of the jury, you've heard your foreperson, juror number 7, announce your verdict in this particular case, that you found Mr. Taylor guilty in count 1, second-degree murder, in count 2, first-degree premeditated murder, in counts 3 and 4, felony murder during the commission of a first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is. If it's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, the foreperson, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, sir.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right. Thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer.
Thank you. Interesting captures. That's really nice. Thank you. Thank you for that. Appreciate you and thank you. All right, so I'm just replaying the verdict. So far,
Mr. Taylor,
nothing.
you've
They're not
heard the
live yet.
verdict of
Hopefully,
the jury in count one. They found you
they're still not
guilty of
live.
second-degree murder. That verdict, as well as the other counts, guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay.
Okay, I'm going to rewind that. He said the court is going to decide his sentencing for count 1. Jury is going to decide counts 2 through 4. Did you guys catch that? I'm going to rewind that. Listen up.
We'll take it for that 1. They found
Thank you, Debbie. Appreciate that. Thank you so much, Debbie.
Mr. Taylor, you've heard the verdict of the jury in count 1. They found you guilty of second-degree murder. That verdict, as well as the other counts, guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing.
Further sentencing hearing for counts 2 through 4. Right? So that's why the jury's going to come back for 2, 3, and 4. He, meaning the judge, the court, does the sentencing for count 1. Right? That's the way I'm interpreting that.
Does the state contemplate in counts guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of initial verdict.
All right, so they this is live. They're still not back. So what is Kathy saying? Let me go to what's Kathy saying over here? Oh, sounds like they're coming back.
Yes.
I was just saying, when the defendant is out, that matter.
Okay. Well, yeah, you can bring him up. What is it?
Your Honor, on the notice that the state filed to seek imprisonment for life without the possibility of parole, based upon the jury's verdict in count 1, the state would move to basically strike our number 3 and what would be in the code section number 16, because that requires an intentional.
As to the
murder was committed against a pregnant woman,
right,
and the defendant intentionally kill the victim. The jury's verdict of a knowing killing, I think, removes that as an aggravated.
From what would be, if it had been instructed at all, in count 3. Right.
Yes, sir.
Okay.
Yes, sir.
All right, so that wouldn't be... All right, now, any submission, Mr. Brand, Ms. Harris, on the mitigating circumstances?
Yes, Your Honor. As far as mitigating circumstances, and I've discussed this with Mr. Moore, we would submit that the mitigating circumstances in Section J1, that the defendant had no significant criminal history, would be appropriate in this case. My understanding is there's no objection to that.
Okay.
That's correct, Your Honor.
And then, I apologize, I don't know which number this is, but the catch-all provision that
Number
any other...
10.
Yes, number 10, any other circumstance essentially fairly raised by the proof in this case.
Does the state care to be heard on that?
Judge, submit under the law that has to be specific as to what that is, like a list of that the defendant graduated top of his class and those sorts of things.
Sure,
not just a catch-all.
Right, and so to specify, we would intend to put on proof related to Mr. Taylor's education, his high performance in school, his high performance in athletics.
You would?
We are going to.
Okay.
Yes, we are going to put on that proof today at today's hearing. His involvement in nonprofits, so community involvement, other essentially positive personal traits and background related to Mr. Taylor that would support mitigation.
Okay. All right, I guess we can discuss the language that the court would place in there once we hear the proof. Anything else before the jury's brought down?
No, Your Honor.
Give opening statements and...
A brief, yes, Your Honor.
Okay.
And we would as well. The state
Okay. And does the state, just again for court's edification, know how many witnesses you may be calling?
3.
Okay. All right, let the jury step down. General Moore, the states, are you in agreement that the jury would be instructed in terms, well, I can ask this later. It dealt with victim impact statement not being an aggravated circumstance.
Certainly.
Yeah.
And the jury can only consider that after they have found the existence of at least one aggravating circumstance.
And just before we get into an issue, the victim impact statements are not going to include any statement of what they want.
No, we've discussed that.
Or you can have a seat. All right, members of the jury, when we get to this portion of this particular trial, the law allows for the attorneys to give to you opening statements, then present proof, and I'll explain all this in the jury instructions. The parties are allowed to introduce appropriate, relevant proof to the issues for your determination in terms of the penalty that the state's seeking of life without parole, or whether it should be a life sentence imposed on the counts 2, 3, and 4 that you've rendered the verdict on. Or does the state care to make an opening statement?
Yes, Your Honor. Just briefly. Members of the jury, because of your verdict, we are now going into the second phase of this trial. And what the state will present is based upon, like it seems long ago that I read the indictment. In this part of the proceeding, the state relies upon aggravating circumstances that are named. And there are 2 of those presented for your consideration. Number 1, the murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. So referring to Ivy. Number 2, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Again, based upon your verdict. The existence of those circumstances have been found beyond a reasonable doubt by your verdict. That allows, at this point in the proceedings, for the state to present what under the law is called victim impact testimony, to give you a view into what Jade and Ivy's death, the effect it has had upon her family, her extended family, and not going into really anything else. It was limited to that. Victim impact. And we'll be calling 3 witnesses. Jade's aunt, Brady Moran, and who would have been Ivy's great aunt, Andrea Browning, who you have heard before, and Jade's mother and Ivy's grandmother, Bridget Parks. At the conclusion of that testimony, and whatever the defendant chooses to present anything, this is proceeding that is submitted to your discretion. The judge will tell you the law, and once we conclude the proof, there'll be opening argument of the state. Perhaps the defense would have a chance, or they will have a chance to make an argument, and the state would close. Again, because we have the burden of proof without a criminal trial. But that is the process, and that is what you will hear in this part of the proceedings, to allow you to, in your discretion, determine what the punishment should be for the 3 first-degree murder cases. Thank you. Thank you, Your Honor.
All right, any opening statement?
Thank you. This case is and always has been tragic. Nothing that anybody's going to say in this relatively short portion of the trial is going to change that. And the thing we are going to ask you to remember is, even if you find there's aggravating circumstances, and really the aggravating circumstances the state is going to ask you to find are based on your conviction. Mr. Taylor's been convicted, there's no question. It doesn't require you to give him the harshest penalty ever. He's going to prison no matter what. The best outcome today is the rest of his life in prison, 60 years in prison, with maybe in 51 years he goes up for parole. He's 30 years now. At 80, he goes up for parole. That's the best outcome for today. You don't have to give him life without the possibility of parole. You can give him the opportunity to try for rehabilitation. You can give him the opportunity to work hard in prison. He's not going anywhere. This is a tragic case, but it doesn't have to be the worst of the worst outcome. Thank you.
Great. Who's the state wanting to call?
Your Honor, the state's first witness would be Ms. Brandy Moran, and as part of the proof in this portion of the proceedings, the state would ask the jury to incorporate all of the proof that has been presented.
Okay, I mean, the law allows that. All right, let her step in. Raise your right hand.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes.
Ma'am, could you please state your name and spell your first and last name for the court order?
Brandy Moran. It's BRANDIMORAN.
You heard me say a few minutes ago that you were Jade's aunt and would have been Ivy's great aunt. Is that correct?
That's correct.
And just so we're clear about the relationship, explain the family dynamics to us.
Well, she was my niece, but I was there with my sister the day she was born. I was in the delivery room when she was born, and for lack of not having children of my own for many years, she was like a daughter to me. My sister and I are very close, and so she was more than just a niece to me, and the same with my husband.
And just to be totally clear, who is your sister?
My sister is Jade Benning.
And so you have known or knew Jade from the moment she was born. Is that
the first breath she took, I saw.
And throughout her life, did you remain in her life?
She, like I said, was like another child, or like my only child for a long time. In fact, she was 13 when I finally had my child, and she was less than thrilled that I was bringing someone into the world to take her place, which he never did. But we took her, my husband and I took her to Disney World for the first time. I took her on her first trip to New York. She loved to travel. She was full of adventure. We traveled Europe together. We were in each other's lives when she went to culinary school. She lived with my husband and I. So we were very, very close.
And where were you when you learned about the February 25th, 2023 incident?
I was at my home in Northwest Arkansas, and I was actually folding laundry. My sister called and said something's happened with Jade. I don't know what's going on, but we're heading to Nashville. And immediately, we talked for a little bit. She was in the car, and in the meantime, my husband was in the background. Northwest Arkansas doesn't have a ton of direct flights, and it's a good 10 or 11 hours from here. So he was getting flights for me, the earliest that we could get in Kansas City, and we actually drove all night so I could catch a first 6 a.m. flight out of Kansas City to get to the hospital.
Did you know before arriving at the hospital that Jade was expecting?
Oh, yes. I learned that Jade was expecting on November 9th, 2022, because it was my son's 10th birthday, and she had actually traveled to Arizona. I was in Scottsdale for work, and my work was wrapping up, and I was flying out my son, and Jade flew out and my best friend so we could celebrate my son's 10th birthday together. And so she arrived at the hotel, and I was extremely excited that my event was over with, and was ready to, relax, and, wanted to have a cocktail with her, and she kept refusing. And so she finally had to tell me without everybody being there, but she had gotten me a little bag that said only the greatest aunts become great aunts, and it had a picture of the ultrasound inside. So from then on, if you look at our text, every single communication after that was about this baby.
And so would it be fair to say you were looking forward to being a great aunt?
Oh, yes. I had already asked off work I didn't have to ask off work, I work remotely. I'd already informed my boss that from middle of June through when my son had to go back to school, I would be working remote in Nashville, helping her learn how to become a mom.
The jury has heard that she was removed from life support, she and Ivy, on her birthday. Is that correct?
That's correct.
What was that like for you, yourself, going through that time?
It was probably, I thought, when my mother passed away a few years prior to that, that was the hardest thing I was ever going to go through. But nothing prepares you for what you see as your family's future going away. And although she wasn't physically my daughter, it was like losing a child. And not in a way that was fair, and especially at a time when my very last text to her was, "I'll see you on your birthday to celebrate." And that's what I was expecting that weekend before. I didn't expect to be driving to Nashville to experience what we experienced.
From the moment you heard, got to Nashville, and saw what was happening, has there been a day that's gone by that you haven't had this on your mind?
No, it's completely changed. We have a small family to begin with, and it's taken away I won't say it's taken away happiness, and I've done a lot with therapy and grief, and it's never going to go away. But there's never going to be pure joy in the celebrations that we have, because there's always going to be one of the big pieces of our joy missing. So
And with respect to the family, your sister, surrounding people we have heard from, have you seen how this has affected them?
Oh, it's everything. It's how we operate in life now. It's even how I allow my son to do things, because we are a normal family. This isn't anything you ever think you're going to talk about. When I say we were boring people, and we liked it that way, and just, you can't let go of the fact that this type of thing now, really happens to other people. It happens to you too, and it can happen to you. And so it impacts every decision, every thought. There's just across the board with my sister, with, our father, with my husband. My son was 10 at the time, and just trying to explain to him why somebody that was, just like a sibling to him is no longer here.
And I was going to ask about that, because Jade and your son would be cousins.
They were cousins, but they were
closer than that.
They fought like brothers and sisters. And she was 13 when he was born, and then she turned into his babysitter. And then, she hit adulthood, and he had a little bit of a problem with her being an adult and not just his cousin Jade. So they fought like brothers and sisters, and there's just. It's really hard for me, like I said, because we have a small family, and my husband and I had our son late in life, and we don't have a lot of other relatives, and she was his only cousin, and he's not going to have her now later in life the way I've had my sister. Like, I relied on, and she watched out for him. She could put him in his place like no other, and just it kills me that I know that he's not going to have that anymore. And
have you seen that actually affect your son?
Oh, definitely. Our entire family has gone through therapy. He had a lot of problems right when everything happened in school, just with behaviors. And it's impacted every single day since it happened.
prior to this, was your sister, family unit happy?
Oh, yeah, definitely. I mean, we were, you know, my husband and her husband are good friends. She and I are best friends, and like his children, like we all were just beyond just a happy, like I said, happy but boring, normal family. And there's just, I think somebody mentioned Jade's light, and that light's gone, and there's a dimness over our entire family that I don't ever see us getting back.
Can you describe, put in words, what you have seen this do to your sister, to Jade's mother, Ivy's grandmother?
It's just destroyed her. When she talked about Jade being her life, she was her life. They talked every day. And aside from the fear and the hurt I know she has, I've lived with the fear of like, is she going to be able to get back at us? And thinking about my sister not being here because she can't live without her daughter has been probably one of the hardest things that I've sat and just prayed and hoped that she is strong enough and will be strong enough, because I can't imagine. I look at my own child every Mother's Day and feel guilty that he's still here, and my sister doesn't have her little girl anymore.
Thank you, Ms. Moran. No further questions.
Hang on just a moment. Question?
No question.
All right, thank you. You can have a seat. Who's the next witness?
Ms. Browning.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes, I do.
Ms. Browning, could you please state and spell your name for the record?
Yes, it's Andrea Browning, Anderea Browning.
Ms. Browning, what was your relationship to Jade?
She was my bonus daughter.
When did you and Jade's dad get married?
2009.
When did you first meet Jade?
She was about 7 years old, which is how old my daughter is now, our other daughter, Ava.
And can you walk us through Jade's early life?
Yeah, she was a little spitfire. The first time I met her, I'll never forget, because the light everybody keeps talking about, it's so obvious. And I was just, this girl was so full of life and so full of confidence. She always had a smile on her face, and she was always ready for anything. And she adored her dad and her family. She just, you could see it all over her face, and her body, her whole body lit up.
And Ms. Browning, do you have another daughter?
Yeah, Ava.
How old is Ava?
Ava's 7 now. She was 3 at the time.
And can you describe Ava and Jade's relationship?
Yeah, that's tough because, you know, like I said, Ava has Down syndrome, and so she's developmentally delayed, and she didn't know Jade because Jade was in Arkansas when Ava was born, and it was also during COVID, and we were taking lots of precautions about who we were exposing her to. And she finally met Jade in, I believe it was 2021, and they looked into each other's eyes and knew that they were sisters. There was a connection immediately. Like, it was really eerie, but also amazing at the same time. But having her here was so great for Ava because she got to know her last year. And also the toughest part about it was that. That's it. That's all Ava gets of her was just that 1 year when she was 3 years old.
And what impact have you seen on Ava's life since losing Jade?
It's tough to tell her because she doesn't understand a whole lot about it, especially because she was so young at the time. But she's really into pictures, and she's always pointing Sissy out in pictures. And she asks about Sissy. She uses a KAC for communication. She just randomly hits Sissy on her words all the time. And it's got a little picture of Jade. And Sissy's always with you, so we can tell her and just keep explaining to her how great and wonderful her sister is and how much she loved her. And, you know, one of the toughest things I'll have to carry with that is that the Instagram post that Jade made that said being in Nashville, one of the best things about being in Nashville is getting to watch my sister grow and they will know her.
And can you tell us about finding out Jade was pregnant and how excited the family was?
I was so excited. I was initially shocked, and she could see that, and I think it was a short conversation, but we were automatically super supportive of her and super ready to do anything and everything, take her shopping, help her with decorating, help her with anything she needed help with. I mean, I had just become a mom myself not that long ago. You know, we talked a lot just about, you know, whatever you need, we've got you. And she didn't ask for much. She had a whole bunch. She knew she could do it. She's got all the confidence in the world.
And the jury has heard a lot about Jade's support system and how many people showed up to Vanderbilt and how many people took action that night. Can you describe for the jury Jade's support system, how many people she has here today, and what it's done to her friends?
I can't even begin to describe it because, like I said, she'd only been here a year and she was surrounded by people that were local, like at the end. I mean, obviously everyone from Arkansas came down, but the amount of people that came there that were not from Arkansas, that were there because she made an immediate impact on them, and they loved her so much, and they knew that this was going to be a huge loss to everybody.
And can you walk us through that night of February 25th and how you found out and how Jade's dad found out?
Yeah, I was actually asleep. I had a young child at the time. I had put her down a couple hours before, and I knew she was going to be up early, so I was sound asleep. And once I woke up, I saw the missed calls. And I was in such shock. I honestly don't remember a lot of, like, who called when, where, how. And I know Bridget had several missed calls from her, as well as Dennis. And as soon as I talked to Dennis and got to Vanderbilt somehow on my own, that drive was awful. I could barely even operate my legs because I knew there shouldn't be anything wrong with her.
And Jade was working at your brother's restaurant back in early 2023.
Right.
Can you describe the impact that her and Ivy's death has had on your brother's staff, your brother, just the restaurant as a whole?
Yeah. It was devastating. It's been really hard to watch my brother because he hired her. I mean, he didn't even hire her. He recommended her to the head chef, and it was a no-brainer for her to hire Jade. You know, he just got her the interview. But everyone at that restaurant, and that's the biggest thing is they knew Jade was not doing anything she shouldn't be doing. And they were always telling me that. How great she was taking care of
Maybe
all
a
the
jury
things.
approach. I'm sorry.
Okay.
Yikes, sorry about that white noise, guys. All right, so we are listening to victim impact statements, but they're being elicited through counsel. So it's kind of It's not like just somebody getting up there and reading.
All right, what's your next question?
It greatly devastated him. I could just leave it at that.
And Ms. Browning, is Jade's dad Dennis Browning?
Yes.
And can you walk us through the impact that Jade and Ivy's death has had on you and Dennis?
It's just been devastating, just knowing that Jade is only sister, and we know that she was always going to be around for her when we weren't, and it's ripped us apart. It's brought us closer together, but it's changed everything. We are very much more protective of Ava now, having experienced what we experienced, and I know that it's just changed everything forever for us.
Those are all my questions.
No question.
Thank you. All right, who's the next witness?
Ms. Bridget Burks. You swear the testimony you're about to give to be the truth, so help you God. Could you please state and spell your name for the record?
Bridget Benning Burks, BRIDGET, BENNING, BURKS.
Ms. Burks, who was Jade Benning to you?
My baby girl.
And was Jade your only child?
Yes.
How can you describe Jade growing up and her light?
As soon as she walked in the room, you knew, because she was so full of life. She's known for being very loud. She got in trouble several times for being loud. So you knew her presence, her laugh.
And Ms. Burks, does Jade have a stepfather?
She does.
Okay, and what's his name?
Lynn Burks.
And when did Lynn Burks come into Jade's life?
She was 6.
And can you walk us through the impact that Jade's passing and Ivy's passing has had on you and Lynn?
We also have 2 boys, and so it just makes it harder, makes us worry more about our other 2 boys. That was his baby girl. You couldn't tell him any different. And it's just a void that will always be there.
Is your day-to-day life different without Jade?
Most of the time. People ask, are you okay? And I always say yes. But behind closed doors, I'm not.
And did you and Jade talk almost, if not every single day?
Yes.
And Ivy would have been your first grandchild?
Yeah.
Can you walk us through the impact of losing Ivy?
Well, I'm the youngest of all my friends, and I'm the only one that didn't have a grandchild. So I was excited to be able to say I'm a grandma now. I'll never get that opportunity because it was taken from me.
And is there a day that goes by that you don't think about Jade and Ivy?
No, every day.
Any other witnesses from the state?
No, Your Honor.
Any proof on behalf of Mr. Taylor?
Yes, Your Honor. Very, very briefly, I would actually call Detective Adam Reese, who I believe is in the court.
Okay.
Detective Reese, as part of your investigation in this case, did you pull criminal history reports on Mr. Blaise Taylor?
Yes.
Do those include NCIC sort of nationwide background checks?
Yes.
In your investigation of criminal history on Mr. Taylor, did you find any prior criminal history?
No, I did not.
Thank you. That's it.
Any questions?
No.
Okay. All right, who's the next witness?
Your Honor, we would call Evie Taylor.
Okay.
Do you swear that the testimony you're about to give to be the truth, so help you God?
It's Dr. Taylor, right?
Yes.
Dr. Taylor, can you please state your full name and spell it for me?
It's Evelyn Taylor, EVELYNTAYLOR.
And Dr. Taylor, what is your relationship to Blaise Taylor?
He's my son.
And how many children do you have, Dr. Taylor?
2.
And is Blaise your older child or younger child?
He's my oldest.
And how old are your 2 children?
30 and 28.
So, Mr. Taylor is how old?
He's 30.
Where do you live, Dr. Taylor?
I live in Texas.
Can you tell us a little bit about who Blaise Taylor is?
Yes. He's the best son I could ever ask for. He's a loving son, a loving brother, a loving grandson, a loving nephew, a loving friend. He's never given me any problems. All throughout school, he was an A student. He was always the teacher's pet. In fact, his kindergarten teacher still keeps up with them to this day. He liked to help other children with their schoolwork because it just naturally came so quick to him. And teachers would always comment about that. He loves sports. He wanted to follow in his father's footsteps, and so he played sports. Every time we moved, he made a lot of friends. He was team captain and leadership. He was a team leader. A lot of the parents would come to me and tell me that how much respect they had for him. He was a good student in the classroom and in sports, and he was the type of boy that they wanted their children to hang around because he was never getting in any kind of trouble and was very respectful.
Where did this? I'm gonna interject for a minute. Where did Mr. Taylor grow up?
We lived all over. He was born in Texas, but because of my husband's profession, we move every few years. So we lived in Texas. From there, we went to New Mexico, and then Louisiana, and then Tennessee, then Oklahoma, and then Alabama, and then Arkansas.
And is it fair to say sports are kind of a big deal for your family?
Yes.
So you mentioned he was very involved in sports. What sports specifically was Mr. Taylor involved in?
Well, his favorite sport was football.
And that's real big in your family.
Yes.
Right? When did he start playing football?
When he was 5 years old.
And how long did he play?
He played through college, and then he got an invite to try out for the New Orleans Saints upon graduation or after his senior year.
And he ended up not pursuing it professionally?
He didn't make the team, the Saints.
How did he, let's start with high school. How did he perform in football in high school?
He was a team captain in high school, one of the leaders on the team. He actually graduated early. He graduated a semester early so he can go to college early.
And you mentioned a little bit about his grades while he was team captain and playing football. How were his grades in high school?
All A's.
And then where did he end up going to college?
He went to Arkansas State University.
And I think we heard a little bit about that during the trial. Did he play football in college also?
Yes, he played football in college, and he actually graduated with his bachelor's and his master's degree in business in 2.5 years. He was the first college football to ever. He was the first college football player to ever do that. And while he was there, he started a nonprofit, the Power 102. He's very passionate about helping children in underserved areas and communities. And so while in college, him and his sister co-founded that nonprofit. And they just did a lot of community events for those children, mentored them. He was a big brother. He volunteered at the alternative school. And his senior year, I think he went like 3 times a week.
Does that nonprofit still exist?
The nonprofit still exists. They've actually given almost like over $90,000 in scholarships. They help each year. They do school supply drives for kids in underserved areas. They do Thanksgiving baskets and adopt a kid for Christmas for children that don't have resources to get presents for Christmas. Pretty much whatever the needs are wherever we live in the community. They just try to serve those children and just meet their needs.
And you said Mr. Taylor's sister was involved in that as well?
Yes. So if you talk to his sister Star, she'll say that he's her role model. She followed behind in his footsteps, and she's an A student as well. And if you ask her why does she make A's, she'll say because Blaise did. Why do you play basketball? Because Blaise did. From the time she was little, he would help her put her shoes on the right feet. When I was her coach, she would be looking at him, and even though he was only in junior high, she valued his opinion and wanted to hear what he was saying, what she can do better, how she can improve, whether it was in the classroom, whether it was with sports, whether it was trivia things or whatever. Whenever she needed advice, she would say that she would go to her brother.
And is Blaise's sister here? Has she been here?
She is. She has been.
Is your family close?
We're a very close-knit family. When we move a lot, we know we have each other, and then every time we move, we make several moves that we always find like adopted families wherever we are. Usually it's through sports, kids under sports teams, and then they become a part of our family.
I know that this process has been very hard. Does Mr. Taylor have support still from your family?
Oh, yes. He has support from our family. We have family members here. It's just hard because we're not from Tennessee. And we've had lots of different moves of people that we're close to are in various states across the U.S.
So when Mr. Taylor started working for the Titans, which we heard a bit about, he was in Tennessee and you were still in Texas?
No, we were in North Carolina at that time.
You were in North Carolina. Okay. Did you have an opportunity, did you keep up with sort of how he was doing at work?
In work, yes. We talk regularly, and football's a big part of our family. That's what his dad does, so we have lots of conversations about work.
What's your impression of Blaise's work ethic?
He has really good work ethic. you ask anybody that knows him, that's one of the characteristics they'll say. He's a hard worker. He's always on time. He'll be one of the first ones there. He's going to make sure that he gets the job done. He has a really good work ethic in everything he does, whether it was his schoolwork, an actual job where he's getting paid, whether it's a non-service. He always goes above and beyond.
Okay. How about, are there any other, we talked a little bit about the nonprofit, are there any other kinds of community involvement or examples that you can think about from Blaise's life, either recently or longer ago, that you can tell the jury about?
Well, he has a servant's heart, so he does a lot of community service. Usually wherever we live, like with his dad, the football teams usually do community service, so he can be involved in various things that they do. I know one thing, like when he was in high school, where he was actually old enough to make a decision to do those things, he was really involved with the Miracle League. And so that's something he did throughout high school, with big brother type programs, mentoring younger children. He would do that. And then when he was in college, he just did a lot of community service, like I was telling you about, like for his nonprofit. But it was primarily through being a big brother and volunteering at the alternative school. So being a mentor, he had a little brother that was assigned to him, and he would bring him to football practice and let him watch. He would go to school and help him with his homework and do things of that nature. And then when he volunteered, I believe it was a third grade classroom at the alternative school, he would just encourage them to do their schoolwork, to respect their teacher, and if they made their points for the week, he would come and he'd bring teammates, and then they would play dodgeball and things like that. And if they had a good week and a good report, he would let them come with him to, or he'd get tickets for them to come to the football game. And he was really involved with the community baskets, and we would do community Thanksgiving dinners. I think one of the things that I'm most proud of Blaise for was one time when he was in college, we were in church, and they were doing baptisms. And I didn't know this because he didn't tell me this. I'm just watching the baptism, and all the people come up and give testimonies, and it was a young college girl, and she said, I just want to thank Blaise because he really shared about the Lord to me. And he was really instrumental in my relationship with the Lord and my baptism. And all the accolades that he had, like in the classroom or on the field, they were nothing compared to what I feel like he did for this young lady that said that she was a friend that just went to the university. And just the fact that he was instrumental in her being baptized, is those types of things that make me really proud of Blaise.
Dr. Taylor, one thing. Thank you, Dr. Taylor. I think that's all. Well, let me ask this. Is there anything else you think you want to share with the jury that I haven't asked you about?
You're all right. I would object to being that open-ended.
Okay.
And that's all I have.
All right. Any questions from the state?
No, Your Honor.
Thank you.
That is the defense's proof there.
Okay. All right. Ladies and gentlemen of the jury, if you'll step down the hallway just briefly, we'll talk with the attorneys about legal issues and then get you right back. You can have a seat. And just for the record, Mr. Bland, like we did the other phase of the trial, let Mr. Taylor step around and deal with his decision not to testify. If you raise your right hand and be sworn.
Do you swear to tell the truth, so help you God?
I do. Mr. Taylor, you understand that at the sentencing phase of the trial, you have an absolute right to make a statement to the jury. I do. You also don't have to say anything. You have the absolute right to remain silent. I do. And we have discussed that option and the pros and cons, and I want to make a statement at this point in time.
Yes.
And based on those discussions, you made the decision that you're not going to make a statement or otherwise testify.
Yes.
And that you're on the scene.
Yes. All right, he can have a seat. And then, Mr. Brand, in terms of the mitigating circumstances that I'd instruct the jury would be the defendant has no significant history of prior criminal activity. Set out the other mitigating factor raised by the evidence consisting of, and what do you contemplate the court instructing the jury there?
Trying to think of how to phrase this, Your Honor.
Right. I mean, excellent student.
I might. What if we said, community involvement, prior acts of service, support system, and educational and personal achievements? That maybe in the ballpark?
Community involvement, education, and personal achievement, and what was the other?
Acts of service.
Active service?
Acts of service.
Acts. Does the state care to be heard on that?
No, Your Honor, I think they come under the catch-all.
Okay, and I was planning on setting forth that catch-all about any other mitigating, but then consisting of and then listing.
Yes, Your Honor, I think that would be appropriate under the case law.
And then charge as to in terms of aggravating circumstances in counts 2, the murder was committed against a person less than 12 and the defendant was 18 years of age or older, and the murder was knowingly committed, solicited during the commission of the language there about another first-degree murder.
Yes, sir.
Accurate. And in 3, it would just be that felony murder type language.
Yes, sir.
And 4 would be both again.
Yes, sir.
Well, both
yes,
again. All right, anything further from the state in terms of jury instruction?
Not without having seen that.
Do you want 10 minutes before we come back with the closing arguments? And I can give you the draft.
Just want to make sure that I don't say anything that's not going to be on the in the charge.
Yeah.
Okay.
I would appreciate seeing the jury instructions, but we don't need much time.
Okay. All right. Good. Court. Just 6 minutes.
Court, a brief ministerial.
All right, now court's going to take a 6-minute break. which would get us to the top of the hour, to write up some instructions, I guess, for the jury. Then we're going to have opening statements, or no, I guess closing statements. I guess it would be closing statements, and then they're going to deliberate. Yeah, because they already had openings. We heard from 3 people. We heard from Jade's aunt, her stepmom, and her mother. So it was Brandy Moran. Brandy Moran was the aunt. She's Bridget's sister. We heard from Andrea Browning. She's the stepmom. We heard from her in trial. She testified in trial. And then we heard from Bridget Burks, who is Jade's mother. And then defense called Adam Reese, who was the lead detective. And he basically said he pulled a criminal history on Mr. Taylor. There was no prior history, which I think we knew. And then Blaise's mother came up, Dr. Evelyn Taylor. She testified. Blaise, so that was the mitigating circumstances. Captain of the football team, was involved in the community, got his master's, first football player in Arkansas, I guess, to get a master's. He started a nonprofit, et cetera, et cetera. So, we've asked this question before. Like, would you testify for your child, your brother, sister, your parent? Is that something that you would do if they did something like this? I asked that way back when, maybe a year or so ago. Like, what would you do? What would you do if that was your brother, your son? Wouldn't be your father, but it would be, be more your brother, your son, your cousin, your nephew. Would you get up there and say, he was such and such growing up, and I don't know what happened. I don't know. What would you guys do? She has a PhD. Do we know what's she a doctor in? Aaron knew here. I'll look it up. I can look it up. Let's see. We know his dad currently is the coach, running backs coach at Texas A&M. Trying to find out what mom. She has a PhD in something. Is it education? Yeah. Let me see if I can find it. All right. Is it Evelyn Johnson Taylor? Was that her middle name, Johnson? I think this is her. She has 3 decades of leadership in women's ministry, dedicated to guiding women through the various seasons of their life. Is that her? Dr. Evelyn Johnson Taylor. I think that's her. I think maybe it's in ministry. 40 years in ministry. Is this her? Oh, here about. Let's see her story. Maybe is this her story? Doesn't say anything about. Oh, my late husband. Okay, I don't think this is her. Well, if her middle name is Johnson, but then it says her late husband. So it's not her. I mean, they're still married. What are they doing? Being cats.
No.
Oh, she actually spoke. Apparently she spoke 2 years ago. Oh, no, wait, sorry. Oh, wait. Mom spoke too. Hold on. Oh, there she is. Oh, wait a minute. Okay, hold on. Do we have a minute or two to watch this? She's a social worker. Auntie, she's a social worker? Okay. So she's a social worker. All right, thank you, Auntie. Apparently she's a social worker. All right. All right. Thank you for that.
Yeah.
What's that say? Social worker? Okay. All right. She's worked as a therapist in mental health.
She's a kind of a combo of both.
Okay. So she's worked, she's a social worker and has worked as a therapist. All right. Elaine says she has a doctorate in education. Or is she a therapist? Does it say anything about doctorate in education? Yeah.
No, get out.
Cats being cats.
I'm trying to record something and she just won't go away. Stop.
She's over here now.
Yeah, look at you.
All right. So Judge said he'd be coming back at the top of the hour. So now we have to go through the next phase, which is the sentencing phase. So we had guilt phase, and now we're going through the sentencing phase. So it took them 2.5 hours to come back with the guilty. How long do you think it'll be for for penalty? Let's see what. How long do we think the jury was going to deliberate today? 525 votes so thanks for that. 2 to 4 hours, 35%. 4 to 6 hours, 28%. All day, come back tomorrow, 26%. 0 to 2 hours, 11%. So those that chose 2 to 4 hours, which was the majority of you, 35%, it was 2 hours and 35 minutes. So kudos to you. Pat yourself on the backs. Good job. So now we have penalty phase. I guess we're getting bonus coverage. Now we get a penalty phase. We'll see how long they take to come up with a penalty. Yeah, with only 3 counts and only for life without parole, I think it'll be a quick decision. Yeah, I think so too. I'll put up a poll. We'll put up a poll. Let me see. Let's put up a poll for those that want. Let's see here. Let's see. All right, how long will the jury deliberate for in the penalty phase? I'll do 0 to 1 hour. 1 to 2. 2 to 3. Yeah, we'll do 3 to 4. Why not? All right, 0 to 1, 1 to 2, 2 to 3, 3 to 4 hours. How long will the jury deliberate for in the penalty phase? All right, we got a new poll for you. New poll for you, chat. All right, we got a new poll. Is he their only son? Yes, Jane. Yep. Yeah, it's yeah, they have a son and then a younger daughter. I think they said 30 and 28. I think the daughter's 28. I think I heard her say. 2 kids, younger daughter. He's the oldest. So they have, thank you, Muggsy, for the flow state. Whoop, whoop, new poll. Yes, whoop, whoop. Thank you for the flow state. Appreciate that. Camilla, you chose the longer so you won't jinx it. Kimber saying, thank you, Muggsy, for the flow state. Linda, I voted for the last one, so it will come in quick. I voted it would take into tomorrow as well. I did not think that they would come back that quick. But I said Hildebrand would come back in like an hour and a half. I went 1 to 2 hours, and I was way off on that. So don't listen to me when it comes to polling. I clearly have no concept. Debbie, thank you for the 5 trial TV Live gifted memberships. Thank you so much. Sue spontaneous. Nice. Anybody, did we get anybody? Dirty Dog? Crescent Moon? Charisma? Anybody in chat? Anybody in chat? Shandy, how are you? Good to see you. Kaylee, yeah, the same. I did not think Hildebrand. I thought Hildebrand would be like hour and a half. That one surprised me. That one surprised me. And this one surprised me too. I honestly thought that they would take. I thought they would take at least like 10 hours. I figured they would take at least 10 hours. Laura, you're always wrong with these polls. Yeah. Muggsy, I voted for verdict tomorrow, so I vote now 0 to 1. Right? What did I vote? I just voted. Did I do 1 to 2 hours? No, I think I did 0 to 1 hour. I can't remember what I just voted. I literally just voted, and I can't remember. Cutie Pie, how are you? Welcome in. Thank you for joining us. 4 more likes till we hit 400. I see 346. Well, let's see if we can get up to 350. Can we get up to 350? Let's start small. Let's start small, and then we'll go from there. Can we get to 350? If you are listening in and you have not hit the like button, take a moment. Just take a moment and see if you've hit the like button or not. See if we can get up to 350 likes. We currently are at 346, 347. If you're listening in, just take a moment, check to see if you had hit the like button or not. Nice to see you, Cutie Pie. Thank you for joining us. Have you hit the like button? Has everyone hit the like button? 348. All right, we got 2 more. 2 more. 350. Awesome. Thank you, guys. All right. Good job. We got to 350 likes. Give yourself a pat on the back. 351, even better. All right, let's see. Ronnie hit the like button. Thank you, Ronnie. 356. Good job. Good job, guys. Thank you. Iowa Backyard Cam, we are at 356 now. 356. You tried to, let's see. Muggsy tried to like it 2 times. Hello, Super Ball. Super Ball doing a cruise by. All right. Thank you, Cutie Pie. You hit the like button before you came into the live. Appreciate that. Thank you. Thank you. Oh, we're at 3. You see 358. I see 357. I see 357. All right, judge is back on the bench. Time to get serious. Judge is back on the bench.
In the jury instruction.
No, Your Honor.
Mr. Brown. Okay. All right, let the jury step down. All right, you have a seat. All right, any closing argument on behalf of the state?
Yes, Your Honor, thank you. Members of the jury, we're down to just about the last decision you'll have to make. And that is, what is the appropriate punishment in this case? I want to start out by saying that yes, the judge will tell you that a life sentence in the state of Tennessee today is 51 years before parole eligibility. That's a long time. It's a really long time. But contrary to what Mr. Brand said about life without parole being the harshest penalty, the harshest penalty wasn't asked for, the death penalty. So there are 3 punishments for first-degree murder in the state of Tennessee. One wasn't on the table. Life without parole is the next step down, and life imprisonment is the minimum sentence for first-degree murder. The state submits that while there might not be a quantitative difference, who knows how long someone is going to live, but there is a qualitative difference. That is, what does the crimes that you have found Mr. Taylor guilty of, what do they deserve? And you can consider, submit by your verdict, where you mentioned this, you found the aggravating circumstances by your verdict beyond a reasonable doubt. That then allows you, and Judge Dozier will read the instructions, not nearly as long as the first one, that upon that finding, you can consider victim impact testimony. What this man's actions have done to the people who loved Jade Benning and would have loved Ivy and did while she was in the womb. She never got a chance. She never got a chance to know how much she was loved. Mr. Taylor, the judge will tell you, consider mitigating. Yeah. Before this, he had no criminal record. that doesn't mean he is not deserving of life without parole under the facts of this case. And again, going back to everything that you heard during the trial, Apple Denny. Apparently, Mr. Taylor was fine with helping out other people's children. He was a good student. No doubt about that. Very smart man, comes from a very well-educated family. A good athlete. Community service. And like I said, good to other people's children. Not his own. That qualitative difference is that life without parole, the state submits to you, is the appropriate punishment. And you'll really have to decide that and come to on each count. But it is your decision, your collective judgment. There's no, oh, we have to prove this, we have to prove that. Once the existence of an aggravating circumstance is before you, and here we have two, then it is your call. And one of the things, victim impact, and you've got, certainly, his parents didn't raise him to be like this. But the decisions that he has made were his and his alone. His family choose to do so. Visit him. So long as he is alive. Talk, communicate, whatever. Because there's a saying, where there's life, there's hope. He's going to be alive. He's going to have hope. He's going to have that sense of living and associating and being, granted, not an environment that any of us would want, but it's of his own choosing, his own making. Jade and Ivy's family never have that opportunity. He took that from them 3.5 years ago. February 25th, 2023. He took something that no one is able to give back. And for that, on behalf of the state of Tennessee, submit that whatever hope of freedom that he should have, he does not deserve, and that he should not receive the minimum punishment for these offenses. Thank you very much.
Any argument on behalf of Mr. Taylor?
Thank you. Life imprisonment is an appropriate punishment for Mr. Taylor. And punishment is what it is. It is not a minimum get off easy kind of sentence. It is life in prison. 51 calendar years at best. That's if you make parole at 80, if he's 30 right now. Yes, in opening I said it's the harshest you have is life without the possibility of parole, and there is death penalty, but this isn't a death penalty case. We knew that at the beginning. It's the harshest option you are considering today. And life imprisonment is incredibly harsh. Living in a concrete box
for the next 51 years. That is punishment. He's not getting off. He's not getting off easy. You're not letting him go. He's not walking out of this courtroom. Likely for the rest of his life. Now, looking at the jury verdict, it occurs to me that maybe there is some consideration from the jury that you all think Mr. Taylor intended to kill baby Ivy and maybe didn't have the intent to kill Jade. But he knew he was killing her, or some version of that. Obviously, I'm not in the jury room. I don't know if that matters in your deliberation for this part of it. But if we're talking about what are the worst of the worst of the worst crimes that you get the worst of the worst of the worst punishments, this was a long, incredibly detailed, complicated trial, and you guys heard a lot. You can consider all that when you're making your determinations. The reason that we put on some proof about who is Blaise, what was his family like, what's his upbringing like, what's his community involvement like, is there's kind of a, I don't know if it's a saying, it's something that's talked about in work when you defend someone sitting at that table, that we are more than the worst thing we've ever done. We're people. Blaise is a person. He's got a family. He had a great childhood. He did well in school. He was an all-star athlete. Yeah, he did something horrific. Nothing that can happen here is ever going to change that. Nothing. And he's going to spend the rest of his life in prison no matter what. So you all can go home and rest assured that no matter what you do here today, he's going to spend the rest of his life in prison. It doesn't require life without the possibility of parole to send that message, to send that punishment. It's not either we let him off easy or we have to punish him the worst of the worst of the worst of the worst. He's being punished. He's getting the message. But he is not someone who has spent his entire life as a criminal. He is someone who's had a good life, who's done good things. I don't have anything to say about it. Did something terrible. There's, let's call it what it is. When you hear the jury instructions, there's going to be a lot of talk about aggravating and mitigating factors. And I said this in my opening, and I'll say it again. If you find aggravating factors, you don't have to find that he gets life without the possibility of parole. It's just something you can consider. Life imprisonment is punishment. It's life in a box. It's life in a prison. It is a message. It is a lot. It is enough. And we would ask you to return for your sentencing that be the appropriate sentence in this case.
All right, any rebuttal from
just very, very briefly, it's time to have this jury determine, does he deserve the minimum allowable, or does this crime, these crimes, Mr. Brand argues this is not the worst of the worst. What could be worse than killing your own child and your own child's mother? That is my life without parole. Is an option in this case, and is an option the state of Tennessee would respectfully request you consider and return. Thank you. Thank you, Your Honor.
All right. Members of the jury have now found the defendant Blaise Taylor guilty beyond a reasonable doubt of murder in the first degree as charged in counts 2, 3, and 4 of the indictment number 2024A490. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of a murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravated circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the sentence only if you first find the existence of one or more aggravating circumstances as has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence. Count 2. Statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1. The murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. And 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempted to commit any first-degree murder. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider as previously indicated any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. The defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. Count 3, the felony murder involving Jade Benning, statutory aggravated circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravated circumstances, which shall be limited to the following. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting to commit, or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder. The definitions of knowingly, intentionally, which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether imprisonment for life without possibility of parole would be an appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspects of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. Count 4, felony murder involving the victim, the unborn female child of Jade Benning, statutory aggravated circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravated circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Definitions of knowingly and intentionally which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether the imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that In arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity. 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you should place no significance on this fact. The burden is on the state to prove any aggravated circumstance or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. You will be provided a verdict form consisting of 6 pages. You have 2 sentencing options to consider on each count, and you are not required to deliberate on these sentencing options in any particular order. The options are as follows. Verdict, life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravated circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory circumstances or circumstances proven by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravated circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. Here on the verdict form, you would list the statutory aggravated circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. You will be provided with a form for all possible sentences in this case. The jury will check the appropriate verdict on the form for each count and complete the form as directed, and each juror will sign the verdict form. The other forms are to be left incomplete and unsigned. Your foreperson will preside over your deliberations, and when you have reached a verdict as to the sentence, you will return to the courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the charge in this case is herewith handed to you, together with the verdict forms for the punishment for each count and the exhibits. You may now retire and consider your verdict. You can step down the hallway with the court. Anything further from the state?
Judge, I know that there need to be a hearing, sentencing hearing. I don't know if we had a date, we might also be looking at our calendars.
Yeah, in terms of merger and count one, and whatever happened.
Yeah, sure. And
we can look at like the week of the August 3rd, like the 5th maybe, or somewhere around there. Discuss that.
Yes, that's all.
Anything further on the jury charge, Mr. Grant?
No.
Okay. All right, we'll need a recess.
Court to the recess.
All right. Here we go again. Verdict watch.
Oh, yes, that is the word.
Verdict watch number 2 for this trial. Starting at 5:40 local time, or our time, sorry. 5:40 our time, Eastern.
So if for some reason,
I'm going to ask to go further than August 5th. I think I can't imagine.
there's a TS research report.
I'm going to say like September earliest, maybe? Is that crazy? Are we really rushing for this? Is that like...
Yeah, we just... That's why I was asking, did you get a confirmed date? So
that's what I mean. I mean, we're not in a rush, right? Like, we don't have to
if we could do it in August, I think that would be our preference.
Hey, that August 15th, if he gets a little bit overzealous, they need like 50 days or more. They're like stacked.
That's kind of what we're thinking that for.
Yeah. It's like, and I was like, man, they just asked for 45 days like 4 weeks ago. So now they need about like 30 days. Yeah. So I was like, let's see what
What happens if the jury can't agree on sentence? I don't know. I've never seen that before. I really don't know. I I've never seen that before. I really have no idea. Serious hot mic, but I can't really hear anything. No, we are not used to 2 verdict watches in one day. Renee, let me look it up. Let's look that up. Why not, right? Let's Google it. What happens if a jury All right. This is from DP Information Center. If a jury cannot reach, and this is not a DP, so let me just put that out there. This is not a DP. If jury cannot reach unanimous verdict during a capital sentencing phase, again, that's capital. I'm still talking. The outcome depends entirely on the jurisdiction. That would be automatic life sentence. So we've seen that before. All right, sounds like they're still talking. We've never seen that before. I mean, they have to come up with something. They can't. Maybe it goes to the judge. Maybe if they say, "Hey, we can't decide," maybe it goes to the judge. Maybe then the judge decides. I really don't know. I'm really not sure. Still talking. All right. Oh, you know what? We wanted to say, what are they going to come back with? All right. I'm going to end the poll. How long will they take? And we'll do what will they come back with. We can do that. Let's do that. Hold on a sec, well, let me just copy and paste this. Judge will declare mistrial in the sentencing portion only. The prosecution may then choose to impanel a new jury to hear arguments and decide the sentence. Where's that information coming from? Is that where's that info coming from? I mean, he's going to be in jail regardless, but where do you know that? Just let me know where you got that info, so that we can. Because I've never run across that before. I've never experienced that before. So where did that come from? All right, let's do. AWOL looks that up. I'm going to get a new. Let's get a new poll. What will they come back with? New poll. All right, so it's life without parole, right? It's life with parole. Life is life with parole after 51 years. Was there anything else? I think that was it, right? I think it was just those two. I think it's just those two choices, right? It's either life without parole or life with parole. Am I correct in that? I didn't hear any other. Oh, they're still talking. They're still going. The internet. All right. Yeah. Find out. Give me a source. Thank you for that. Right. It's only life without parole or life. I think that's it. Right. I think these are. I think it's just those two, right? Yeah, JMS. I think it's just those two. They have no other. It's either life without parole or life with 50 after 51 years. All right, and we'll throw in hung. Why not? I'll just throw in hung just because I have that option. All right. All right. New poll for you: life without parole, life with parole after 51 years, or hung. All right, so new poll for you guys. New poll for you, chat. And the other poll, let's see, Brat posted something here. What's Brat say here? All right, Tennessee Code criminal offenses. Brat pulled out specifically, except as provided, no DP or sentence of imprisonment for life without possibility of parole shall be imposed, except upon a unanimous finding. All right, we know that. Should the jury find the defendant guilty of first degree, it shall not fix punishment as part of the verdict, but the jury shall fix the punishment as separate sentencing. Okay, we know that. All right, this is the Tennessee Code. I'm reading from the Tennessee Code here. Tennessee Code Title 39. The separate sentencing hearing shall be conducted as soon as practical before the same jury that determined guilt. In the sentencing proceedings, the attorney shall be allowed to make opening statements, which we saw in the sentencing proceedings. Evidence may be presented. All right, we saw all of that. In the sentencing proceeding, the state shall be allowed to make a closing argument. After closing arguments in the sentencing hearing, the trial judge shall include instructions. All right, we saw all of that. Jury shall be instructed the defendant who receives a sentence of imprisonment for life shall not be eligible. The jury shall be instructed. Okay, we saw all of that. If the defendant has been found guilty of first degree as described and the jury unanimously determines that no statutory aggravating circumstances have been proven, the sentence shall be imprisonment for life. Okay, so now I guess they have to decide if there are no statutory aggravating circumstances. I guess that's what they have to really decide. According to the Tennessee Code, if the defendant has been found guilty of first degree, which he has, and the jury unanimously determines that no statutory aggravating circumstances have been proven by the state, the sentence shall be imprisonment for life. The jury shall return its verdict to the judge. All right, so if the jury unanimously determines that no aggravating circumstances have been proven. So it boils down to if the state proved aggravating circumstances, and those were under 12 years old and over 18. So all they have to do is decide, was Ivy under 12 years old? Yes, she was. Was Blaise over 18? Yes, he was. All right, so what were the... So murder committed less than a 12-year-old, less than 12. Ivy obviously was less than 12. He knowingly committed it. I think they're going to come back with life without parole. Based on that, just based on that, that's going to be life without parole. All they have to do is, was Ivy under 12? Yes, she was. Did Blaise knowingly commit it? Yes, he did. The way I'm reading that, what's Brat say here? Hold on, Brat, let me pull that up. If after further deliberations, the jury still cannot agree as to the sentence, the trial judge shall dismiss the jury and the judge shall impose a sentence of imprisonment for life. All right. The way I'm reading it also, all they have to do is determine if the state proved beyond a reasonable doubt that no aggravating circumstances were proven. And the two aggravating circumstances was that Ivy was less than 12 years old, which of course she was, and that Blaise knowingly committed it. Those were the two aggravating factors. So sounds like it's going to be life without parole. Sounds like it. JMS should be life without parole, like the prosecutor said in rebuttal. He deserves that for eliminating two people, one the mother and one of his unborn baby. Well, we have to go by the law. We have to go by the law. Yeah, they're still in there. They're not going anywhere. There's still people in that courtroom. All right, we'll just stay here. So the way I'm reading it, the jury has to review the two aggravating factors, which were Ivy was under 12, check. Blaise knowingly did this, I think, check. I think you can't you can't say that he didn't know what he was doing. It's not like, oops, I didn't mean to put that in, I didn't mean to put that liquid in your drink. You know what I'm saying? I think this one's going to be quick. I think this will be under an hour. I think this one will be under an hour. So, all right. Thank you for that, Brat. Oh, that's for the DP cases? All right, that's for DP. All right. Well, keep searching. See if you can find where that was. Here, let me do it over here. Well, I won't do it over there. I mean, yeah, we could keep searching, but I think it's going to be, the point is moot. I think the state proved those two aggravating factors, at least based on the codes here. This code from Tennessee Code. Yeah, I was trying to find like a some kind of memorial service for Jade. Maybe let me try and find see if I can find a grave. I think unfortunately that's what it's called. Oh, here's a dignity memorial. All right, let's look at this. Let's check this out while we wait. Unfortunately, I cannot scroll. I hate when they do this, where you can't scroll. I don't know why they do that. I'd like to show you her memorial page. Unfortunately, I cannot. I'm not able to scroll through this. Well, I'll read it to you. Hear what I can do with this. I'll do this. All right. Jade Tristan Benning, March 6th, 1998 to March 6th, 2023. On March 6th, the world lost a bit of its light in the passing of Jade Tristan Benning, the 25-year-old resident of Nashville, Tennessee, who was born March 6th, 1998 in Little Rock, Arkansas. A graduate of Little Rock Central High School, 2016, Jade spent much of her early years involved in cheerleading. She was very athletic and started cheer at age 7 at Cheer City United. She would later become cheer captain at Horace Mann Middle School, then on to captain of JV and varsity at Central. She brought that same discipline and dedication to her passion for cooking, graduating in 2020 from Brightwater Culinary Arts. Jade spent her career in roles as head pastry chef at Mirabella's Table and chef at Ernest Bar and Hideaway, and her catering business, JTB Eatery. To know Jade was to love Jade. She had a smile that would light up the room, a laugh that was contagious, and a heart that loved everyone. Well, there were a few exceptions. That was in parens. In addition to her passion for cooking, she enjoyed taking time to travel as much as possible. She loved her tattoos, music, and a good Netflix series. But most of all, she loved spending time with the extensive group friends and family who got to share her warmth over the years. Jade was preceded in death by her maternal grandmother, Susan Benning, and her paternal grandfather, Joe Browning. Services were held March 25th, 2023. That's Miss Benning. Still talking going on there. William Pisces, your date of birth is March 9th. Christopher, the next case, I don't know. I'm not quite sure. I was kind of checking during verdict watch there, and nothing's popping up right now. So we're not quite sure. Not quite sure. We're going to be looking over the over the weekend. We'll be checking the dockets. Peanut, welcome in. How are you? If a jury in Tennessee cannot reach a unanimous decision on life without parole or life in penalty phase, judge dismisses the jury and sentences life. Judge cannot sentence to life without parole in this case. So he goes down. It's kind of like in the DP. It sounds like it's like DP where they go for the lesser. That's like with DP. They go for the lesser. It sounds like they go, like with DP, if you can't decide, then they go for the lesser. Christopher, you'll be here either way? Right on. All right. All right. So that's Jade Benning. Yeah, I'm not sure what our next one is. I know we have something lined up. It's a 6.5 hour stream. We were going to save it for Friday because court would be off because it's officially the July 4th holiday for us here in the United States. But now since we're ending here, we'll show it tomorrow. Maybe we'll do an ego. We haven't done an ego takes the stand. Maybe we can do that on Friday. But tomorrow we're going to look back at Becky Hill and Alec Murdoch because he had a hearing for a new trial earlier this week. So we're going to look back on the saga of Becky Hill and Alec Murdoch. So that's going to be tomorrow. Brett, yep, it's just like the DP decision, only between life without parole and life. Yep. So if a jury can't decide, then the judge goes to the lesser. That makes sense. There are some phenomenal trials coming up in August. Some phenomenal trials. Absolutely. Yep. There was a hearing today for Tupac, right? That's what you were doing today? The Tupac? Yeah, there was a hearing today for Tupac. Maybe we'll do that. Maybe we'll do a deep dive on Friday of Tupac. We might do that. We could do that on Friday. It's either Ego or Tupac. We'll see how much info we can get. So, Bama, you love Ego Takes the Stand? Yeah. Laura, yes, the jury's now deciding the sentence. That is correct. Let's see, I'm trying to find something on Jade, something more on her. I was trying to find like a video, like a memorial of her. Oh, here's something. All right. All right, I think we saw this. I think we already saw this, but you know what? Let me look at this again. All right, I think I want to play this. Hold on. I'm just trying to find, just bear with me. Her friends spoke about her. I know I showed it during our deep dive, if you will. Oh, maybe it's this one. I think it might be here. I think it's Lauren Weber Talks. Yeah, okay, here it is. This is the one I want to show you guys. All right, check this out. We watched this before, but we'll watch it again.
A former Tennessee Titans scout is accused of poisoning his pregnant girlfriend. 27-year-old Blaise Taylor is awaiting extradition to Nashville to face charges on 2 counts of murder. Jade Benning's unborn child died 2 days after she was hospitalized last February, and Jade died on her 25th birthday last March, just a few days later. As News 2's Kenley Hargett reports, Benning's friends are remembering her 1 year after her death.
To know her was to love her, and we're also glad that she was a part of our life.
25-year-old Jade Benning remains on the hearts and minds of so many people. Benning served as a chef at Ernest Barn Hideaway in Nashville's Wedgwood, Houston neighborhood, where she quickly developed a reputation for desserts.
A great dessert maker, so she would make creme brulee, and that is something that we refuse to take off of the menu because that was Jade's dish and we have to have it.
Her manager and close friend Lauren Weber says Benning would put her all into her dishes and even more into the people she loved. Weber shares a birthday only a few days from Benning, and to honor her memory, she has her birthday tattooed on her arm.
Birthday and mine are 3 days apart, so we were both Pisces girls, so we always hung out.
And inside the restaurant are 2 memorials of Benning that helps her restaurant family find comfort and peace.
We have a small picture of her that's right outside of the kitchen where she worked, and we light a candle for her every day. And then the employees that are here with me at the end of the night, we actually all blow it out together and tell her good night. We've got a picture by the server station where we see her all the time, and then we all have these bracelets that we wear as well.
Saying goodbye to Jade was hard, but it's remembering all of the happy times she brought to others that helps many who loved her find peace.
She was the glue that basically held all of us together.
Reporting in Nashville, Kenley Hargett, News 2.
U.S. Marshals took Taylor into custody near Salt Lake City. He had recently been on the football staff of Utah State University. Investigators say Taylor called 911 the night of February 25th of 2023 to report Jade Benning having an allergic reaction.
All right. So Lauren Weber did testify. When did she testify? She testified day 2. Let's see. Yeah, they still got the audio up. Laura says the restaurant Jade worked at closed down. Which one? There were 2. There were 2. Was it? Do you know which one? Renee, yeah, I don't think he wasn't welcomed in the hospital. I'm sure he was not welcomed at any service. Debbie, she was very, very pretty girl, young woman for sure. All right, we're still here. They're still milling about. Nobody's leaving, so I'm thinking that they're thinking it's going to be, fairly quick. If you have not taken the poll, take a moment. We've got. What do you think the jury will decide? Life without parole, 69%. Life with parole, 51. After 51 years, 30%, and 2% of you think that it will be hung. 2% of you think that it will be hung. See if I can find any other videos. there's a ton of news on him. There's unfortunately not a lot of videos on her. Sadly, there's a ton of videos on her. I'm sorry, there's a ton of videos on him. There's just not much video on her. Sadly. Sorry, I'm just trying to look for anything else to check out on her, because I want to give Jade I want to give this time to Jade. What's up, Super Bowl? All right, here's a statement that that they put out. Let me just. All right, we, the family of Jade Benning and her unborn daughter Ivy, wish to address the recent apprehension and arrest of the suspect in their tragic murder last year. I'll probably make this bigger. The past 12 months have been an incredibly emotional and trying time for our family as we grappled with the loss of Jade and Ivy. Jade was a beloved daughter, granddaughter, niece, sister, cousin, and soon-to-be mother. She was a cherished member of the community and a dear friend to many. Her untimely death has left a void in our hearts that can never be lifted. We would like to extend our deepest gratitude to the professionals at the Nashville Police Department, the Prosecuting Attorney's Office, the Medical Examiner's Office, and the grand jury for their unwavering commitment and dedication in pursuing justice for Jade and Ivy. Their tireless efforts have culminated in this significant development, and we are profoundly grateful for their diligence and perseverance throughout this process. As we continue to mourn the loss of Jade and Ivy, we kindly request that our privacy be respected during this sensitive time. While we understand the public interest in this case, we urge all parties to refrain from speculation and allow the legal proceedings to unfold in accordance with due process. For any inquiries or requests pertaining to the specifics of this case, we kindly direct all parties to the prosecuting attorney's office for further comment. We trust that they will provide accurate and timely information as the case progresses. Jade and Ivy's memory will forever remain in our hearts, and we will continue to honor their lives in the days ahead. Sincerely, the family of Jade Benning. So. So, there you have it. Virginia, he went to, he got a coaching job out there. He went from, he got a coaching job. He went out, he was with Tennessee, as we know, and then he, fled, left. Sure. But he left for Utah. Yeah, be careful in that heat, you guys. Definitely. Grampy, were you with us earlier when I was showing all the potential the forecasts coming in? Were you with us? I was reading all the forecasts for and Detroit was one of them. Did you happen to see that? Let me see. Not that one. While we wait, we can. And we, Grampy, I don't know if you were with us when I showed this or not, but I'm going to show it again. Detroit's going to be 98 today, 98 tomorrow, and 94 on Friday. So definitely take care of yourselves. Thank you, Kaylee. Yeah, we have a great set of mods. That's for sure. All right. I kind of want to show something else, but then I'm like, I don't want to show something else because I think they're going to come back. I mean, I'm thinking they're going to come back pretty soon. I don't think it's going to take much longer. Of course, as soon as I do pull up something, they're going to come back, which maybe I'll do that. I want to see Lauren. Let's look at Lauren. I want to watch Lauren's testimony again. As soon as I play this, they'll probably show up, right? All right.
You previously filed a motion eliminating number 13 relating to an objection.
Sorry, hold on a sec. All right, this is Lauren Weber. This is the woman. This is her friend. This is the woman we heard from. Are they coming back? They might be coming back. Does that sound like they're coming back?
I want to see that happen.
Just sounds like there's a lot of activity. Hey Selena, how are you? Sounds like a lot more people are in the room. We'll stay here for a little bit. Right, sounds like there's a lot more people in the room. Yeah, it sounds like people are coming in. I agree. Sounds more active. William, did they handcuff him? Not that we saw. Doesn't it? It sounds like people are coming back in, right? It sounds like there's more activity. It's okay, Selena. Thank you for letting us know. I hope that worked out for you. And Warren, I hope he had a good birthday. I know his birthday was the other day. I hope you guys had a good birthday. I hope Warren had a good birthday, Selena. So nothing official, but it does sound like there's more people coming in. He is in custody, Melanie, yes. He is in custody. We just didn't see him handcuffed, but yes, he is in custody. They revoked his bond. And he is in custody. They revoked his bond, so. Yep, they revoked his bond. I didn't see him placed in handcuffs, but they revoked his bond, and that's it. Yeah, Kaylee, they definitely sound happy. There's something's going on. Either Camilla, either a verdict or they have a party going on. They definitely sound happy. Well, they got the conviction. Now it's just a matter of the sentencing. So, Just Stephanie, how are you? Good to see you. Fanny Pack, yes, they have made victim impact statements. Yes, they have. Thank you, Selena. Appreciate that. Thank you, everyone, for caring so much about Warren. I feel like we are an extended family here. Thank you, Selena. Seashell, thank you for that. What did Seashell send? Stay hydrated. Yes, the little turtle. I like that little turtle. Thank you, Seashell. Appreciate that. Victim impact statements were quite a while ago now. Like an hour or 2 hours ago. Over 2 hours ago. But if you want to see the victim impact statements, they were about 2 hours and 15 minutes ago. Renee, no, they gave them, it was weird. They had them come up on the stand. It was aunt, stepmom, and then mom of Jade. Those three came up in that order. First it was her aunt, then it was her stepmom, and then it was her mother. And they, the attorney kind of asked them questions, please tell us a little bit about Jade, that kind of thing. So they were victim impact statements, but they weren't really, and they called them victim impact statements. So it was kind of like, it was sort of like in Charles Jones, where we saw Sandricus, she had a letter read into the record between the guilt phase and the penalty phase. So it was kind of like that. I don't know now if there's actually going to be further victim impact statements. I don't know. We'll have to see if there were. And then on the defense side, his mother talked, and is there anybody else that talked for him? Oh, yeah, they called up Detective Adam Reese just to say that he had no prior criminal record. But I would expect them, because look at what happened with Charles Jones. They did have victim impact statements. They between the penalty phase and the guilt phase and the penalty phase, Sandricus Mays had a letter read into the record, and then at the sentencing phase, well, no, this is the verdict. Well, you know what? I honestly, I'm not sure what's going to happen. I don't know what's going to happen. We'll just have to wait and see. We'll have to see if they're going to get up again and talk again. Yeah, they did testify, but they called them victim impact statements. It was weird. He did call them. The state called them, or I think the judge said victim impact statement. Yeah, they were like witnesses. I know, it was weird. He did call them victim impact statements, though. I don't know. Maybe they'll get back up again. Maybe they'll get back up again one more time. I'm not quite sure how they do it here in Tennessee. Maybe they will get back up again. Iowa Backyard says maybe the family will get to tell Blaise how they really feel. Yeah, maybe now. Mama of a Medic, glad the storms have passed. Hey, Amy, how are you? Welcome in. Good to see you. I'm thinking maybe, when they were up on the stand being interviewed, if you will, testifying, the defense did ask for them to not say anything about years, or what the outcome would be. So maybe now, once they hear the verdict of the penalty, maybe now they can say, I hope that you give them, I don't know, I'm really not quite sure. I'm not quite sure what's going to happen. Selena, I missed the defense closing arguments because of the doctor's appointment. You've just seen in chat here and there that she did a horrible job. She missed a lot of points. I'll say that. She did miss a lot of points. She didn't talk at all about Apple. She didn't talk at all about what were some other things she didn't. She went over her time, even though yesterday she said 45 minutes, and today he said I'll give you an hour. It could have been better. I think it could have been better. She talked, let's see. Just trying to think about what she talked about. Both of them, being in their 20s. People in their 20s aren't happy about pregnancy. She says it's unfair to punish him and not Jade. Blaise couldn't win. He would be wrong for lying to her. He would be wrong for being honest with Jade. Yeah, she didn't talk at all about Apple. She didn't bring up Apple. She did talk about the cocoethylene. She didn't really talk about the friends going into the apartment. Right? She didn't really talk about that, did she? I mean, if she did, it was very... Let me see here. She talked a little bit about law enforcement and how they didn't talk to anybody else. They didn't talk to key witnesses. I thought that was pretty good. Oh, yeah. She talked a little bit about law enforcement told them to not lock down the apartment. She talked a little bit about that. She could have probably talked a little bit more about that. Yeah, let's see. What else did she leave out? I think not talking about Apple was probably the biggest thing. Great Gams, she was all over the place. I think her openings I thought were a little bit better because she had that timeline and she was much more concise in her timeline. Yeah, she did not address Apple. She did not address Apple. All right, might be something happening here.
Raven and Andre Johnson. Well, one thing too,
Janet says, I thought the prosecutor ended strong with what is worse than ending the life of your own daughter and your daughter's mother. Yeah, that was pretty good. That was pretty strong. I agree with that. Those of us who said under an hour may be wrong. Well, there's some activity. There's people walking around.
Murder and potentially felony or serious. That's why it's been 6. Yes,
Yeah, I thought I heard the judge too. Renee. And then they cut the audio. So maybe they cut the audio now. They know that they're coming back in. They just cut the audio, so maybe that means they're coming back in. Or the judge realized that they had the audio on, of course. And they're not supposed to. As Aaron just reminded me, they're not supposed to have the audio on. Or maybe they're coming back in. All right. Well, now we have no. Oh, what was that? Paul Lee. Oh. All right. Should I play? I have Lauren Weber's testimony queued up. Suppose we could always. All right. I'm going to play Lauren Weber's testimony. All right, this is Lauren Weber's testimony.
All right, just step up and raise your right hand and be
Do you swear the testimony you're about to give is the truth?
Good afternoon, Ms. Weber. Could you please state your full name for the record?
Lauren Weber.
And can you spell your last name for the court reporter?
Weber.
And Ms. Weber, do you live in the Nashville area?
Yes, ma'am.
How long have you lived here?
My whole life.
And at some point, did you meet Ms. Jade Benning?
I did.
When was it that you first met Jade Benning?
We were friends roughly a little over a year. She moved to Nashville and ended up working for my brother's restaurant, and we became fast friends.
And what restaurant was your brother's?
Ernest Bar and Hideaway.
And was your brother a single owner, or did he have a co-owner?
He had a co-owner.
And who was that co-owner?
It was actually Jade's uncle, Jay, excuse me.
And when did you first start working at Ernest Hideaway?
I began working there, I want to say it was 2023, roughly. I was there for about 3.5 years. I'm not sure the exact date.
Were you there before Jade started working there?
Yes.
Okay. And did Jade start working there in 2022?
Yes.
Okay. So you would have been working there in 2022 at least?
Yes, that's correct. Sorry.
And what was your position at the restaurant?
I was the assistant general manager.
How much time would you say that you spent with Jade Benning on a weekly basis?
We spent a lot of time together at work. After work, we would go get food together, so we spent a lot of time together throughout the week.
Did you guys ever actually travel together?
We did.
How many trips did you go on with Jade?
We took one trip.
And can you describe what was Jade's position at the restaurant?
She was a chef in the kitchen.
And about how many people worked at the restaurant?
I would say roughly 20 to 25 people.
And can you describe Jade's kind of demeanor within the restaurant and the other employees? Was she well liked, or what was your perception?
She was definitely well liked by everyone. She was someone that could sense if you were having a rough day. She would make you smile, and we would do the same for her. She was just a light. Everyone truly loved Jade.
Did she confide in you personal things that had nothing to do with work?
She would. Sometimes also about work, but yes.
And at any point, did you learn that Jade had met Blaise Taylor?
Yes.
And do you recall, when did you first learn about that?
It was in the winter months. She had just mentioned him to me, and then eventually I did meet him.
Do you remember exactly when you met him?
Not the exact date, no.
Can you describe that encounter?
We had gone to a bar that was downtown. It was raining outside. We went up to the bar and I met him, and there was not much communication. It was just more of a nice to meet you, and then kind of didn't have much else other conversation.
And did you see him with Jade again after that?
No.
At some point, did you learn that Jade had become pregnant?
Yes, ma'am.
All right, well, we've officially passed the hour. So it's 0 to 1 hour. 66% of you said 0 to 1 hours. So the next up is 1 to 2 hours. 27% of you said 1 to 2 hours. So 66% of us said 0 to 1 hours. And now we're just over an hour.
And how did you learn about that?
Jade called me and she told me.
And do you know how long Jade had known she was pregnant?
She called me as soon as she found out. So she hadn't been very long.
And I want to ask a couple of questions about before that day. So before the day that she found out she was pregnant, did you know Jade to drink alcohol?
Occasionally, yes.
Did you know her to ever get drunk?
Occasionally, yes.
Is she someone that you knew to drink every day excessively?
Absolutely not.
Did you know her to do any other types of substances?
Yes.
And what did you know her to do?
Smoke marijuana.
Did you know her to do cocaine ever?
No.
Are you sure about that?
100% sure.
And can you describe, after that day that she told you she was pregnant, did Jade's behavior change in any way?
It did.
Did you ever see her drink again?
I did not.
Did you ever see her or even hear about her smoking marijuana again?
No, ma'am.
And did you have any knowledge of Jade would to get
All right, the court staff's been made aware the jury's arrived at a decision in terms of the punishment phase, so we'll let them step down and announce it. And was there an agreed on date on any sentencing issues?
I think the clerk was looking at possibly a date in September.
You want to do the 9th? Check that, let us know if it's not good. All right, juror number 7, you are still the foreperson, and the jury's arrived at a verdict in terms of the sentencing issue.
Yes, ma'am.
All right, if you would, please, ma'am, stand and announce that verdict from the jury verdict form.
We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by defendant while defendant had a substantial role in committing first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
And that is
count 2.
Okay.
For count 3, we, the jury, unanimously find the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. And for count 4, we, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
All right, and that's signed by each of the jurors?
Correct.
All right, you can turn that document into the court staff. Anything further from the state?
No.
Anything further on behalf of Mr. Taylor?
No, Your Honor.
All right, ladies and gentlemen of the jury, I appreciate very much your service for the last week plus to the court and your community. You'll be discharged from this case and from your jury service. You can step down the hallway with the court officer. All right, Mr. Taylor, you have a seat. Mr. Taylor, you've heard the verdict in terms of the punishment. Counts 2, 3, and 4 that the jury is imposing a life sentence in each of those counts. That verdict will become the judgment of the court. We'll set this on 9/9 for any sentencing issues, merger issues. And if that date doesn't work, Mr. Brand, just let us know in advance.
Yes, thank you.
All right, let Mr. Taylor step in the back. All right, we'll be adjourned.
So imprisonment for life means he can get out. He's eligible for parole at 51 years, in 51 years. So it's not life without parole. From what I could understand, he has eligibility for parole after 51 years. That's the way I understand it. According to the Tennessee Bar Association, in Tennessee, imprisonment for life generally means a mandatory minimum of 51 years in prison before parole eligibility. So it sounds like it was not life without parole. It was mandatory minimum of 51 years. So, and that's just for counts 2, 3, and 4. He still has count 1 to go through. He still has the second degree to go through. So don't think he's getting off and he's going to, be walking free in 2 years. So the judge still has to take care of count 1, which will be September 9th. So September 9th is going to be, and then we have September 9th is going to be sentencing. Let me just jot this down before I forget. So September 9th is going to be sentencing for count 1. So that was for counts 2 through 4. So counts 2 through 4 was for the jury. That was first degree, and they gave him life for all 3, which means he's eligible after 51 years. Eligible after 51 years. It doesn't mean automatic. You're right, Ronnie. It does not mean automatic. It's just he's eligible for parole after 51 years. Then the judge has to decide the count 1, which they came back with second degree for Jade. That's going to be September 9th. So September 9th is going to be sentencing. Sorry. So September 9th is going to be the sentencing. All right. So yeah, he won't be eligible until he's 81. Eligible is the operative word there. And also don't forget he still has the second degree. He still has the second degree for Jade. And second degree in Tennessee what is he looking for? Second degree in Tennessee sentencing. So second degree is 15 to 60 years. So then he's looking at an additional 15 to 60 if they do consecutive. If the judge goes consecutive, then that's it. He's just not. If the judge goes concurrent, then he could get out. He could get out after 51 years. Eligible. So count 1 was for Jade. Count 2 was for Ivy. Count 3 was for Jade, but that was while committing count 1, and count 4 was for Ivy while committing count 2. So count 1 and count 2 were first degree murder, just straight up first degree. The jury found that, here, let me pull this over here. The jury found that they went with second degree for count 1. So they felt that he poisoned Jade in trying to get rid of Ivy, and Jade unfortunately passed away. She was collateral damage, if you will. So I hope that helps you. Mike showed him leniency. Possible. Beck, how are you? Good to see you. So he's still looking at 15 to 60 years, whether that's concurrent or consecutive. We still have to wait and see. I'm gonna see if we can get a press conference. See if we can get a press conference here. See if anybody's going to do a press. I'm going to look around for a press conference. You know how I like my press conferences. Let's see. See if there's a press conference up there. Everybody's signing off. They'll probably do a press conference, but it'll probably be later. They'll probably upload it for the news and stuff. All right, I'll stay on for a few more minutes. See if we can get a press conference. I'll stay on till 7. We'll see if we can see if there's a press conference. Anything. Debbie, does anyone know the answer to your question? What was your question? Debbie? Isn't it 3 counts and 3 lives? Yes. Yes, you are absolutely correct. Yeah, no, you're right. They gave him life for all 3 counts. No, you're absolutely correct about that. They gave him They gave him, counts 2, 3, and 4. They gave him life for each one. No, you're absolutely right. So, yeah, if the judge does that consecutively, then you're right. No, you're absolutely right about that. Absolutely right. You're absolutely right about that. Anyone know the Tennessee percentage of overturned? I do not know. I do not know. All right. All right, Sharon, take care. We'll be going off the air in like 5 minutes. I'll give it 5 minutes. Just to see if anybody's going to give us a presser. And they very well may do a press conference, but we're just going to, it may be later. Kaylee, thank you. Thank you. Appreciate that. Lori, welcome in. Yes, he was found guilty, and then second degree on count 1, which was Jade. And then guilty on all the other counts. Count 2 was Ivy, and then count 3 was Jade, but it was like in the commission of. And then count 4 was Ivy, and that was in the commission of. So the counts 1 and 2 are the actual act, and then the other counts are in the commission of committing those acts. So they found him second degree on count 1, and then first degree for the other 3. So basically, the jury, the upshot of all that is the jury thought that he was aiming to take out Ivy, and Jade was collateral. Unfortunately, the jury thought that he did not mean for Jade to die. It was all about taking out poor Ivy. Aaron, thank you, appreciate that. Thank you so much. All right, I'll stay on for another 3 minutes, and then we'll wrap it up here. Oh, so tomorrow. All right, tomorrow and Friday. We're going to stream tomorrow and Friday. Friday is courts are off on Friday, celebrating July 4th, which is Saturday. So July 4th will be celebrated on Friday. So there will be no live courts. But we'll either do we're going to do Alec Murdaugh tomorrow, I think, because we have that ready to go, and then we'll do maybe a Ego Takes the Stand on Friday. Let's see. Yes, Melanie, we know Aaron posted that. We did a video. Aaron posted a video, so go check that out. Jadzia Dax, have a fantastic evening. Thank you for joining us today. Let's see. Oh, you know where I can go is, let's see, maybe sometimes these guys have something. Oop. Let me see here. That's a pass. Nope, that's that. Don't want that. Oh, watch live maybe. Let me see if they'll see what this channel is talking about once I get through their ad. All right, Debbie, thank you. Have a great night. Thank you so much. Thank you so much for everything. Yeah, I guess if it's consecutive, if it's concurrent, then it would be after 51 years. Camilla, love me some Ego Takes the Stand. Yeah, I think I'm leaning towards an Ego. We haven't done an Ego for a while. I'm missing my Egos. I think we'll do an Ego. Ego Takes the Stand on Friday. Tomorrow's going to be Alec Murdaugh. It's going to be about Becky Hill and Alec Murdaugh, because he just had a hearing and he got a new trial date. So tomorrow we're gonna look back at what got us to here. So, all right, Anthony, have a good one. JMS, have a good night. Alexa, have a good night. Eva Renee, have a wonderful evening. Make sure notifications are set. Yes, Iowa, thank you for that. Yep, make sure you have your notifications set. Just waiting just to see if they have a press conference over here. Waiting to see if they have a press conference over here. Waiting for a commercial to end. Come on. Oh, look at that, another commercial. Imagine that, another commercial. Oh, no, wait, okay. No, all right. No press conference. All right, you guys, we're going to wrap it up. Grampy, you know what time it is. It's time for your girl. Yeah, it's a good girl. Yeah. Yeah, it's a good girl. Oops, sorry. Sorry for the camera work there. I'm trying to scritch your ears and hold the camera still at the same time. Yeah, it's a good girl. All right, you guys. Thank you so much for joining us. Really appreciate you spending your day with us. Leave comments if you have any comments. Put some comments in below the video once it uploads and processes. Appreciate you guys spending your day with us. Thank you to our mods. Thank you to Erin. Erin did release. She did a video on Charlie Adelson, so go check that out. And thank you for getting us. We're almost at 30,000 subscribers, you guys. We're at 29,455. So really appreciate that. Thank you for all your support. Thank you for the cups of coffee, the Venmo. Thank you for the super chats. Thank you for the memberships. We have a great community here. Really appreciate you guys. And with that, we will be, I think we'll start around 10 o'clock tomorrow. We're going to do Alec Murdaugh. He had a new trial. He had a hearing today for his new trial. Date was set. So we're going to look back at Becky Hill. We're going to look at it from the Becky Hill angle. I've got some interviews with her. I've got her on the stand talking. So join us for that. And with that, have a fantastic evening. Thank you so much for joining us. And we will see you tomorrow at 10 o'clock. That's Thursday. And then Friday, we'll figure out an ego. We'll probably do an ego. So, all right, guys, take care. Thanks again for joining us. Bye. Oh, I forgot to tell you, that's a new song. That's a new outro. Did you guys check that new outro out? I gotta kill the loop. So check out the new outro. I totally forgot. That's a new outro. All right, it's so cool, I'm gonna play it again. So here, check out this outro. Aaron just created this yesterday. Here's a new outro that Aaron created.